What's that?
Oi, aloha mai kako. My name is Dawn Chang and I am Chair of the Board of Land and Natural Resources. This is the October 24th, 2025 meeting of the board, and it is 9:05. I'm going to go over some meeting protocols before we start the formal portion of the agenda. We are holding this meeting as a hybrid meeting. Some of us are in person in the Kalani Moku Boardroom in Honolulu, and we are also holding this meeting remotely via Zoom. In addition, it can be watched live on YouTube. For those testifying via Zoom, we will move you from the waiting room into the meeting when the board hears the item you signed up to testify on. Please remember to mute your YouTube when you enter the Zoom meeting, or we will get an echo. The chat box is not to be used for any comments because that presents a sunshine issue. However, the board secretary may message you via the chat box to ask which item you wish to testify on, so we can let you into the meeting at the appropriate time. Presentations by staff and comments by applicants are limited to 5 minutes each. We ask members of the public testifying on agenda items to limit their testimony to no more than 2 minutes. Testifiers will not be allowed to relinquish their time to others. I apologize in advance if I ask you to summarize, but we do have a lot of people we anticipate today wanting to testify. I ask that if you submitted your testimony via email, that you stand by your testimony, as the board members have reviewed the testimony that were submitted on time prior to last night. Please address your comments to the board and not to the project applicant. I have board member Riley Smith next to my right. And he is our timer. He will keep track of the time and give you a 30-second warning. And at 2 minutes, I will ask you to stop testifying. I will then move on to the next testifier. Adhering to these guidelines will enable us to hear all of those present who would like to share their comments, as well as those on Zoom. Before starting your testimony or your comments, please clearly state your name and identify yourself for the record. We may take breaks as needed. I am now going to read the standard contested case statement. In some of the matters before the board, a person may wish to request a contested case hearing. If such a request is made before the board's decision, then the board will consider the request first before considering the merits of the item before it. A person who wants a contested case may also wait until the board decides the issue, then request the contested case after the decision, but before the close of the board meeting. It is up to you. Any request must also be made in writing within 10 calendar days. If no request for contested case is made, the board will make a decision and the department will treat the decision as final and proceed accordingly. In addition, the board may go into executive session pursuant to section 92-5A4 of Hawaii Revised Statutes in order to consult with its attorneys on questions and issues pertaining to the board's powers, duties, privileges, immunities, and liabilities. I'm not going to take roll call of the board members. If you are participating via Zoom, please acknowledge if anyone is in the room with you, and please provide their names. I will first start with board member Karen Ono.
Karen Ono, Kauai member.
Denise?
Denise Iseri Matsubara, Oahu member.
Calvin Young, at large.
Don Chang, chair of the board. Riley?
Aloha, Riley Smith, Hawaii Island Board Member.
Aloha mai kako, Doreen Napua Canto, Maui Island member.
And Kaivi Yoon?
Aloha mai kako, Kaiwi at large and chairman in office when no one is present and or around me.
Okay, thank you very much. I'd like to also introduce the board secretary today is Rihanna Wright, and our deputy attorney general is Danica Swenson. I am going to, we generally take agenda items in the order that they've been agendized. However, I do try to accommodate if there are requests for move up. I do want to, for the record, note that there was a request to move up items F1 and F2. After thoughtful consideration and given the anticipated volume of public comments, we will be taking agenda items F1 and F2 at the end of the agenda to ensure we have sufficient time to hear all the public comments and to provide the board sufficient time for deliberation. Items F1 and F2 relate to the aquarium fish. So, and we've also moved agenda item D2. We moved that to the end of the meeting in the event that I lose quorum or we don't have enough time. Okay, so given that, I'm going to start with the board with agenda item A1, which is the approval of the September 26, 2025 summary board minutes. Board members, do you have any questions or comments on item A1? Seeing none, do I have any comments from members of the public on item A1 in the boardroom? Okay, seeing none, do I have any comments on Zoom? I'm going to close public comments. Board members, do I have a motion on item A1?
So moved, Chair.
Second.
Oh, good. A motion has been moved twice and seconded once. So with that being said, since this is the first action item by the board, Rihanna, could you do a roll call vote, please?
Member Ono,
Aye.
Member Isari Matsubara,
Aye.
Member Young,
I,
Member Payne,
Aye.
Member Smith,
I'm going to abstain because I was not here for the entire meeting.
Member Paco,
Aye.
Member Eden.
Abstain, not here for the entire meeting.
Okay, so the vote passes with 7 votes. I always have a hard time counting our, with 5 votes. I apologize. 5 votes. Sufficient to pass the meeting notes. Thank you. The next item is item A2. These are summary minutes for agenda item, for the October 10th, 2025 board meeting. Board members, do I have any comments or questions? Okay, seeing none, do I have any comments from members and the public in the boardroom? On item A2, seeing none, do I have anybody on Zoom? Okay, I'll close public comments. Do I have a motion on item A2?
I move to approve as submitted.
Thank you. Do I have a second?
Second.
Motion has been moved and seconded to approve item A2. All in favor, please say aye or raise your hand. Motion passes with 7 votes. Do you think
Chair,
today's?
abstain.
Oh,
Sorry,
I'm
Chair.
sorry.
Abstain, wasn't here for the total meeting.
Okay.
Sorry, Chair. Thank you.
Thank you. Motion passes with 6 votes. What do you think? Do you think the rest of the board agenda is going to go like this?
Probably not.
One can only be hopeful.
What do you mean? What are you talking about? I abstain? Don't you say?
That too, yeah.
No.
But we had very good, I appreciated the efficiency of those 2 votes. Thank you so much. Okay, now we're going to move on to agenda item C1. David?
Hey, good morning.
Good morning.
David Smith, I'm the administrator with the Division of Forestry and Wildlife. C1 is a request to approve the acquisition of private lands at Hamakualoa District on the island of Maui. 3 different parcels. Approve the post-closing issuance of a management right of entry and authorize the Maui branch manager to issue permits. And also authorize the division to conduct public hearings for the potential addition to the forest reserve system. So you have the submittal. This is the second phase of the East Maui Rainforest Coastal Rainforest acquisition. Makes it about 650 acres of really prime coastal lands that are, in danger. I mean, the pattern out there has been to subdivide the properties and turn them into private homes and the like. So we're hoping to keep it in conservation. And what we're trying to do is provide connectivity from, Mauka lands all the way down to the ocean, protecting stream resources, protecting native forest, and protecting coastal areas. You have quite a bit of the information. I have lots of people here that can provide more than I. Just a couple of things. Of note, let's see. The one issue we just want to bring up is that there's broken title on the parcels, and that's a potential issue. There may be some folks that that find that to be a risk. We find the risk to be limited. EML, which is a subsidiary of AMB, has had the property for about almost 100 years and hasn't had it claimed. We think the risk is limited given the long ownership tenure. And also if there were claims, it would only affect portions of the parcel. It's really, there's conservation urgency attached to the property, public benefits. And also the funding for the acquisition, the source of funding, baseline source is all private funding. And all of the folks that have donated money are in favor of proceeding with the acquisition. The quitclaim deed does not include environmental warranties. We're comfortable with taking on that. We've done this before. It's just part of our, risk tolerance that we carefully consider these types of things and find that we're within our risk envelope, which is for us is pretty broad, but we've been successful. The other thing is we have a lot of testimony and support. So Trust for Public Land, the Aha Moku Maui Council, Ko'olau District Rep, Commission on Water Resources Management, East Maui Water Authority, Hawaii Land Trust, Ahavaio Maui Hikina, the East Maui Regional Community Board, Koa Range testifying as an individual, Rep Mahina Poi Poi, Mayor Bissell from Maui, and a person that's the Nahale Advisory Council, Namoku Aupuni o Kopalahui, Maui County Council, Sierra Club Maui Group, and the Maui Nui Seabird Recovery Project. And hopefully you've got copies of those, but there seems to be pretty strong across the board support for moving forward with the acquisition. And, we got Tanya Rubenstein, who's our pro on acquisition. We have other folks that want to testify. And so we'll just, we also have Scott Fretz is here he's the branch manager for DOFA over on Maui. Very, very involved in this and kind of the leader on this whole East Maui acquisition project, this series. And so, we'll still open it up to any questions the board may have.
Thank you, David. Tanya, did you want to add anything?
I'll just be here to answer any questions.
Okay, great.
I have a question.
Yes.
So, David,
Yeah.
the lands right now, I see these phase 2 parcels encompass undeveloped coastline. So these are all agriculture and conservation zone right now?
Yeah.
So you're not changing any type of zoning? Thank you.
For the department, this is a great acquisition, one that we don't have to expend funds, but it does permit us to have, as David said, our approach has been Mauka to Makai and developing that connectivity from to permit comprehensive stewardship of our lands. And so we've completed phase 1, we're into phase 2. I know we also have our Deputy Attorney General here, Tina, in case we have any questions on, in particular, the acquisition process and concerns related to the deed. I know the board has at times recognized the risk when we do have broken title, but given the longevity of the prior landowner, we seem to, I think the department is willing to accept that risk. So with that being said, Scott, did you want to add anything before I open it for public comments and additional questions?
Yeah, I appreciate everything is covered. Just the one thing I would add that was mentioned is the urgency here. AMB does plan to sell these lands. So we know what happens from experience when lands in areas like this are sold. They tend to be purchased by investors and developers. We know that results almost always in loss of public access, loss of shoreline access, loss of opportunities for these public benefits. So we have this rare opportunity, and I just wanted to reiterate that urgency.
Thank you for that very much, Scott. Okay, seeing no other questions from the
Chair, I
board.
have a question
Oh, go
for
ahead.
Scott or any of staff. In the case of broken title, and for the record, real plainly speaking, what happens when the title is challenged in the future?
I've got Tina here, but we'll defend the title. Tina, did you want to add anything there?
Answer that question.
Okay. Here, why don't you come up front, Tina?
Thank you. Good morning, everyone. So in cases of broken title, if a claimant does come and files a legitimate action in court, the state will respond accordingly. This case, since it does have broken title, we won't be able to carry title insurance, which is a safeguard that we usually have for all acquisitions. But in this case, like every other lawsuit that is filed within the state, we'll just use our available resources to respond, and that will be with the AG's office.
Thank you so much, Tina, for that.
Thank you, Tina. I just wanted that on the record. Thank you.
Thank you.
Thank you. Board members, any other questions before I take public comments? Okay, thank you very much. I'm going to first take public comments from members in the boardroom, and then I'll go on to Zoom. Is there anybody in the boardroom that would like to provide a comment on item C1? Yes, please come on out. Oh, thank you.
Hi, good morning,
Good
Chair
morning.
Chang and board. Thank you for the opportunity. My name is Akko Wiedemeyer. For the record, I'm with Trust for Public Land, and I'm the project manager assisting on this acquisition. I stand by my testimony, which you have received, but I also just wanted to underscore just a few points. The first point I would say is I really believe this to be a generational opportunity because of the nature of the landowner, their tenure, how long they've held the lands, and that this is no longer lands that they would like to hold. And also the fact that this is a multi-phase landscape level project. This is an important piece though, because this is almost 700 acres. And again, the connectivity, which you guys have heard about, the Malcolm Mackay, the corridor that it creates, and just to reiterate Scott's point, that this isn't, we see what happens when this goes to private parties, and the no trespassing signs continue. This is a great opportunity. The other point I want to make is that, again, that this is is being acquired, if approved by you folks, by a donation. So that's a really unique opportunity there. And then the third point I would say is that the next phase that we are looking at, what we call phase 3, some of the matching funds are coming from this particular phase. So this phase is also helping acquire further lands, additional lands in phase 3 through matching funds. And that phase 3A, which is a single parcel, has already been awarded 1.5 million in funds. And phase 3B has also been ranked high for federal funds. So we see this as continuing on, and that's my testimony.
Thank you very much.
Thank you
Akko.
very much.
Appreciate you being here.
Thank you.
Is there anybody else in the boardroom who'd like to provide comments? Is there anybody on Zoom who'd like to provide comments? I see Lucianne. Do you want to provide a comment, Lucianne?
Yes, I
Please go ahead.
can folks hear me?
Yes, we can.
Thank you very much for taking up this matter. Sierra Club Maui Group, I'm the chairperson of that, strongly supports this acquisition. We did submit a letter as part of your packet, and we stand by that testimony. However, not to take up much of your time, but I personally am very, very familiar with this land. I've hiked Makaiba Bay, which is like the heart of the purchase, And as I mentioned, I was able to go there with our legendary botanical treasure, the late Rene Silva, and he spoke so highly of all the resources that abound in this area, archaeological, natural, botanical, ocean-related resources. So as an East Maui resident, I really emphasize what Scott has said. These are beautiful view properties. If A and B just puts them on the market, someone will snap them up to make large estates. And this is a wonderful opportunity for the state to accept this donation. The matter of broken title, the county of Maui did acquire some lands in Ukumehami about 20 years ago that had broken title. They've never been a problem. They've proved very, very useful lands. Some of them are going to be restored as wetlands. Some of them are being used for other purposes, but it's a very, very good chance to take. So thank you for your support.
Thank you very much, Lucian. Is there anybody else on Zoom? Okay, I am going to close public comments. Board members, do I have a motion?
Sure. I move to approve self-submittal.
Thank you.
Second.
A motion has been moved and seconded to approve staff's recommendation on item C1. All in favor, please say aye or raise your hand. Motion passes unanimously. Thank you very much, all of you.
Thank you.
I do want to recognize for the record that we have Senator Favela here. Thank you for joining us. And for many of you who have joined us after I did some introductory comments, I am going to take item F1 and F2 related to the aquarium fish. That's going to be at the end of our agenda. So you are free if you want to. I've got several other agenda items before then if you want to do other business, but you are welcome to just stay in the room as well. Okay, but I did want to let you know I had it. All right, so that is item, we've completed the C items. We're going to move on to D1. Maybe we're not going to move on to item D1. Oh, I guess we'll do K1. Okay, we're very flexible here today. We're very
He is
flexible.
not here.
We'll
so
do
go ahead.
We'll do K1. We'll do K1. And it may have been that I've gotten the.
The agenda said C, then K.
You're probably right.
Oh, Michael.
It does say that. I'm the one that's out of order.
Okay.
Good morning, good morning.
Good-
Okay, please go ahead.
Good
K1.
morning, Chair, Board members, Michael Kane, Administrator, Office of Conservation and Coastal Lands. Item K1 is an enforcement action. We're asking for fines against John Gugliardo individually and against the Hawaii Loa Ridge Preserve, which is his nonprofit, for what we allege are unauthorized land uses in the conservation district. This is in Aina Haina, in East Honolulu. The parcel is a steep slope that leads from the Aina Haina neighborhood up to Hawaii Loa, most of it undeveloped. In the lower portions, we approved in 2018 a site plan approval for Hawaii Loa Ridge Preserve Habitat Restoration Program. And for our relatively new board members, site plan approvals are smaller permits that we can issue administratively. We don't bring them to the board. And this allowed for habitat restoration in the area. It's dominated by invasives, along with accessory structures that would support the restoration program. That was in 2018. Over the past 7 years, we've had a non-stop series of neighborhood complaints regarding activities on the parcel. To be honest, many of them turned out to be nothing. Sometimes we did find structures that were unauthorized. And we tried to solve those alleged violations administratively through what the CRVS, and I forget what that means, but we have the option to do administrative fines and resolve violations, again, without bringing them to the board, smaller fines,
after the fact permits. We've done that twice. And here we are a third time with more unauthorized structures on the parcel. No, we allege are unauthorized, and again, no permits. So at this point, we feel it's like our goodwill, our trust is over with this landowner. We feel the landowner knows you need permits and did not secure permits. So we're asking for. My guys keep turning off my policy. $29,500 in administrative fines and the removal of all unauthorized structures. Those are itemized in our recommendations, recommendation number 3. And a brief summary is also on page
11 and 12.
correct. Also on page 5, the bullet points under July 15th are the structures that our staff saw during a study. At this point, we would prefer not to consider after the fact permits. We've done that twice, and we reach a point where we'd rather proceed with enforcement actions. And we did receive testimony. I do not know if they're here online from the. Oh, okay. With that,
Thank
I'll
you very
close my
much.
testimony and turn it over.
Thank you, Michael. Board members, do you have any questions for staff?
So Michael, how come there was 2 after the fact permits? What did we not catch the first time?
No, it was a second round of activities.
Oh, a
So
second.
so
round.
we felt we had resolved it, and then there was, I think it was a treehouse this second time. So the second one was for the second round of activities, and now for the third round. We're done.
Here we are. Okay, thank you.
I have a question too,
Thank you,
Chair.
Chair.
Your E item 29,500 is a total for A through D, right?
Correct.
Where is the extra $500 coming from?
That's a good math.
Sorry.
We have, so number A is 15,000.
Uh-huh, 10,000,
And
2. And we end up with 29,500.
I can't answer that. I'll have to say, let's amend that to 29,000.
Okay.
Unless my staff
No.
raises their hand.
Okay.
Thank you.
Good math. Okay.
Chair, I have a question.
Yes, please, go ahead.
So the request is to issue fines against both the entity and individually.
Correct.
Are fines, can fines be awarded against both the entity and the individual so that you could double the amount?
I don't think so. And one of the reasons why it took us a year to bring this to the board is because we were working with the AG's office and how to phrase it when we have an individual and a organization. So, but I've never seen a case where we could bring identical fines against 2 different entities.
All right. So then my second question would be, is the fine going to be, if we approve your recommendation, would it be a joint fine then against both the entity and the individual jointly?
Correct.
Okay, thank you.
And to follow up on that, Michael, have both of the entities all received notice?
Well, so the entity is headed by the individual. So
Okay.
yes,
But so the notice included, it was on the notice, it included both the individual as well as the
it did, although our notices were returned and that we don't have confirmation until we emailed it to them and they responded to the email.
Okay, very good. Thank you. Board members, any other questions for Michael?
I do, Chair. Michael.
I'm going to take Riley first. Good
Oh, sorry.
evening.
I can't see you guys. Yeah, okay, fine.
Yeah. So I'll acknowledge you. Thank you. Go ahead.
No worries.
Riley.
So Michael, we were in communication yesterday, so the individual and the person that controls that property. I think the property was purchased from Hoy Lower Ridge Association. And then he received a driveway lot agreement, easement or something to get to the property off of that Manaawea Street in Ainahaina. And
I can clarify that for you. It's a
Okay.
little bit incorrect.
Okay,
I'm
so,
talking-
yeah,
And so since the person we're complaining against has been non-responsive, I was wondering if there's a way that we could include the Hawaii Lower Ridge Owners Association because they are contributing to the problem by allowing him access to conduct these improper activities.
Right. So my understanding is that the, only the driveway is under the Hawaii Lower Ridge Association. At the end of the day, the landowner is ultimately responsible for actions on their parcel. So we do have that option in the future if we're unable to resolve it, to go after the landowner. We did not do this in this agenda item, and Riley and I did discuss this earlier, and so I don't think it's appropriate to add them in without proper notice
Okay,
today.
and
Thank
I
you.
understand that rationale. I guess I just want to put on the record that I think we should have a subsequent action to go after the Hawaii Lower Ridge Owners Association, because I think they have more resources that we could recover from and possibly terminate the driveway access. And then he couldn't get to the property, and that would have more leverage over him to comply with the rules that he purchased the property.
Yeah, we'll have to take that into consideration. Thank
I'm
you.
good, thank you.
just one final question. Are any of these, based upon your site visits, do these all appear to be? It's just a private residence. Is any of this, does it appear to be a commercial or a rental?
I don't have evidence that
Okay,
it was a
okay.
rental. It appeared more to be a private recreation area, picnic area, storage area.
All right. Very good. Board members, any other questions before I permit the landowner an opportunity? Oh, yes.
Oh, thanks. So this is Mari Kurosawa, the staff planner who prepared the report.
I wanted to clarify, so the extra $500 that you saw is the administrative fees. Sorry, I didn't make that very clear, but I just want to clarify that.
Oh, perfect.
That is Exhibit H.
Okay, thank you. You're more prepared than I am for mail.
Well, I was looking for it myself, so I found it. It's Exhibit H.
Okay, perfect. Thank you, Mari.
So with that being said, then the fine is as 29,500. Okay. Okay, Evie, did you have a question?
Oh, yeah, thank you, Chair. Michael, so to date, we've had zero or no response from John or anybody representing the organization?
No, we have received confirmation. And actually last night he emailed me after the fact site plan approval application.
Okay, but that's pretty much it. I guess what I'm asking, kind of following up to Riley's train of thought, John reports to a board of some sort, right? Or no?
I don't know the exact
I was
structure.
trying to find out in my research, Michael. So if you don't know, that's okay. I couldn't find it myself. But I think this went back as far as 2017 when this preserve was being contemplated. And I want to say it was while I was on Legacy Land. I can't remember, but I guess my question is if there is a board or some kind of oversight committee, have they weighed in on the matter as to John's actions, inactions, and actions and inactions?
I can't confirm that this is an active entity.
Okay.
Yeah, sorry,
No, it's okay. I couldn't find it myself, Michael.
okay, thanks.
But for the record, if there is a board that has oversight over this executive director, I mean, I hope that there is some kind of accountability for these kinds of actions, because like I said, if my memory serves me correct, these things always start off great. We have all these positive comments of how we're going to preserve and culture and natural resources, and then things like this happen. And I think it's very unfortunate, So I
Yes.
hope there's some kind of oversight committee that holds these kinds of actions accountable, other than ourselves, other than the Board of Land and Natural Resources. Thank you, Chair.
Any other questions, board members? Thank you, Michael. I'm Leviona? Yes, I'm going to take up the public comment. So why don't you come on up? If you can introduce yourself, please.
Hi, how you doing?
Good to see you. My name is John Gugliardo. I'm Executive Director for the Hawaii Lower Ridge Preserve. So just to clarify the driveway issue, was created in the 80s to cover a 3-foot drainage ditch that connects to a rain collection gulch. So we have 4 rain collection gulches with about maybe about a mile and a half of channels that drain into the river and then the various stream gulches. So we've put our focus on making sure we maintain and clean those ravines and gulches. The access that we have, it isn't something we developed. It's just simply part of the city rainwater gulch that we access the property to. So when we first acquired the property back in 2017, it was, like you said, a legacy land. It was from Herbert Richardson and the Richardson Foundation. And they had owned it, from what I could tell, all the way back to the statehood. It's an area of 3.2 million square feet, 75 acres, and it's the neglected area between the developed Aina area and the Hawaii Lower Ridge Homeowners Association. So it's a big band of steep surface area. Since the Richardsons, I got it from them when he was about 85 and he was divested himself of extra property. So when we got it, there wasn't even a realtor. We got it directly from his lawyer, who put it on MLS. And I guess it was on the MLS for about a year or so, and nobody had wanted to take care of it. 30 seconds, thank you. So the property itself.
So why don't you try to address the specific allegations?
Oh, thank you. So the property itself was neglected for about 100 years. So when we first got it, we had a lot to do. So the things that we did, we jumped in because we were really concerned about trying to take care of it. So the first thing we noticed is the tremendous amount of rockfall dangers. So all along the driveways and all around the people's houses, along the encroachments, sorry, wrong word, easements, there was tremendous amount of rock fall potential. A lot of the neighbors, when we surveyed them, said, yeah, there was rocks that had come into their neighborhood. So the first thing we did was we created several rock barriers and then a rock fall gate at the end of the driveway to catch anything. So we did a lot of sandbags in the beginning and then immediately created a 30-inch CMU wall, which was the first violation. But the CMU wall violation that we did was really as a response to the 2018 40-day rain that we had that washed out the road, washed out everything. And it was about a 2 or 3 foot rain gap that had dug it out, which I'd given you photos and he'd come out and seen. And then we put the protection area in front of that. During the pandemic,
This is what we're talking.
okay, during the pandemic, we had some other big rain issues. And so we had a whole bunch of rocks that came down again, a lot of soil, a lot of erosions. And so we put a second wall at the top of the driveway, which is the SPA that we sent last night, that we're asking for, which is the violation that we're concerned about, I guess. So
let me ask you this, John.
Yes.
Are you, so do you recognize that all these things that you've done have been without approval by OCCL? Because you knew when you bought the property, it's conservation lands?
Correct, yes.
And did you know when you bought the property as conservation lands, those require OCCL's review and approval?
Sure, and we've submitted the SPAs Yeah, the
Site
SBA's,
plan approvals?
as soon as we found out that was something that was required. Again, we were responding to rainfall and the road being eroded out. And it was, like I said, a road that protects the rain gulch, and it was 2 feet, which we had to fill in and put a protected barrier in front of. The same thing is during the 2019, during 2020, during the pandemic, where we found the same thing on the top, which is what we put. So these are the two issues we're talking about is trying to take care of the land the best we could during emergencies. Now, during the pandemic, we did contact the office to ask if we can move forward with this, but they said, sorry, office closed, pandemic. So we went ahead and put it in because it was an emergency.
Does
And
that include the treehouse?
Oh,
So I'm going to go down through the
thank you very
list.
much.
So because this may be your first time before the land board. And so I just want to keep us focused on the items before. So the first one is you're fined $15,000 for violating provisions for the placement of the following unidentified land uses: a treehouse, an outdoor kitchen facility, and a deck made of concrete blocks on land which is Conservation District subzone. Did you build a treehouse, outdoor kitchen facility, and deck made of concrete blocks?
Almost. So there is no kitchen. The classification of a kitchen, Mari, I don't know where you got that from. We have a Kiawe wood grill on next to a picnic table, which we used to eat. During all of the work that we do on Firewise came out and gave us an assessment of the area, and we were very involved with trying to clear out any wood debris and grass that was dried and would die. So we wanted to keep the place safe for all the neighbors. We had the
I don't
fire
think so
department
much
come
the
out.
question is your ability to do it. It is, are you following the process? Meaning, have you gotten their approval?
If I can
I'm
have a
sorry.
little bit of latitude, I can address that, please. So the kitchen area that we're in discuss is simply a Kiawe grill and a picnic table that we use while we're there because we have to have a lunch break. During the pandemic, my kids were sheltered in place, and I wanted to have them come out and help do some volunteer work and pick weeds and help clean up. So my daughter suggested, hey, let's do a treehouse. I looked at the DLNR and I looked at DPP to see if there was any regulations about not putting a treehouse. And we made a treehouse for my daughter.
Okay, so you don't deny that
No,
there's a
no, it was-
treehouse and there's some kind of a cooking facility and a deck made of concrete blocks?
And correct. And
You
then
don't deny that
No.
you did it, you built it without approval of OCCL?
correct.
Okay,
Correct.
I'm going to go to the next one, okay?
And if I could make one clarification, so since DLRI came out and mentioned that they didn't approve of the treehouse, we have removed it.
Okay, okay.
And
So
then,
the second one is,
and if, regarding the concrete tile pads, so the soil, when it gets wet there, is really gluey. So if you step on it, you get caked and caked. So it's intraversible. So we've put pathways down of toppers,
so
so we
John,
could walk
John,
on.
I'm going to try to keep us really focused because
But the toppers is what they're calling the concrete covering. And it's not a concrete cover, it's just some tiles we get so we don't get our feet stuck in the mud.
Okay.
Thank you.
So the second one is landscaping through rock wall terracing resulting in permanent change of the land within conservation district. So these were.
Sure, that's the one I was
That's
addressing,
okay.
is that we were intentionally trying to save the neighbors from having the debris go down. And during the 2018 and 2020 storms, oh my gosh, there was so much debris that washed down the area. So it was really essential that we took care of that.
You
And
didn't get approval from OCCL.
which we filed for now,
Oh, you just filed it last night.
correct.
Okay.
Well, I only
So-
got this
so-
notice a few weeks ago, so this was as quick as we could do it.
Okay, so the third one is for the construction and placement of one accessory structure containing a vinyl storage shed on land within the conservation district zone.
I'm not aware of the vinyl storage shed.
Okay.
We do have a 3x2
Can we take that out?
Home Depot thing that we keep our
Okay, so
shovels in.
This is what put that on your property? Did you put that there?
There's no vinyl thing here, ma'am. There's my surfboard rack and then the shed, which was permitted.
And the next one is for the construction and placement of one accessory structure consisting of a rainwater catchment tank on land within conservation district.
Thank you. I'd like to address that. So before, in 2018, when Michael came out, yeah, he took a look at our rain barrels, our totes that collects from the rain. We needed to do the planting there. 6 months a year, there's no rain out there. It's at the end of the area where the rains sit every night. So there's a area by the driveway that is dry half the year. So that's where we get our rain catchment from. The rain catchment is basically just a barrel, a water tote, the water totes that our drain goes into. Michael took a look at the time and he said, no, that's not considered a water catchment, and that's fine. You'd give me verbal approval at the time, correct?
Did I give you verbal approval? to
Yeah.
apply? No, I said
For the
apply
ra-
for
for
things.
the-
I've
for
been
the-
very clear, you apply for.
For the rain tote, you said that wasn't considered a water catchment, and that would be fine.
Okay.
I'm sorry, that was my impression at the time. I do apologize if I didn't understand that, but I remember him specifically saying, no, that's not considered water catchment. That's fine.
Okay, so John, so you see, I've got a room full of people here who want to, they're here for another agenda item.
Yeah,
So I want to
please,
give you the
continue.
opportunity to address the allegations being asserted by OCCL to the land board, upon which they're asking us, the land board, to approve a fine. So so these were the 4 particular structures. And I want to be clear, I don't want to put any words in your mouth, but you acknowledged at least that there was a treehouse. You have subsequently
Yes,
removed it.
yes, I
So-
made a treehouse for my daughter,
Okay,
yes.
so these items that have been listed, maybe there's a difference of opinion between you and the department and staff, but I don't hear you necessarily denying. And I also don't hear you saying that you did get approval, because you just submitted a site plan. You just submitted the after fact last night.
Okay.
So at the time that these were built, you didn't get any approvals prior to that.
Yeah, I didn't realize that treehouses required DLNR's involvement, since it didn't touch the land. It just was some sticks in a tree for my kids to sit on.
Okay, so, all
So,
right.
The next item that you had mentioned, that was in here, that was mentioned, was that we used chemicals to remove plants. That was
Okay,
never,
that's not being fined.
that was never the
Okay, but
consideration.
that's
That
not
was
an
never
issue.
done.
So the only 4
And then
issues,
the paddleboard rack. Yes, we do have a paddleboard rack. We keep our boards there. It's very convenient. If you want, I'll move my board somewhere else. Also, there was a mention in here that the
so I'm
shed,
looking at page 11, because that's what the department,
that the
page 11 of the
shed was
recommendations.
being used for unauthorized use as primarily a personal storage, which is completely incorrect.
Okay.
We 100% use that for our facility. We keep our gas cans, for, and our tools and our
I think
shells
the
and
point
everything in
is
there.
that these structures were built on conservation land, without the approval of.
We did, everything was approved for the shed.
Okay, all right, okay. So I'm
And-
going to let you give one closing comment, and then I'm going to take other
And
public
then,
comments.
and then the mentioning that we use it for the personal thing. It says there was bar stools and fans in there. Yes, the fans were ready to be installed to make it cooler inside there. And then the bar stools were something that we have since removed, but it was nice to have a place for the kids to sit over the treehouse guard wall. So it was part of our treehouse fun. And again, during the pandemic, the kids were locked in place. I wanted them to come out and have a nice experience with it for involvement.
And I don't,
And thank you for considering the request to not fine us for making a treehouse for my daughter or storing my surfboard paddles there.
so, okay, so I'm now gonna, so I think you've answered all of our questions. Board members, do you have any other questions for?
I do, Chair, if no one has.
Wait, no,
questions.
I've got, Paul, go ahead, Paul.
John, I'm sorry, I can't say your last name, forgive me. You seem to place the burden on an act of God to what happened on the property with rainwater, et cetera, et cetera. And while I get it, I mean, that just cannot be the reason that you're implicating that it's an act of God. Okay, and secondly, I truly believe that on your part, it's a lack of respect for the state in what you've done. And I will leave it at that. I know a lot of people have something to say, but
Thank you for your concern. Is it right if I make a comment?
No,
thank you. That is a comment.
okay, all right.
Thank you.
Thank you.
Karen?
I have a comment too. Okay, similar to what Member Canto said. I think one of the misunderstandings that we've been getting more and more of is on conservation land and what you can and cannot do without a permit. And so that's where a lot of the issues that are coming up now are people doing items without a permit. And I understand the situation with the weather and everything else, but you could have easily called probably Michael OCCL and said, hey, I have a big issue here. Can I get a permit? And I'm sure that they would have probably tried to work out something because we were all going through the same thing at the same time.
I actually did. And he said the office was closed. This time we'll take care of it later.
Yep.
I called and sent several emails. I'd be happy to provide the evidence.
Okay.
All right.
It
Well,
wasn't you personally, it was to your department. Thank you.
regardless,
Thank you, you, ma'am.
you answered
I
my
hear you.
question.
All right, any other comment, any other questions? by the
I
board?
do.
You
I
do?
do, Chair. Yep, sorry, thank you, Chair. John, let me get this straight. So I was listening to your testimony and wrote down some notes. Did you say that the treehouse was for your daughter? Is that what
Correct.
you said? Okay.
Daughter.
And
And then-
daughter and son, but she was the.
Yeah, daughter and son, your
source of it, yes.
daughter and son. Okay.
Correct.
And then you also said the rack was for my surfboard racks. Is that correct?
Correct. It's
Okay.
it's for our family. Yes.
Yeah. And then there was a quote, something I guess in the treehouse again, a stick for your kids to sit on, correct?
The bar stools. Correct.
Yeah, okay. John, are you aware, like in a state, any kind of culture, natural preserve, there's a more public kind of expectation for the use of such lands. Are you aware of that, John?
Yes.
So how does that congruous with things for your daughter and your son and your surfboard? How is that congruous? Can you explain that?
So thank you. If I may. So the property requires a lot of upkeep. 75 acres, around 200 different homes. So while our volunteers come, yes, we have picnics. While I try to entice my kids to put their iPads down for the day to come out and help Daddy dig in the dirt and garden. Yes, I've made a treehouse to try to entice them, and the surfboard rack. There's some good breaks there. It's very nice to have. So, but if you want, I'll definitely move the surfboard racks. But having
John,
75
sorry, John,
acres,
I
having
don't want to,
one
John,
area that
John,
we use
sorry, I don't
for-
want to interrupt. I know Chair wants to move this on, so I'll try to be quick. John, sorry. My question is not surfing or the sport of it and all that stuff. It's the possession of your stuff, your kids, my surfboards in a very public, what should be a very public and open area.
It's not
for
a public area. This is a private property, sir.
I get it, but it's so divorced from anything that's really conducive to kind of community gathering and helping Malama Aina, which is the kind of the.
I think in Hawaii, every community has a surfboard rack around here. I think that's just part of the
Mm-hmm.
culture.
Okay, John.
To
Hey,
say that's
thanks, John.
not, that's
I
not part of
appreciate
the
your
public.
time and answering the questions. Thanks, John.
Thank you, sir. I hear your concerns.
Thank you very much. So I'm not going to take public comments. I've got several people that have signed up here. So the first one I've got is on K1 is Melia. Come on up, John. So
John,
yeah,
move.
you can both John, both of us. Yeah.
Good morning. Aloha Chairperson Chang and board members. My name is Melia Lane Kamahele. I serve as the Vice President of the Ainahaina Community Association. I'm a 45-year resident of Wailupe Valley in Ainahaina. I retired from a 40-plus year career as a resource conservation and management, and I'm an adjacent landowner immediately on the downhill side from the Wailoa Ridge Preserve. With a heavy heart, I have watched the absolutely irresponsible management of these parcels for almost 10 years since it was purchased. In addition to what you have in your binders, I would like to provide a few additional comments. It is documented that a male lived on that parcel for more than 2 years. When we asked John Guagliardo why this person was there, he told us he's a quote unquote caretaker. A caretaker of what? At the time, there were no sanitation facilities on site, a tool shed, and the community was concerned regarding sanitation issues. In addition, there are documented at least 27 truckloads of construction debris that were taken up on that site. Concrete, driveway, walkway components, building foundation materials, ceramic toilets, glass shower doors, rocks, boulders, and wood were all dumped on site and used to build a huge unpermitted terrace above my residence with issues of slope erosion, instability, and current water runoff. The residents of Monowea Street remain concerned about insurance coverage at the parcel and potential rockfall issues and other things such as flooding and slope. Within the last 6 months, all the remaining kiawe trees on the site Malka of my residence have been cleared and cut out. There are 2 remaining healthy old growth trees along the driveway that have been sheared off on one side, so we don't know about stability of those. There's no permitting that we know of and it's the conservation and preservation zoning up there has been blatantly ignored. Cumulative impacts have damaged the lands and resources, and this is not Pono. It is disrespectful, arrogant behavior and ignores the rule of law. I'm supportive of the staff submittal and recommendations. Mahalo for your time and consideration.
Thank you very much, Melia. I have next on A1, K1. Is it Jean Ota?
Chair Chang and members of the board, Jeannie Ota on behalf of the Ainahaina Community Association. You have my written testimony asking that you approve of the recommendations of the staff, impose fines, and escalate to daily fines if necessary. We have neighbors who have complained for many years and are concerned about the safety of their homes. So we need to put an end to this. Thank you.
Thank you very much. Is there anybody else in the boardroom to provide comments on K1?
Sure.
Yes.
Thank you, Chair. I wasn't going to speak on this topic, came for a previous one. But what's concerning to me is conservation, right? Bottom line. The idea of private land, what he told the board member, that's the attitude we have. When we have these lands that is protected by the state or by the people, we have people that buys it, thinking they can do whatever the heck they like. No accountability. So I don't know when is this going to be fines? When is it going to be taking away the land? Because now, I did this because of the storm. I did this. Regardless, I cannot go ahead and put a big wall in front of my neighbor's yard because the neighbor's smoke coming over or his debris from the wind. Because I got to go get a permit. Why does people feel entitled that they can just go ahead and do whatever they like, and then after the fact put in one permit? Everybody with money and stuff. That's just the whole reason why we get this kind of pilikia. Because now I'm glad what the lady was saying is true. They got the kiawe trees, put this thing over. Lucky the land never go down and kill somebody in her house. Those are the things that they don't take consideration, having an engineer go out there, see if you're removing these things on the land that was there forever, regardless of the landslide. So to me, I agree you guys are going to do this fine, but is this going to teach the person that owns the land a lesson? Probably not. Mine this, I this, my that, there this. It's all about him. It's not about the preserving of the Aina. And that's the problem we're having right now, you guys. We keep on giving on Band-Aid to these guys. Yeah, 29,000 is more than I think I can pay for. But again, what is he gonna do after he pays the fine? After he fixed out, take down the treehouse? All of these things, considering going over and over, and we're considering to let it go from the state and the county. Soon as these guys pay the fines, then we're back to zero again. Where is the protection for the land, the INA, and the residents surrounding that land? Since 2017, seems like they've been having one issue. When are we gonna protect that over the private landowner? So I'm not sure if there is or there ain't, but I wanna work with you guys going session time, that we need to figure out how, if you're neglecting the land that is supposed to be protected, and you bought it knowing the way it is and what was the land about, then we need to take consideration in taking the land back, and we, people, take care of the INA, or the state, I guess. I'd rather not say that, but I mean, I'd rather have somebody preserve it to protect the people that are living in the area. So that's what really got me, was sitting here listening to his justification. It does never justify anything of what he did on that property. Not 1 cent he made to justify the disrespect for that property and the people that lives around it. Thank you, Chair.
Thank you very much, Senator. Is there anybody else in the boardroom that'd like to make a comment on K1? Is there anybody on Zoom? Rihanna? I'm going to close public comments. Board members.
Can I ask a question about previous testifier?
Yep.
Okay. Ms. Kamali, can I ask you a question? At the end of your comments, you talked about kiawe trees that were cut.
Yes.
Okay, I wasn't aware of that. I didn't see any pictures of that. So I'm assuming you said you lived in this property for like 40 years or something.
I've lived adjacent to this parcel,
Okay.
so I've watched all of this for 10 years. So just to clarify, when the tree house came down, he not only took down the tree house, he took the whole tree.
Okay, so my question is,
Mhm.
were you living in this location in 1987 when those storms on New Year's Eve happened?
In 87. No.
No. Ms. Oka, were you there? Okay. I used to work for the landowner. Maybe school's property in Hawaii Kai. All of the valleys in East Honolulu flooded on New Year's in 1987. Whether it's Kalama Valley, Haheone, Kamiluiki, Kuli'o, New Valley, Ainahaina, all the clay soil ended up flooding the drainage ditches. And part of that and the damage that clogged the drainage structures was because of indiscriminate tree trimming, and then the soil came down. So I think that's an important item to notice in the record, that you can't do that kind of landscaping in a conservation district without a permit. So I just want to put that in the record, that occurred, and there's a public health hazard for everybody who's downhill of them. Okay, I'm good. Thank you.
Thank you. Any other
Chair,
questions?
question for Melia. Chair, sorry.
Okay, so you go.
Hey, how's it, Melia? Good to see you. As far as the caretaker, where's that caretaker now? And was his position or role ever to be verified synonymous to be that of a caretaker?
No. We don't know where he is now. I don't know. I haven't seen him up there recently. I do pay attention to traffic up and down because it comes right past my house. And as far as we knew, there was never a defined role for a caretaker. And there was never the intention of a tool shed that turned out to be huge. And we had issues with the gentleman who lived up there for 2 years. And the neighbors had a number of circumstances which involved us having to call the police department. So he was randomly living up there every day for more than 2 years, and we document him going up and down. I have spreadsheets of time in, time out, what was in the trunk of the bed of his truck. Sorry, I just, I have to be proactive about what's going on and who's cruising in the neighborhood.
Okay, thank you, Melia. Appreciate it.
Yep.
Thank you. All right, I'm going to close public. No, I'm sorry, you can't. Thank you very much for offering though. Okay, I'm going to close public comments. Board members, do I have a motion?
Motion to accept staff's recommendation, Chair.
Second.
I am going to, thank you. Motion has been moved and seconded. I am going to propose an additional amendment to this action. that since the board has found in making its motion violations, that that a condition be added that the board's action be recorded at the Bureau of Conveyances so that it runs with the land. Oh, did I miss that? Oh my God, they're ahead of me. Thank you,
It's on number
staff. I must have missed that in the recommendations.
It's on number eight.
Riley just pointed that out. Okay. I don't know how I missed that. I apologize. Okay, with that being said, a motion has been moved and seconded to approve staff's recommendation to fine the owner $29,500. All in
Can I
favor?
make a comment?
Oh,
Okay.
yes.
Discussion now.
Okay.
So I just wanted to point out item number 5 in the recommendations is that it allows the owner of the property 6 months to correct all these violations. And if he doesn't, on the 6th month and 1 day, he starts accruing additional penalties of $15,000 a day.
Per day. Good point. Okay. Thank you. So I think, all right. Okay, so motion has been moved and seconded to approve staff's recommendation. All in favor, please say aye or raise your hand. Okay, motion passes with 7 votes. Thank you very much. Thank you. We're now going to move on to item K2. Michael?
Morning, again, board members, Chair Michael Kane, Office of Conservation and Coastal Lands. Item K2 is another enforcement case. This involves what we allege is permanent noncompliance regarding a shoreline erosion control device and encroachment without authorization on state land at 55-271 Kamehameha Highway. This is in Laie in the Ho'olauloa district, or the windward side for those who are familiar with the Oahu districts. Quick background, because I know we have big items ahead of us. In 2017, check my dates, OCCL issued an emergency permit for 2 properties in the Pounders Beach area. They're experiencing severe erosion. We authorized the placement of sandbag burritos, erosion control devices for 3 years while the landowners worked on a long-range plan. This is a little bit different in that the emergency permit was actually accompanied by that plan. So that's Exhibit H, dune restoration plan, a beach nourishment plan. So at least in 2017, this appeared to be ahead of the curve. Like usually in other cases I've brought to you, we've approved emergency permits with the understanding a plan will be developed. This came with the plan. However, to our knowledge, that plan was never implemented. And in fact, you'll notice that the engineering prepared the plan. I want to let them off the hook a little bit, because apparently they were not the ones who installed the devices. The landowners changed contractors. So I'll be nice to them this once. So that was due to be completed in 2020. In 2021, site visits to the area showed that the structures were dilapidated, half buried in sand, not even protecting the properties from erosion. 2025, we received complaints routed through the governor's office about these structures. We have a number of site visit photos showing you the condition of the beach. And I don't know if it's appropriate to share photos from yesterday, given that, huh?
It's okay.
I can? All right. So this is the condition of the property. Yesterday, I'll share with the audience. Sorry, guys. I'm low tech. So in this case, we met with both of the property owners after our initial site visits and worked out a plan for removal. One property owner moved forward. This property owner, even though we had met with them and developed a plan, never submitted a plan. To our knowledge, never really followed up with removal of these structures. They did submit evidence at one point when we pressured them that they had been doing work. This would be page I do want to share page 82 of your staff report in the exhibits towards the end. As evidence of the removal, they submitted a picture of some broken sign bags. This is exhibit 9. Page 82.
Yes.
But a subsequent site visit showed that on the beach, again, there were significant structures. So, we're bringing this to the board for resolution. We're asking for $213,000 in fines and that they be removed by February 1st, 2026, or additional daily fines will begin accruing.
Thank you.
And
very
thank you.
much. Thank you, Michael. Board members, any questions for Michael? I do see the landowner and his counsel here.
Good morning, Chair Chang and board members. Tim Irons from Denton's US LLP on behalf of the Greggs. We have James Gregg here, his son is here, and other family members. To cut to the quick, I was retained yesterday. I submitted a letter last night. It may have not made it into your documents. Basically, what we would request is a 30-day continuance to get up to speed, assess all the facts. And what I do know is they recently submitted a beach restoration plan to staff. And, you know, the original, I'll just say the original report with the permit back in 2017 was really an analysis, and it had all sorts of alternatives, including a seawall and other things that wouldn't ever be approved. So it wasn't like any plan was approved back then. That was just information that was given to the board. And so what I would say is the owners they want to do what's right. They got a permit. They want to protect their property, their home. And what they have done is attempted over time to remove the fabric of the bags, because these bags are up to 40 feet long. They are extremely heavy, and the conditions of this nearshore environment out there are such that sand will move in, and throughout the year, it'll cover all the bags. It'll be buried under the sand. So there is no access. And then other times of year, it might be exposed and you see some of the pictures of the fabric there. But in order to pull those bags out by hand, you have to literally dig through tons and tons of sand in order to expose the bag enough to pull it out. And they have done that, you know, since the permit expired. And so, you know, it's not for any willful act on their part. It's just the impracticability or impossibility of actually doing that work. And what they would hope in the interim, if you do grant a continuance, a short one, is that they can work with staff for a plan they have that's actually feasible, doable, and could be copied by, you know, other homeowners who are facing this on the North Shore, which there are many. And it's, you know, multiple times per year sand replenishment program in connection with removing all those bags. They can remove them, but they will require heavy equipment similar to what was used to place the bags, which took 6 weeks. And if they remove all those bags, they are very concerned about not only their house, but the neighbor's house, if they can't simultaneously restore the beach and the dune. They have access to the sand, they have the ability to move it over, and they would really love to explore a win-win and spend all their money doing the plan and fixing the beach and the dune rather than paying fines.
Thank you. So your request is for a 30-day continuance.
Yes.
And I'm also hearing, I guess I'll ask the landowners. You've just recently come on board, so you
Correct.
may not know the history of the property.
Not in detail like they do.
Okay, thank you. Why don't we have the landowners come up?
Technically, James is a landowner and Joshua
I'm
has
his son.
Okay.
his son, but he is knowledgeable.
Hi,
Good morning.
I'm the guy cutting the bags.
Okay.
I'm James Gregg. My son,
My name is-
older son Joshua.
Joshua Craig.
We've, well, we don't like the look of the bags, I mean, to be honest. I mean, who would like that? I mean, they look horrendous and terrible. We'd like to get them all out. But we've been in Hawaii for my grandparents, my wife's grandparents, we've been in Hawaii since the late 1800s. And then I've spent all my time surfing from North Shore to East Oahu, South Shore, not too much on the west side. But I've been doing that for 60 years now. And I've known the currents and everything. And I've body surfed at Pounders over there. When I was just a little kid, I would look at the houses over there. That was a Walker Estate. And look at that and thought, boy, that's a beautiful house. Someday it would be so nice to live next to a body surfing beach. And so we have a house in town, and then Henry Walker subdivided their property, and then we're able to purchase one parcel of that, and back in 1998. And then, so we've lived there since then, and we've looked at the ocean. It's been gradual erosion, but then it's been really heralded by huge storms that have come in and then eroded sometimes up to even maybe 8 to 10 feet of our dune on the property. So we are kind of accommodated for that, but then we wanted the permit to get the sandbags placed. And then when they expired, the sandbags were present in, like sometimes a month or 2 months at a time, usually at this time of year. And then we would try to trim away all the broken fabric. But to remove the entire bags, really need heavy equipment to do that, because you don't want to piecemeal take it out. You need to get it all out, otherwise it's going to go in the ocean.
So, all right, so, do you want to have?
Would you like me to speak first before asking questions, or? Oh, so my name is Joshua Gregg, for the record. Thank you this morning. So in 2017, we had a very large erosion event that took almost, I think, 30 feet from the dune in about 3 or 4 days. That's when we spoke with Sea Engineering. They produced kind of options for moving forward. The short term through the OCCL at the time with Sam Lemo was that we'd be able to build sandbags, give us time to assess the situation, come up with a final plan. I think in 2020 is when I think it's Act 16 formed. It made about half of the options that we had been developing up to that point illegal. So we reassessed and began working on effectively the plan that we just provided to you a few days ago, or to the OCCL a few days ago. We have been actively removing the sandbags. I can attest that they did look decrepit starting in 2021 because we no longer serviced the bags as the permit had ended. There was minor repairs, but really just entirely removing anything that was exposed. As it became exposed, and especially as the bags failed, we would cut the loose fabric away and remove it. The beach moves considerably throughout the year. Some periods of time, the beach will be 5 feet high of sand below the bags, and that is truly impossible to dig by hand 200 feet going 5 feet down to get these bags out. When the bags do become exposed, it's often it's under turbulent conditions. It's very quick. The fabric becomes exposed, we cut it away, but there's more fabric underneath. To fully remove the sandbags, we need machinery. We had met with Michael Kane and Trevor Fitzpatrick on May 5th, kind of outlaid our plan that we had been working on, as well as what we would need to remove the sandbags. It took us longer than we had hoped. I appreciate that. But we now have a plan that we can stand behind. We had asked for 30 days to just work through what that plan would entail with the OCCL. It's an opportunity that guarantees that the dune will exist forever, the beach will exist forever, and our home will exist forever. We've lived here for 30 years. I fully plan on having my grandchildren living here. I love this place.
Thank you. So I just want to confirm, you've lived on this property for 30 years?
Yes. It's never been an Airbnb, nothing.
Taking
care of it too. Yeah.
So, and would you confirm this was apparently a picture taken on October 23rd? Is this accurate?
Yeah, that looks about accurate.
Were any attempts made to remove these?
So we have not been there since October 23rd. Or not on the beach. We've been just devoting our attention to this board action.
Board members, do you have any questions for the Gregs?
I do, Chair, if no one
Go ahead.
does. Okay, thank you, Chair. So in the packet, it says on September 2017, the department authorized a temporary erosion control structure for 3 years, during which time permitted to work on long-term solution, which you identified, from 27 to 2020. And then Act 16 came along, which in effect kind of killed armoring of shorelines. That's the Cliffs Notes version of it. And then you also said that half of the solutions that you came up with in the 3-year period were no longer viable because of Act 16. If I look at the report, the Muliwai Shoreline Erosion Alternatives, section 3.2, it explicitly says, and this is previous to Act 16, the state of Hawaii and the city of County of Honolulu have adopted policies that discourage the hardening of shorelines, particularly in areas with sandy beaches. So what I'm saying is, previous to Act 16, the report had already been proactive about the fact that armoring would not be a viable solution. 3.21 then gives a possible solution as a series of groin structures accompanied by beach fill would create a stable beach cell within the groins. So what I'm saying is, the problem was identified previous to Act 16, solutions were provided, and the responsibility of providing solutions technically should have happened in 2020 or 3 years after 2017. So what solutions, I haven't seen what you've submitted to OCCL, was it yesterday or I can't remember what you said, but what in a nutshell is the solution that you're proposing that is going to be different and innovative from what was already codified in 2017?
So difficult doesn't mean illegal. We definitely appreciate that getting a seawall in 2017 would have been very difficult and most likely cost prohibitive, just as the growings were cost prohibitive. I mean, it's more money than what we have. We can't afford to do a $10 million project. We felt what was expressed to us was that we did have some kind of situation in which we would possibly be able to harden the coastline or do something kind of more extreme than what we're currently proposing, because we are at the end of almost 3,000 feet of hardened coastline. We are the only property in that entire kind of bay area. There's a large pipe that emanates out from the coast. It's a stormwater drain. And from that point on, 3,000 feet down the coast, which is the direction of the current, it is completely hardened. It's all rocks. There's everything that's there. There's also a large natural coral shelf. It's kind of a sandstone shelf that allows for the ocean to wash over it, but it doesn't wash out like a natural sandy beach does. All of the water for that 3,000 feet exits at only one low spot along that entire coast. That happens to be directly in front of our neighbor's house. And so it produces this just massive current. You can't swim against it. You can't paddle against it. It's in our report. I think it's midway through the pictures. You can see it. It was during the Kiko hurricane that came by the islands. You can see the wall of water coming past the point. It washes out. You can see the sediment washing into the
Josh, if I
ocean.
could ask you
Mhm.
to answer the question. So he asked
Chair.
specifically, what are you proposing?
Sorry about that. So what we're proposing is that we lose sand during high tides, storm events. That sand then moves down south towards Pounders Beach Park. It washes into the stream mouth, which is the Muliwai, and it retains all of that sand. It washes it above kind of the peak of the beach and then into the stream mouth. It retains, right now, we think there's about 16,000 cubic feet of sand there. Most of that sand comes from our dune or the beach in front of our property. What we're proposing is that twice a year, we would move a small portion of that, as much as, practical, but no more than we would alter the Muliwai in any capacity. We don't want to harm it. We would move that sand, put it back to where it came from in the dune, and then we would have plantings in our property that would try to, protect the existing dune, allow the beach to erode naturally, and then as it erodes, because it's really only a few storms a year that move sand one way or another. We gain sand about 3 months, 4 months out of the year. We lose sand 3 or 4
Proposing a
months out of the
sand
year.
replenishment.
Yeah, sand replenishment.
So Evie, do you have any other questions you want to ask him?
Yeah, thank you, Chair, for keeping it on point. So just one last, so this solution that you're proposing was, which is basically nourishment, Chair is correct, is basically a sand nourishment. Is that being engineered or looked at by a coastal engineer of any sort, or is this kind of your own idea?
So it was
had before by Sea Engineering. That was one of the proposals.
It had been guided by Sea Engineering's proposal. We had talked with Andy Bolander, during that whole process extensively, but we produced this plan ourselves.
Okay, thank you very much, Chair.
I guess, my concern sitting on the board is landowners don't act until we come down with an enforcement action. And there's a history here. There's been, appears if you have tried, you've attempted, as Michael said, back in 2017, you actually came with a potential regional plan that was never implemented. But we're now at 2025, almost 2026, and nothing has been done. I will share with you our concern from the state's liability. This is extremely hazardous. People have been caught in these bags. I've had testimony from people from the North Shore. Denise Antolini has talked about being wrapped in these sandbags. These sandbags create a hazard for marine resources like monk seals. So you knew when you placed the sandbags that you were going to have to remove them at some point in time. And that original approval was in 2017. And again, we are in 2025. I recognize that the changing conditions have exacerbated the shoreline erosion along the North Shore, but you're not the only ones. I mean, we have been issuing fines of over almost $1 million to landowners along the North Shore for situations very similar to this. So, but again, I think the department and likewise the board, we are much more considerate when you're proactive. But when you come to us in response to an enforcement, it's really difficult to, how would I say, to engender that there's a real desire to do something. Because it does appear as if you're only coming to us when there's an enforcement action. Because it sounds like you just submitted your plans to OCCL, and I'm assuming that's after you received our notice of violations.
May I say something towards that effect? So this plan would have been submitted about a month ago if it had not been for the notice of board action. That greatly complicated our submittal. We had to rush to, find counsel, that sort of thing. We had some difficulty doing that. It's the reason.
But that's really.
But this has
you're
not been an
required to
easy
have counsel.
process for us at all.
But this has been going on pre-2017. So
not pre-2017.
there has been erosion in this area. That's why you came to us with the sandbags in 2017. So this is not a unique or a one-time situation for the properties along this area. You bought beachfront property. That is part of the nature of land in Hawaii. You buy beachfront property, that shoreline may erode away. it may accrete, but it may erode away. So I mean, I think, and you seem to be extremely bright people, so that I think you didn't go into this totally blind. But I guess the requests, so you are not denying any of the allegations. It's just that you're requesting additional time to work with OCCL.
It would,
Well, Joy, hold on. I'm asking, they're not gonna answer, they're not gonna agree to all the allegations in there. There's tons in there. We dispute the vast majority of them. In particular, there's one that claims that there's some sort of public easement. It's not, it's a private easement. So I'm not gonna let them just agree point blank, their blanket.
Yeah, I would prefer,
Of
yes.
all the allegations.
And I would prefer not to have to go through each one of the allegations to get your statements, but I recognize you have counsel and your counsel has asked for a 30-day extension. Is that your request?
yes.
Board members, do you have any other questions? Or let's see, do I have any other members of the public that would like to provide comments on item K2? Okay, anybody? Oh. Oh. Okay, okay. So I have just been informed that, that your request for OCCL to review your beach nourishment proposal would have to be, OCCL could not entertain that because there's been a notice of violation. So you'd have to address that before OCCL could authorize any beach nourishment project or any remedies that you may be proposing.
If I may, I would just suggest that within the 30 days, I don't think there's anything preventing both of those to happen simultaneously, so that if there's some agreement in terms of moving forward that works for everybody, it's a win-win, then the penalties or fines as well could be part of that. And so I don't think technically they can't be discussed at the same time if we get the opportunity to.
And I'm not sure I necessarily agree with you unless we agree to the extension so that there's no
Correct.
action taken on this.
Yeah.
Then you could proceed. Okay, board members, I'm going to close public comments because I haven't received anybody in either the boardroom or on Zoom. So I'm going to close public comments. Board members, do you have a motion?
So move, Chair.
Okay, a
To
motion has
support
been
staff
moved to
recommendation.
accept staff's recommendation.
Second.
A motion has been seconded to approve staff's recommendation
As submitted.
as submitted. Cure the violation.
Yeah, and Chair, just open to
Yes.
discussion, open to edits to the motion.
Okay. Okay, are there? Well, I'm debating whether we go into executive session.
So can I just have a
Yes.
clarification here? So our motion and second is to cure the violations.
It is to adopt staff's
Yeah.
recommendation of the
Of the
fines,
violations.
of the fines.
So nothing more beyond that point then.
Yeah. I'd like to make a motion to go into executive session.
Second.
Yes, a motion has been moved and seconded to go into executive session. We're going to go into executive session and then we'll come back.
I think you have to take up a vote.
Oh, you're right. All in favor of going to executive session, please say aye. All right. So I'm going to call a little we're going to go into executive session. We will come back. You may stay here. We're going to go in the back. Everyone, we're back from our executive session. The board went into executive session pursuant to HRS 92-4 subpart 5 to confer with our deputy attorney general on our duties, privileges, and liabilities. We went into executive session pursuant to 92-5 subpart A subpart 4. Thank you very much. So, all right, we are back on the record in open session. Board members.
Yeah,
A
Chair,
motion has been moved, yes?
Chair,
Go ahead.
in light of council's request for 30-day continuance and in the spirit of consistency previous to previous and relevant board decisions, I will withdraw my motion.
Thank you. The second?
Second.
Okay. So thank you. The motion has been withdrawn. The chair is going to make a motion to grant the 30-day extension as requested by Mr. Gregg's counsel. The expectation within that 30 days, and actually it's probably going to be a little longer than 30 days. It will be at our December 12th land board meeting. But the expectation is that one, Mr. Irons, our deputy attorney general is Danica Swenson. We would ask that you make sure you call her as far as expectations, and that you are working with OCCL, the Greggs, on developing, response. But the agenda item will come back as is, as an enforcement action. So we are hoping that by the time you come back in December, that you have, in extremely good faith, worked with OCCL on some solution, okay?
Thank you.
Okay.
Thank you.
Okay.
You're welcome.
Okay. A motion has been made. Second, a motion has been moved and seconded to defer item K2 until our December 11th, 12th, 12th, December 12th, 2025 land board meeting, and that will be in Honolulu here. All right, all in favor of the motion, please say aye.
Aye.
Thank you very much. The vote passes.
Just for clarification, now that you voted,
Yes.
should I wait to hear from Danica?
No, I think you can continue discussions. I think Danica will have a conversation with Mr. Irons, and then, but
Thank you.
yes.
Include me in any discussions that you have with them, please.
Very good. Thank you very much, Michael, and thank you very much. And I apologize. We are going to take, a 10-minute restroom break for the board members, and then we're going to come back. I am wondering, I have items D1 and D2. I know many of you are here for F1 and F2, and that we're going to anticipate is going to take a very long time. What I'm proposing is that we do items D1 and D2, we do a lunch break, and then I come back and dedicate the whole afternoon to F1 and F2. Is that okay? Because I know many of you are here for that. That way you can go out and take a lunch break, come back. We will try to reconvene. I'm assuming D1 and D2 isn't going to take too long, so we're going to try to come back by noon. Okay? Noon. All right. So with that said, we're going to take a 5-minute restroom break. Okay? All right. Thank you. Thank you. Thank you, everyone. We're back on the record. We're going to take item D1 at this time.
I'm not sure whose binder this is.
I don't know.
Oh. Good morning, Chair, members of the board, Ian Hirokawa with Land Division. So item D1 is a set aside to State Department of Transportation for pedestrian safety improvement purposes and issuance of a construction and management right of entry at Kawailoa, Waimea, Wailoa, Oahu, and seaward of parcels 619, 21, 22, and 6110, 19, and 20 portions of that. So I think the easiest way to explain this is that if you turn to Exhibit A1 on page 5 of the submittal, this is near the Laniakea Beach, the highway, Kamehameha Highway fronting Laniakea Beach. So if you look at the image, the blue area is the existing highway right away. Because of, the shoreline has moved inland, DOT is proposing to realign the highway to what is the kind of white area. And the area of set aside is the yellow. So what it is basically the red is the shoreline, the most recent shoreline. The yellow is an area of submerged land that is essentially in between the existing right of way and the new highway alignment. So we're just proposing to set it aside to DOT to create one large area under DOT management. So we don't have like this orphan strip of land between the two areas. And the area Makai of the highway, DOT plans to provide landscaping and pedestrian bicycle access to offset
This is the Turtle Beach one, right?
Yes.
Okay.
And I'll be available for any questions. And I think DOT and the consultants might be online as well. So
Board members, any questions for Ian? All right, is that Todd Nishioka? Okay, these are all of our consultants, DOT consultants. They were waiting to be let in. Okay, DOT, I hope you heard Ian's presentation. Do you have anything you want to add to this, D1? If so, introduce yourself.
Hi, this is Todd Nishioka. I'm from WSP USA. We're the consultant for the Department of Transportation. And sorry, I was trying to figure out which button to press. So I was hearing it from both sides. I apologize for that. I think what he said is pretty accurate there.
Ian is usually pretty good. He's usually pretty accurate. Okay.
yeah, thank you.
Any questions for board members? Do you have any questions for either Ian or DOT? Okay, seeing none. Is there anyone in the boardroom that wants to provide a comment on item D1? Is there anyone on Zoom who wants to provide a comment on item D1? I see many people, but my suspicions are that they are consultants for DOT. Okay, Rayon, anybody's got their hands up, or I'm going to close public comments. Board members, do I have a motion on item D1?
Motion to accept staff's recommendation.
Do you have a second? Motion has been moved and seconded to approve staff's recommendation as to item D1. All in favor, please say aye. Aye, raise your hand. Oh, thank you very much, Kaivi. Motion passes with 7 votes. Let's do item D2.
Okay.
D2, we can do that very quickly.
D2 is a non-action item, a report on non-action item prior to, a lot of the briefings you've had in the most recently regarding these court cases. So report on Hawaii Supreme Court published opinion in Ke Kauhulu Omana versus Board of Land and Natural Resources. The copy of the decision is attached to Exhibit A, and I believe the AGs will provide the briefing.
And I believe Miranda Steed is on her way down. Do you have a motion to go into executive session?
I move.
Have a second. The motion has been moved and seconded to go into executive session. All in favor, please say aye.
Aye.
So what we're going to do for everyone is we're going to go into executive session and can I also include that as a lunch break, Danica? Or is it just executive session?
I know you guys have done case briefings during lunch before,
Yeah.
but I'm not entirely sure what that looks like statutorily, so I'd recommend just doing the executive session and then
Okay.
doing the lunch break. Rather than doing them together. I mean, if you want to, you can.
Yeah, it's a non-action item, so that's just so that I can give the public a notice of when we're gonna come back.
Okay, yeah, that's fine.
Okay, so we're gonna do executive session and we're gonna do a lunch. And we're gonna come back at 12 o'clock. And the items that we're gonna take are items, the last two items is F1 and F2. The board, oh, and I'm sorry, I think we have to stay on site here. So I'm sorry, I'm gonna have to ask members of the public in the boardroom if you can go out and then come back and we'll reopen the door at noon. Okay? So we are both in, we're gonna move into executive session and recess. you for your patience. We are back on the record. I'm going to close that we took an executive session in item D2 to confer with our Deputy Attorney General on the board's privileges, duties, and liabilities. So now I'm going to move on to item F1. So thank you. Before we start, I'm going to make a statement on the record. The land board members received very late. It was a motion to disqualify Board of Land and Natural Resource members Wesley Kaivi-Yoon and Riley Smith from agenda items F1 and F2. We also received a email from Mahesh Cleveland representing Earth Justice, and in response to the motion to disqualify. So I want to note that for the record. At this point in time, I am going to give an opportunity to both board members, Riley Smith and Kaivi-Yoon, to make a statement before we proceed. So, Riley? Okay, Kaivi?
Oh, yeah. Okay. Thank you, Chair. And thank you for sharing the emails. I just want to start with for items F1 and F2, Chair, I firmly believe I can be fair and impartial to the matter, and my decision making as a board member will not be affected by my personal opinions or backgrounds. But it's worth noting that I think as human beings we all have personal feelings and backgrounds, and sure that helps inform our worldview. But I have every confidence that the board and the way it's making its decision is for the betterment for the people, culture, and natural resources for the state of Hawaii. Thank you, Chair.
So can I ask you, Board Member Yoon, can you be fair and objective in rendering a decision on items F1 and F2?
Yes, I can, Chair.
Thank you very much. Board Member Riley Smith?
Yeah. Hello. I just wanted to let everybody know that I've read all the materials that have been provided to the board. I've also conducted a lot of my own research. Based on that research, I do have my opinions. And at the same time, I feel that I can be honest, open, fair, impartial, and that I am not irrevocably closed to openly looking at all the information provided to us. And I just want to make that statement. Thank you.
Thank you very much. So Board Member Riley Smith, can you be fair and objective in reviewing and taking action on items F1 and F2?
Yes.
All right. With that being said, we're going to proceed on items F1 and F2 with all 7 board members present. Okay. Brian and David, please proceed.
Yeah, aloha, Chair, board members, Brian Nielsen. I'm the administrator for the Division of Aquatic Resources. Also joined by David Sakota, Dara Fisheries Program Manager. And then on the Zoom, we have Chris Teague, who's our district biologist for West Hawaii, and Brian Ishida, who's our fisheries biologist. And we'll be starting with F1, which is a recommendation to deny the written contested case hearing request filed by Ron Tubbs et al. Regarding the board's acceptance of a petition to initiate rulemaking filed by rulemaking petitioner Kalani Hale, Kama'aina United to protect Aina Kupa Friends of Ho'okena Beach Park, Moana Ohana, Polaupopo Hawaiian Civic Club, and for the fishes. And hand it over to David to make a few comments.
Thank you. Good afternoon, board members.
Afternoon.
Again, David Sakota, Fisheries Program Manager with DAR. Just to give a brief overview of what this item is about. So in October 2023, we received a petition for rulemaking to do rules to ban aquarium collection statewide. The board heard this petition at its meeting on December 8th, and staff's recommendation was to deny the petition for a number of reasons. Recognizing that the board could initiate rulemaking on its own. The board ended up not going with staff's recommendation. The board approved the petition and directed staff to initiate rulemaking. But there was also guidance from the Attorney General at the time that the board did not have the authority to completely ban aquarium fishing statewide because of the existence of a statute that permitted it. And so the instruction through the division was to proceed with rulemaking, taking into consideration the statutory requirements and the sentiments expressed at that board meeting, of which there were many testimonies both against and in support of aquarium collection. So that's kind of what we proceeded to do, to develop rules. In April of 2024, we did our own independent review of the best available information regarding the proposed take of certain species by the West Hawaii fishery. We presented that to the board. And along with that, we asked for clarification of the board's guidance to proceed with rulemaking. And the guidance we received then was still pretty vague. It was to do rules to regulate the aquarium fishery. And so based on that guidance, we have developed these rules that we're proposing today. But before we can do that, on this petition, there was a contested case hearing on the initial rulemaking petition. And we consulted with our Attorney General's office regarding the petitioner's actual rights to a contested case hearing. And the guidance we've received is that there is no right to a contested case hearing for a rulemaking proceeding, being a petition for rulemaking. So with that background, our recommendation is for the board to find that rulemaking actions pursuant to HRS Chapter 91 are not entitled to contested case hearings as a matter of law, and requesting the board to deny the petition for contested case hearing by Ron Tubbs on that rulemaking petition. And happy to take any questions if there are any.
And I guess I just wanted to be very clear. There is a remedy in the event under the chapter HRS 91-7 that the remedy to challenge a rule would be to seek a declaratory judgment versus a contested case. So we're not precluding, but that's once the rules go through the process. Is that correct?
Correct.
Okay, because I want to be very clear to everyone that we're not saying you cannot challenge the rules, but there's just a process to do it. A contested case is not the appropriate process to challenge a rulemaking procedure. That is through chapter 91-7. Okay, all right, thank you for that clarification. All right, board members, do you have any questions for staff? Or do I have anybody online, staff, that want to add anything to the presentation on item F1? Okay, seeing none. Board members, do you have any questions for staff? Okay, I am now going to take public comments on item F1. And I will ask everyone, we have item F2, which is the actual proposed draft rules. Item F1 is just the action on the denial of the contested case, okay? So I just want to be real clear about that. With that being said, do I have any comments on item F1, which is the denial, the staff's recommendation that the board deny the written contested case hearing filed by Ron Tubbs et al. In the petition to initiate rulemaking. Is there anybody here who wants to make a comment? Mahesh, come on up.
Thank you, Chair.
Thank you.
Good afternoon, everyone. Welcome to the new board members. My name is Mahesh Cleveland. I am with Earth Justice, and we have represented the folks advocating for protection of the nearshore resources for several years now. On F1, we agree with DAR's assessment. We attached to our testimony the rulemaking petition from December 2023 that was the subject of the aquarium collectors contested case hearing. It is clear, not just from the AGs, but in our case law and in our statutes that there is contested case hearings and rulemakings, as you said, they've got nothing to do with each other. And as you've mentioned, the proper remedy for challenging a rulemaking is to challenge a final rule. So I just wanted to reiterate our support for the staff on this one and point out that the petition that this board unanimously granted was to form the basis for the rules that DAR was to bring to you folks to take up for hearing. And that'll be an F2.
Mahesh, I want to thank you.
Oh, I usually only show up when I on this one. You're right this time. There you go.
There is a moment to sell, but you know what I appreciate? Just, the law is the law. And, and we, let's find a path forward, but I really appreciate recognizing that and having, and I will say, the courage to come and tell the board exactly that. It would be easy to sit in the back there and say nothing, but you took the time to sit up here.
And I think in this case, maybe we didn't need to say anything, since that's but I also really want to thank Member Smith and Member Yoon for standing your ground on this, because the whole reason we have volunteer decision-making boards in our government is to make sure that we incorporate a broad variety of perspectives and opinions about things. So thank you, and thank you all.
No, so should there be some kind of subsequent legal action, we would look forward for your participation.
We'll see my name on it. Thank you.
Thank you very much. Thank you. Okay, is there anybody else who wants to make a comment on item F1? Is there anybody in Zoom who would like to make a comment on F1? I see Ron Tubbs. Go ahead, Ron Tubbs. If you can introduce yourself and unmute yourself. Go ahead.
Yes, Board, I'm unmuted. Can you hear me?
Yes, we can.
Yes, I'm Ron Tubbs, former aquarium fisherman for over 45 years. Participated in numerous ecological studies and have been an advocate of sustainability in the Hawaiian Islands regarding the fishery. Just like to point out that the fact that there's a lot of precedence in not closing or being prejudicial against one fishery over another. The mere fact that we are the only group that has a permit that DLNR submits is sitting before you having to complete an EIS and passing an EIS and still not having permits goes to show that the prejudicial nature against this fishery. Science and all of the facts regarding the fishery over decades have supported the stance that the fishery has always been sustainable, will be sustainable, is highly valuable. It also has the lowest carbon footprint of any fishery in the state. The resumption of the fishery to the state of Hawaii would actually reduce carbon footprint, because instead of having to import aquarium fish into the state, we could once again take fish locally. Fish are the most renewable resource on the planet. They're highly reproductive.
Ron,
So I'm hoping that everybody understands that, the Constitution upholds our right to fish along with the Hawaiians' right to fish in this fishery.
So I just wanted to remind you that this is F1. It's on the petition for room. It's on the petition to deny the request for contested case, not on the rulemaking. In case you weren't aware.
Thank you.
Thank you very much. Okay, all right. Is there anybody else on Zoom who wants to provide a comment on F1? Renee Umberger, and again, if you could limit your comments to F1, which is the denial of the written request for contested case hearing. Please go ahead.
Yes, Chair. Mahalo. Aloha, Chair and members of the board. Renee Umberger, Executive Director for the Fishes, 2023 petition Hui member. I support the recommendation to deny, but I also feel compelled to point out that I think it's interesting that on the one hand, DAR's recommending to deny the contested case request, but on the other hand, in item F2, for all intents and purposes, DAR is giving the trade the relief they sought in the contested case request, which is a rejection of rulemaking to ban in favor of rulemaking supporting it. And I find that pretty stunning. And that's all I have. Thank you.
Thank you very much. Is there anybody else on Zoom? Okay. Seeing
Yes,
no other
yes, there
hand-
is.
Oh,
Yeah.
I'm sorry. Go ahead. Who is that? Who is that?
This is Jeff Davis. I'm not seeing my video on my screen, and to be
Yeah,
honest, I don't
see
know
your
why.
video either.
It says it's on.
We can hear you, but we can't see you.
Okay.
So if you'd like to proceed, go ahead.
Yes, thank you, Chair Chang. First of all, as Mr. Cleveland referenced the motion to disqualify, and I will too briefly. I filed that yesterday. We didn't have a lot of notice when this meeting was coming up, for sure. Whatever Mr. Cleveland sent you in response to it, I don't have, so I don't know what he said. The standard in a motion to disqualify is not whether the board member or the decision maker says they can be fair. It is if they appear to be unfair, they may not serve. And Board Member Yoon has said, I would never support aquarium fishing. I am anti-aquarium. Board Member Smith has, not in quite such strong language, but said that he agrees, I am generally opposed to aquarium collection in West Hawaii. This is not a broad range of views. This is people who have pre-decided the issue in one side. The Supreme Court has said people who have made those decisions in advance may not serve. The appearance of impropriety is enough to disqualify. This is under Hawaii Supreme Court case law that I have cited to you. As to the specific F1 agenda item, this was a petition for rulemaking that is targeted to a very small group, to affect a very small group of the public, the fishers. This is not a broad-ranging rule that says nobody may take a boat into a certain area or everybody must have a license of a certain kind to use the resources. There is a very small group. Mr. Cleveland and the group he works for, Earth Justice, and their clients have been targeting just the aquarium fishers for a very long time with this type of procedure. They are not targeting the public. They are not asking you to do something that affects more than a few people. Right now, there are 7 fishers with an accepted EIS who want to fish. They've been deprived of that for years. So this is a targeted attack on them. It is not a broad-ranging rule. Okay. And
so, Mr. Davis, your time is up.
Well, Chair Chang, I filed that petition, and I think.
And I'm sorry, we have decided, I have asked both of them if they can proceed and be fair and objective, and they both indicated yes. So while I recognize
that is not the standard, I would like a hearing on that.
No, excuse me. So while I recognize you may have a different understanding of the law, we're going to proceed with the full board at this time. You are free to take any kind of action that you may feel appropriate after that, but we're going to proceed with item F1 and F2 as they've been submitted.
Yes, I understand you are proceeding, and I am making my objection to proceeding.
Okay.
Chair Chang, and to proceeding without a formal hearing over the standards for disqualification that we outlined in our brief. And I am objecting to F1, and that's all I have to say.
All right, thank you. We will note your objections for the record. But thank you very much. All right, is there anybody else on Zoom that wants to provide a comment on F1? Okay, with seeing no hands coming up. Oh, is there one?
Or maybe they're just here for F1 and don't want to testify.
Okay, if I don't see any hands up, so I'm going to close public comments. Oh, Kim Cock, you have a comment for F1? Go ahead and unmute yourself.
Sorry, my reception's bad.
And this is on the petition? This is on the denial of the written request for contested case hearing.
Correct. Chair and board, I believe many of you don't understand this history. It spans many terms of chairs, starting with Mr. Isla, 2 terms of Ms. Case, and now into Ms. Chang's. Every time the board and chairs have weighed in, specific instructions were given how to proceed. First, the courts required environmental review. An EA was done by the entire fishery. 125 licenses were evaluated. That was denied, and specific instructions once again were given to include cultural consideration, science, and preventative measures such as climate change. A full cultural impact statement was conducted, which every person here today included to participate and give guidance from cultural perspectives. The NGOs participated with front row seats as consulted parties to guide in this alternative process. A full EIS was prepared based on the cultural impact statement and NGO consulted parties. The species were reduced once again from 40 and limits on the amount of participants based on the EIS process and requests from the board. This board and chair then denied this and said it must be redone based on science and 14 other things. So again, fishery reductions were made, species were reduced from 40 to 8. The board requested hard limits, so quantities were reduced, historical limits based on science, and extra reductions were taken to account for preventative measures like climate change, and many species were giving up for cultural concerns like the pakui. The fishery has been reduced to such a small amount that it is equivalent to death by 1,000 cuts, a ban by endless reductions. To summarize, this is the first, second, or third time some of you are weighing in on this process. Realize that your peers have mutilated the fishery and written requirements were given to use science to guide decision making. I ask you to take responsibility and ownership of the decisions this board has made and maintain the criteria and guidelines set out through this entire process that has brought us here today.
Okay. So Kim, your time is up. Your time is up. Thank you. All right. Is there anybody else on Zoom that wants to provide a comment on F1, the denial of the contested case? Seeing none, I'm going to close public comments. Board members, do I have a motion on item F1?
Chair, I move that we approve a denial of the written contested case hearing as recommended by staff. And I wanted to cite the consultation with the Office of the Attorney General that recommends that the board find that the petitioners are not entitled to a contested case hearing and subsequently deny the request.
Second. Motion has been moved and seconded to accept staff's recommendation, which is specifically to 1, find that the rulemaking actions pursuant to HRS 91 are not entitled to a contested case hearing as a matter of law, and 2, to deny the petition for contested case hearing. All in favor of the motion, please say aye or raise your hand. Motion passes with 7 votes. Thank you very much. We are now going to move on to item F2.
Okay, thank you, Chair.
Thank you.
Moving on to item F2, request for approval to hold public hearings on draft administrative rules, updating and consolidating aquarium fishery regulations into a new chapter, Hawaii Administrative Rules, HAR Chapter 13-77.1, Aquarium Fishery Management, and amending HAR Chapters 13-75, Rules Regulating the Possession and Use of Certain Fishing Gear, and 13-60.4, West Hawaii Regional Fishery Management Area, Hawaii, for clarity and consistency. And I also want to mention that we did put together a packet of just some of the charts that are in the presentation, because some of them are quite complicated and hard to see from the screen, but it is a long, complicated history with this fishery in terms of legislative bills, BLNR actions, and court cases. So we've also summarized a timeline of those 3 things as well. So that's in the packet.
Are
that
there
was handed
extra
out.
packets?
There's extra packets.
So members of the public can also get a copy of those. Okay. Thank you
And
very
with
much.
that, I'll hand it over to David to provide a presentation to the board. Thank you.
Thank you.
Okay.
There's a copy up here, so I only have a few. If you want a copy, please help yourself.
Okay, we'll get started. So I have a PowerPoint presentation. We'll make this available in PDF right after this. So
So that means it would also be available to the public
yes,
as well.
yes,
Okay.
and it will be
All right.
posted on the
Very
board
good.
website.
Okay.
So this, I'm just gonna go over in part 1 an introduction and background information about the proposed rules. And then in part two, I'll go over the proposed rules themselves. So first, I wanted to give a timeline of the aquarium fishery, just as a refresher for those of you that have been involved in the process for a long time, and then for our new board members to kind of get you up to speed. And a lot of this is detailed in our submittal. So from October 2012 to October 2017, there were a series of court rulings stemming from the initial case filed by Renee Umberger et al. Against DLNR. That lawsuit sought a ruling that aquarium permits that were issued by DAR were subject to the HEPA process, the environmental review process. That series of cases ultimately resulted in the Supreme Court ruling in 2017 that aquarium permits are indeed subject to HEPA. After that, when it was remanded to the circuit court deemed all commercial aquarium fish permits void and illegal until HEPA was complied with. And so from April 2018 through June 2021, a couple of groups of aquarium collectors, one in West Hawaii, one in Oahu, started to go through that environmental review process. And finally in in 2021, June 2021, this board was reviewing the second version of the West Hawaii environmental impact statement for acceptance, and there's a tie 3-3 vote, which as a matter of law is deemed to accept the EIS, and that was affirmed by the court on appeal. So as of then 2022 August, the validity of the revised final EIS was confirmed by the circuit court. And then in November of 2023, jumping forward, we received a petition to initiate rulemaking to ban aquarium fishing, which I kind of went over in F1. And we've gone through that process. And then that brings us, I guess, to today, where we have these rules that we've drafted based on the guidance that we received from the board, and our best attempt to regulate the fishery through rulemaking. And yeah, here we are with this approval, and this is the beginning of the process. So at today's hearing, we're requesting initiating the official Chapter 91 rulemaking process, which would involve us going out to public hearing, receiving testimony, and then coming back to the board with a final recommendation.
Sorry, David, I do want to interrupt, but I noticed on your photo, you didn't cover legislative.
Yeah,
Is that you're
so
gonna cover that?
throughout this time, and even before, there have been a number of bills introduced at the legislature regarding aquarium collection, mostly to limit or close the aquarium fishery. None of those efforts have ultimately been successful or resulted in legislation to regulate or shut down the fishery. And we just wanted to note that because this hasn't only been a request for DLNR action, it's been also debated at the legislature as well. Anything else you want to add?
No.
Okay.
Slide 2.
Oh yeah, sorry. This is you have a handout on this. There was a bill in 2017 that would have ended the aquarium fishery until DLNR could do a very comprehensive review of the sustainability of the fishery, and ultimately that one was vetoed by Governor Ige at the time. And then I did mention, so in April of 2024, last April, our staff did an independent review of the preferred alternative in the final EIS for West Hawaii, which was a proposal for the take of 8 whitelist species and annual catch limits for those. The materials are, I believe, on the BLNR website for that date, as well as on YouTube. So I encourage you, if you're interested in learning more, you can go back to that hearing, that board meeting, and review the DAR briefing. But ultimately, this independent review concluded that although some risks cannot be avoided, overall risks of major population and ecosystem impacts are low. And that's for allowing collection under that preferred alternative. And we also evaluated all of the proposed regulations that we would implement to regulate the fishery if permits were issued. And so based on that, the conclusion was that the fishery, as proposed, would be the most intensively managed fishery occurring in state waters. Okay, so part 2, I'm going to go over the actual administrative rulemaking proposal. So these involve chapter amendments to HAR chapter 13-60.4, which are the West Hawaii Regional Fishery Management Area rules, as well as chapter 13-75, which are our rules regulating the possession and use of fishing gear. And I just want to note that these are only being amended to accommodate the new aquarium provisions that we're including in a new chapter, which is 13-77.1. So even though these other chapters have other sections in them, we're not making any changes to those non-aquarium related sections. So very quickly, the amendments to the West Hawaii, the WRFMA chapter, the West Hawaii Regional Fishery Management Area, are to repeal all provisions related to the West Hawaii Aquarium Fish Permit and Aquarium Vessel Registration, because those provisions that formerly applied only to West Hawaii are being applied statewide in our new chapter. We're leaving in place all other fishing rules in West Hawaii, including the fish replenishment areas where no take of aquarium fish is allowed, and all other marine managed areas within the WRFMA. And then very quickly regarding the amendments to chapter 13-75, which is our gear regulations, we amend references in the nets generally section to match the new State of Hawaii Aquarium Fish Permit and the new rules that we're proposing. We're amending the rules for traps by reorganizing that section for clarity. And then there was an AQ exemption for small mesh traps, and we're putting that into the correct section instead of in the net section. And then we're also amending and adding some of the definitions in that chapter to align with the new chapter that we're proposing. Okay, and then the meat of the rule changes is this new chapter 13-77.1 we're entitling Aquarium Fishery Management. And there are 2 subchapters. So subchapter 1 includes rules that would apply to aquarium collection statewide. So sections 1 through 5 are applicability and scope, penalty provisions, asset forfeiture provisions, severability, which are all standard in all of our rule chapters, as well as definitions that apply to this new chapter. Section 6 outlines rules for non-commercial take, which I'll go over later. Section 7 outlines the requirements for State of Hawaii Aquarium Fish Permit, including the application process and the general terms and conditions associated with that permit. Section 8 outlines aquarium collection vessel rules, and Section 9 deals with commercial aquarium dealers. And then subchapter 2 involves regulations specifically for West Hawaii. And this includes an applicability section for state waters of the West Hawaii Regional Fishery Management Area. And then rules that apply specifically to West Hawaii through a geographical endorsement. It incorporates all of the previous West Hawaii aquarium fish permit terms and conditions and restrictions. And then it provides an updated whitelist and ACLs. And I'll go into more detail on that. So here's a brief overview of what we're proposing for non-commercial aquarium take and commercial aquarium take. So previously, there was no regulations on non-commercial aquarium take. So if someone was using legal gear, except in West Hawaii where you needed an aquarium permit, in the rest of the state, you could use legal gear and take, unlimited fish for personal use. Under the proposed rules, we're proposing 5 specimens per person per day. They wouldn't need a permit. If you have a home aquarium, you could take up to 5 per person per day, using legal gear, taking legal species subject to statewide size limits and season restrictions. And then we also have special activity permits. And so that's using restricted gear or taking restricted species or sizes or during a closed season. And usually those are issued for researchers or educational institutions. We can also issue it for management or propagation purposes like coral nurseries, etc. So that's a way to improve our management of the non-commercial take. For commercial aquarium take, we're establishing criteria to be eligible to apply for a commercial aquarium permit. So a person needs to have no criminal resource violations within the last 5 years, must demonstrate compliance with HEPA, and has to have a valid commercial marine license. Once someone is deemed eligible for an aquarium permit, they're issued a state of Hawaii aquarium fish permit plus a specific geographical endorsement, which authorizes collection in a specific area. And this allows commercial aquarium collection of whitelist species in specific areas up to the established annual catch limit or ACL. That's kind of generally how it works. So what does HEPA compliance under our rules mean? Because that's one of the criteria for applying for a permit. So what we're proposing is that if an EA or EIS is completed and accepted by an individual permittee, then that named individual is eligible for a permit. If an EA or EIS is completed by a group or an organization, then that organization is the initial applicant and must designate individuals to receive the permit under their HEPA compliance. And these designees must comply with all of their permit requirements, and they're responsible for all subsequent renewals. And they also assume all responsibilities to comply with the terms and conditions and for any violations. We've established a permit application process, and this is just an illustration to show how this process would work. So there would be an initial submission window. Initially, it would be for 30 days after these rules are adopted. And then every following year after that, the submission window would be from October 1st through November 30th of each year. And that will give us time to review applications as they come in. So when we get applications, DAR would review and inform applicants if additional information is necessary. If all the requirements are fulfilled, DAR would send a statement of preliminary approval, letting the applicant know that their application has complied with all the eligibility requirements. And then we would do a final review of applications after the close of that application window. So between November 30th and December 31st. And we would issue those permits within that time frame. So that they could begin collecting January 1st of the next calendar year. additional general permit terms and conditions, and this is again statewide. These aquarium permits would be non-transferable and usable only by the permittee. It would allow the individual to use fine mesh aquarium nets and traps. These collectors must transfer their catch to a registered commercial aquarium dealer within 1 calendar day after landing their catch and before submitting their final catch report. They're also subject to container and gear labeling requirements, and that's something that used to apply just in West Hawaii, and we're making it statewide. For reporting, we have a couple of new reporting requirements to facilitate enforcement. So we have an at-sea report that's required prior to landing. So the collector will have to, before they land at the ramp, they have to either send us a text message or email letting us know where they're landing, who's on the vessel, which vessel they're using, and then which whitelist species they caught, how many of each species they caught. And they notify DAR and DOCARE so that we have the opportunity to go to the ramp and check them. And what they report needs to match up with what they come in with. And then they're required to final aquarium trip report within 1 calendar day after they land. And that's to verify that what they reported is accurate and consistent with what they actually landed. And there's a 5%, allowance for miscounting while they're on the water. Specifically for West Hawaii, we have terms and conditions that were in the WRFMA rules previously, and we're incorporating in this new rule package. So no aquarium take at night, although collectors may possess restricted gear with prior notification to the department. That's consistent with the prior rules. We're proposing the allowance of take and possession of kole of any size. And this, again, is what was allowed in the prior rules. When we adopted the herbivore provisions a couple of years ago, which regulated the minimum size of kole at 5 inches, one of our recommendations was to carve out an exemption for the aquarium fishers because they target the smaller sizes. This board said, let's keep the minimum size at 5 inches without a carve out, and that can be addressed at a later time. So this is that later time where, we're developing rules for this fishery, which targets those smaller sizes. The kole, even though they can be taken at a smaller size, there will be a annual catch limit. So it still limits the amount of kole that they can take. And then there is a rule also that was in the prior rules that we're incorporating here that no more than 5 kole larger than 4 inches can be taken for aquarium purposes. And with the ACLs, DAR will issue a warning notice to all of these collectors when the ACL is at 95%.
And the ACL is annual catch
Annual
limit.
catch limit, yeah. So we track that because of these daily reports. We'll have real-time counting of how many fish are reported caught. So for each of these species, if any one of them hits 95% of the annual catch limit before the end of the year, we're going to issue a warning notice to them by email at least 3 days prior to closure. So it'd be, you're at 95%, the fishery is going to close in 3 days. So they have 3 days to keep fishing. If the catch exceeds the ACL within that 3-day window, we just subtract that amount, the overage, from the next year's ACL to ensure that, it doesn't keep adding up over and over. Here's the proposed West Hawaii whitelist species and ACLs. So Lauipala, yellow tang, 200,000 fish per year. Kole, gold ring surgeonfish, 12,775 fish per year. Umamalei, or orange spine unicorn fish, 5,827 fish per year. Chevron tang, 3,152 fish per year. Potter's angelfish, 1,086 fish per year. Ma'i'i'i, brown surgeonfish or lavender tang, that's 800 per year. Hinalea EEV or bird wrasse, 344 fish per year. And Thompson surgeonfish, 182 fish per year. And this is the cumulative among all 7 collectors. And for West Hawaii, we're not planning to do individual catch quotas. It's just a overall ACL. So, you know, any combination of catches totaling that will close down a species for the year. Just a few more slides about statewide regulations for aquarium collection vessels. These used to only apply to West Hawaii, but we're making them statewide if there should be a fishery elsewhere in the state. Registration as an aquarium vessel is required, as well as identification markings on the vessel. So specifically the letters AQ and a flag with or pennant with the letter A on the vessel. Dive flag required when divers are in the water. That's a DOBOR requirement. Notification to DoCare and the Coast Guard when the vessel is inoperable. One new thing is that we're allowing up to 2 non-permitted individuals to be boat operators to help with operating the vessel. They're not allowed to participate in the aquarium collection or be in the water unless of an emergency situation. And these vessel operators will also have to have a CML because they're participating on this commercial fishing trip or be covered by a vessel license. And then we have proposed rules for commercial aquarium dealers statewide. We just implemented a commercial marine dealer license on the 1st of this month. So now all dealers, whether they're food fish or aquarium, need to have a license, an annual license. On top of that, we're requiring aquarium dealers to register as aquarium dealers. That's a new requirement. All specimens taken for commercial aquarium purposes must be transferred to a registered commercial aquarium dealer. So this prohibits a collector from collecting fish and then exporting it to an out-of-state dealer because we have no accounting of what those out-of-state dealers are purchasing. So this requires transfer in-state, and we have a requirement for those local dealers to report what they're purchasing from collectors. Dealers are allowed to sell aquarium fish after the ACL, like if an ACL is reached and we close the season, if they have stock on hand, they are allowed to sell it, but they're not allowed to purchase more, and they have to have receipts showing when they purchased it. They're also subject to an export report. So any fish that they send out of the state, they need to report to us. And so that allows us to have an accounting of what's caught by the collectors, what's sold to the dealers, and then on the dealer side, what's purchased from the collectors and what's exported. So here's an overview slide of some of the regulations that were in place prior to the fishery closure compared to the current proposed rules. So for the permits, previously, the permits were only for the use of small mesh nets, and that's generally statewide. Specifically in West Hawaii, you needed the permit for any gear for aquarium collection, but in the rest of the state, it was just for small mesh nets. And under the current proposed rules, we're proposing that you need an aquarium permit for any aquarium collection, regardless of gear. Previously, there was no requirement for HEPA compliance. There is that requirement under the new rules. Previously, reporting was required once a month, and that's after the month ended. Under the new rules, we're proposing at-sea reporting as well as final reports within 1 day after landing, which I described. Before the closure, vessel and registration and marking requirements were applicable only to West Hawaii. We're extending that statewide under the current proposed rules. I went over the dealer registration and reporting requirements. So previously, there was no dealer license, no aquarium dealer registration. There was reporting, and under the new rules, dealers have to have a license, they have to register, and they'll have to report. And then there's this additional export report requirement. There is no requirements for transferring to dealers under the old rules. Under the proposed rules, all catch, as I mentioned, need to be transferred to a local dealer. And then under the old rules, there was no review of the criminal history of an applicant. What we're proposing is that any criminal conviction for an aquatic resource violation in the past 5 years would make the person ineligible for a permit. And then specifically for West Hawaii, previously there's a whitelist of 40 species, and we've reduced that down to 8. And there were no catch limits for any of those species. And I went over the proposed limits for that. And one additional thing, I think it's in the handout that we provided. Pre-closure, I believe 42% of West Hawaii was completely closed to aquarium take due to various fish replenishment areas and other marine managed areas. Since then, the Miloli'i CBSFA has been established, which provides additional closed areas to aquarium take. And so under the rules that we're proposing with the new area closures, I think the amount of coastline closed to aquarium fishing is up to 46%. So additional protections. I believe we've provided also a handout on frequently asked questions and frequently heard comments. And we just wanted to highlight a few of them because I know questions will likely come up. So why has DAR not done an analysis on the proposal's impact to Native Hawaiian traditional and customary rights, also known as the Kapa'akai analysis or Flores case Ohana analysis? And similarly, why have we not done a public trust analysis? So these analyses are not appropriate at this point in the process. We're just requesting to hold public hearings. The rulemaking process and those public hearings are meant to solicit feedback from the public that will inform these analyses through testimony. So they run concurrent to the rulemaking process, and we can only complete that analysis after we receive those testimonies. So we will be presenting those analyses when we present final rules to the board.
So it's not that you're not doing it, it's just the timing upon which you're going to
Yes,
do it.
at this point, we can't do that because we haven't heard fully from the public. Number two, how is this proposal in alignment with the board's hierarchy of use policy? And this is a policy regarding commercial activities and recreational uses and the resources themselves. But that policy specifically notes that it does not apply to extractive uses of resources such as fishing. However, we're confident that even if that hierarchy were to apply to extractive uses, the proposed take that's being proposed in these rules would still comply with the hierarchy because the data show that the proposed take will not have any measurable impact on fish populations or the habitat for those species. And the hierarchy allows for commercial activity when the use does not impinge on the natural or cultural resource or on use by the general public. Number three, DAR is attempting to circumvent the board and remove their oversight of aquarium collecting permits. So the board remains the ultimate decision maker in these matters. You have direct oversight through the approval or denial of administrative rules. Through this process, we hope to lay out clear and objective guidelines for permit issuance making permit issuance a strictly administrative step that's carried out by the division. Number 4, why is DAR proposing to allow take of species that are successfully bred in captivity at aquaculture facilities? So DAR's policy is to promote the sustainable use of the state's aquatic resources. As we've presented to the board, the data shows that the proposed take will likely not have a measurable impact on these fish populations, and therefore we think that the take of in the proposed rules is sustainable. And then finally, a comment, 200,000 lauipala is a lot, too many to take from the reef. Again, our review indicates low risk of population or ecosystem declines due to the proposed take limits. A conservative estimate of the lauipala population in West Hawaii is 2.6 million. It's likely higher than that. And using that conservative value, the proposed take of 200,000 represents 7.6% of the population. Couple of things that it's important to note. This fishery targets the juveniles of these species, and research indicates that very few of the new recruits and juveniles actually survive to adulthood. For yellow tang, it's estimated that just 1% of the new recruits make it to adulthood due to natural mortality, predation, competition, etc. And then also research indicates that each adult female yellow tang releases an estimated 1 to 1.3 million eggs each year. So just to give you an idea, like 200,000 is a lot, but in context, this is a very abundant species. So we believe that, allowing the take of the juveniles of that species won't have any noticeable impact on the population as a whole. This is my last slide. Next steps, just to provide the board with a rulemaking timeline estimate. So today we're requesting approval to hold public hearings. In November, if the board approves, then we also will take these to the Small Business Regulatory Review Board for their review. We'll likely hold public hearings sometime in the January through March timeframe. It'll take us a while to analyze all the public testimony. And then we plan to bring it back to the board and back to the Small Business Review Board roughly summer 2026. So it could be faster, could take longer, but that's kind of a rough estimate.
Thank you for the comprehensive review. Thank you. Board members, do you have any questions for staff?
Yeah, give me a few minutes.
Okay. So as board member Ono's getting prepared. So in this set of rules, you're requesting approval for both the general aquarium fish rules as well as specifically the West Hawaii.
That's correct.
And these are geographic. So West Hawaii is a geographic designation. So as I understand your proposal, you need to have two things. You've got to have a geographic designation. So if somebody on Oahu wants to do aquarium fish, they're going to have to go through this rulemaking process and establish their own regional designation. Is that correct?
And comply with HEPA.
And
as well.
So how that would work is they would do an EIS for Oahu, and we would evaluate the risk of opening that fishery and establish proposed rules, amending this chapter with new rules for Oahu. We'd bring it to this board for approval for those rules.
So these proposed rules do not permit aquarium fish beyond, at this point in time, West Hawaii.
Beyond West Hawaii, correct.
Any future aquarium fish would have to come back to the board.
Yes.
And go through this
And the
process.
board would also have to accept the EIS
Yes,
for those
accept
other
the EIS.
fisheries.
That's it. Okay, thank you. Karen?
Okay, yeah. The numbers that you showed, your accumulated totals, that's for everybody that's licensed at that particular time? So that 200, yeah,
Yes.
that. So all the permittees have to be within that amount. So 200,000 is the maximum.
So this is the maximum for the fishery right now. There's up to 7 potentially eligible applicants. If more collectors enter the fishery through like another environmental review, then the larger group of collectors would still be subject to
It's
this
still subject to
same
that
limit.
total.
Yes.
Okay. And then the other thing you mentioned about the monitoring, DAR and DoCare. Do you guys check? Okay, so I know you do it on water, but then when they come back into harbor, is there some kind of report that is done there or surveyed by anybody?
Yes, Chris, do you want to talk about kind of planning for on-water and ramp checks?
Sure. Thanks. I'm Chris Teague. I'm the district aquatic biologist for DAR in West Hawaii. Yes, so we've chatted with DoCare about kind of how we can best enforce this this rule if it all goes in place. And part of it would be, as you mentioned, kind of on water checks. So based on that at-sea report, we'll have the ability to work with DoCare directly alongside of them or just by ourselves to go in and meet up with fishers while they're on the water still and check that their catch matches the report that we receive. We also have the ability to, if we're not out on the water, go check them at the ramp that when they're coming in. So we're discussing with DoCare right now about kind of exactly how we would want to lay that out. It would have to be, something random, so it can't be something that, is easy to circumvent. And then we just have to figure out kind of the frequency of those types of checks. I think you were also asking about kind of more broad monitoring. So the reports that we receive from the fishery, both the on-water reports and the final submitted reports, will be checked by our staff on Oahu to make sure that they're consistent with each other. And one of the stipulations is that those reports need to match each other within 5%. Those reports then need to also be matched with the dealer reports and the export reports. So all of that needs to be reconcilable.
Okay, thank you.
Any other questions, board members?
I do, Chair, if no one else is going to. First off, yeah, mahalo, Brian, David, and Chris. It's awesome. It's always awesome. I have a rhetorical / empirical question. How many years and hours and staff have researched and invested time and effort into this AQ issue? Like, you can say choke. That's fine too.
Choke.
Choke.
Or then
I bring it up, guys, because I think we should acknowledge not only the good works of DAR and DLNR, but here we are in consideration, effort, and giving resources to enable commercial AQ. So it's not like board members or DLNR is out here trying to kill the whole thing. We are out here trying to find responsible ways to enable this to happen. So I think that's worth mentioning, and kudos to you guys. At its current status, I find myself at an impasse because this presentation is fantastic. I think one of the things that perhaps it could use a little bit more flavor on is what are the any additional considerations or initiatives that the AQ industry can support or advocate for on a broader level for the health of our moana. You know what I mean? It's like all these rules and procedures are saying X amount of fish, this is why, and the data's there, it's great. But I'm missing the part where the fish win and our moana resources win, right? The commercial fishermen, the AQ fisher, they're winning because, again, we're trying to enable this to happen. I'm trying to find out the win on the other side. And I'm not criticizing staff. I'm just saying it's just a thought I had. And lastly, Chair, thank you for indulgence. I always thought, and we are always taught, probably all of us, as Hawaiians, we leave a place better than how we found it. And that's kind of the a mana'o that's kind of missing in this, because in my mind, if you take something, you have to replace it with something equal, if not better. So the only thing that's better or that wins, again, back to my opening comment, is the AQ industry, right? We enable this to happen to whatever degree, and yeah, it might, you know, upset AQ people, but we're trying, right? We're trying. And to balance I think Chair said it well a couple of meetings ago, to balance all of the politics, the natural cultural resources, staff, it's not easy. It's difficult. You know, so I just wanted to acknowledge the staff and kind of what we're doing. And I hope our detractors and people that have very pointed criticisms against DLNR, its chair and the board, I hope they take a breath to think about kind of how we must think about this. And it's not singular to somebody's opinion or personality. So thank you guys again, and thank you for indulgence, Chair.
Okay, thank you. Riley?
Yeah, I just want to clarify one item. So in your annual catch limit, so you monitor the number of fish that are caught, and that would go up to whatever the annual catch limit total is, okay? So that does not, or let me put it this way. So that's the amount of fish caught at the ramp. But then with fish caught in the wild, every time you handle those fish, so you put them in a container, you ship it to the mainland, you ship it to a dealer, there's fish mortality at every stage. And so you're only monitoring the amount of fish that are caught, not the amount of fish that are sold. And because you're dealing with a fish in the wild, it's likely that those numbers of what are caught could be significantly higher than what are sold. And because we're the Department of Land and Natural Resources, it just concerns me that there might be high fish mortality with wild caught species. So I'm just making a statement, but I mean, that's what you're monitoring, because that's all you can monitor, right? Is what comes in at the ramp. But at every stage you're touching them, there's going to be less.
Right.
They're not going to be more.
Right.
Yeah. Okay. Thank you.
I have a comment. I'm going to put it on my Director of Land and Natural Resources. I think a comment was made about how much time has been spent. A considerable amount of administrative time has been spent getting us to this point. A considerable amount of time is going to be spent on monitoring, on enforcement, and there's no revenue we're generating off of any of this. And I am really looking for a mechanism for us to have the industry help us maintain this activity. I mean, this regulation. And there isn't anything in the rules that provide for that. I mean, fortunately, we had the ocean stewardship fee, the $1, and we are making a considerable amount of money, which is permitting DAR to go back out and do better monitoring. The draft rules have gone out. I mean, they're prepared. I do want us to begin. And so I am putting everybody on notice, including the AQ industry in particular. The rules currently don't have a fee structure for an extractive activity. I mean, they are taking out, and we're not getting anything. And I think that was part of Board Member Yoon's comment about how are we ensuring that we're giving back to this resource. I would like to see some kind of a mechanism, whether it's an annual registration fee, a permit fee, but something that gives us the opportunity to reinvest those fees back into managing these resources. Because DLNR, we are faced with a tremendous amount of responsibility with very little financial support. And the people who should be paying for it are the people who are making a benefit off of it. And so, I would like to see that when we're starting to do the public trust analysis, that we are looking at some kind of consideration for that. So I'm just putting people on notice. I also want to make a point that it is really important that the rules that are drafted now, when we go out to public hearing, those set of rules, if the time is now, so we're gonna take all of your comments. And if there are any changes to the rules that need to be made, they need to be made now, not when we go out to public hearing, because we're hoping, I'm being probably unreasonably optimistic, that the rules that go out to public comment will be able to come back to should the board approve them. I'm not predetermining an outcome, but, those are kind of my comments. I really do want to acknowledge the work of DAR. You guys have spent a tremendous amount of time really trying to fashion something that seeks that little balance. I mean, and I've said this numerous times, the job here at DLNR is walking that fine blade of the peely grass, trying not to go over one side over the other, but really trying to walk that fine line and trying to find the balance. So I think these rules reflect a lot of the comments that you've heard. You've closed a lot of the loops, with the dealership and these other permits that I think you've really heard the community. We're not going to satisfy everybody, but I think that this has been an attempt to find a mechanism that takes into consideration the balance of all of the different interests. Okay, with that being said, if there are no other comments by the board, I am now going to open it up for public comment. I'm going to first take public comments from those who have signed up in the boardroom, and then I will take comments from the members in the board, and then I'll go on Zoom. But I'm going to first take Kupuna. I'm going to ask Kupuna who want to make a comment to please come up. Then I'm going to take people who are traveling. If you came here from in particular Hawaii Island and you want to give your comments early, I welcome you to come up, but we'll do Kupuna first. So any Kupuna, and I'm very careful about who I identify as Kupuna. Everybody's anti, because but I will let you self-identify. If you are Kupuna, you are welcome to come up. Please, you're welcome to come up. Please don't hesitate. Wear Kupuna with pride, wear it with pride. But if you can introduce yourself, and I'm going to ask you as much as possible if you could stay within the 2 minutes, but if you got something to say, you
Good
go ahead.
afternoon, ladies and gentlemen. My
afternoon.
name is Evangeline Leimomi Keaulana. I live in Nanakuli.
Okay.
The other day, I had a very, very hard phone call that I heard of my friend from Miloli'i, that they had these commercial fishermen fishing in Miloli'i, and they're from Waianae, which really made me upset. Now, why are the people in Waianae commercial fishing inside Kapu lands? These people use their fish, that's their living. They live by the ocean, they take everything clear. So I said, you know what? This is going to be war. And I told them, I said, whoever is doing that in Altu, we're going to find out who you are, and we're going to put you in public ridicule. I'm not going to go hurt anybody, but I'm telling you, stay out of our Hawaiian places. We've been pushed around so much. This is the last fishing village. These people are so fabulous what they do. They're self-sustaining. They take care of their land. They take care of their babies. They take care of their aina. I mean, that's the last one. A couple of years back, they said that they were going to make a Waianae down by the Waianae Boat Harbor. They wanted to make a fishing village there. I don't know what happened to that. But I would like to see that, because I'd like to see our people keep our values, because we're being pushed too far. It's time to push back. And we need people like you to listen to our pleas. Please don't let Miloli'i go. try and take care of what we have. You have a responsibility to, I know you have a lot of responsibility, but please hear our plea. Thank you very much.
Thank you, and I appreciate you coming all that way to provide us
Thank
comments and
you.
staying here all day. Thank you.
That is a bona fide kupuna.
He is indeed. Okay, Uncle, anybody else who wants to come up? Please, come on up. Don't be ashamed, don't be ashamed.
No, my name is Wilfred Kaupico, Willie, they call me. I'm just like big kahuna, Miloli, stand up for my community,
Mhm.
and I still will do.
Okay.
I'm just kind of fascinated when William Isla was here,
Mhm.
you know, in your position. I bought my two kupunas from Miloli, Walter Paulo, and Ericana now. Speak to him in Hawaiian.
Mm.
He cried because he understand what they're talking. We have to malama the ocean. Malama what we get in the ocean is our icebox, yeah? We're taught like that. So that's why I look at this kind of industry. Unfortunately, I went to Washington Cemetery, no ahead, giving me this magnificent civic bill. I stopped the development. There was going to build 400 boat marina. I stopped that. They couldn't build it. So, you know, it gave me the fishing rights from South Point to Pocana, all over. So I closed it up. But Bill Wash closed the other end of the divers, asked me if I can stay. How long are you going to stay? I give you 1 year. They stayed 5 years. Today I suffer. All the fish is gone. They took all the life pala, they took all the, you know, it's sad that the Dillinois didn't really manage. That's why if they cannot manage, don't allow this kind of stuff. Believe me, you can, because when money talks, it gets ugly. All the people who's diving in injuries told me, Willie, you gotta stop them because the fish is gone. I'm not there to see one. But every time I see people throw them in the rubbish can when they were tropical fish, they die because the pump, so you know what I mean? And they show them as hurt. People look at the kupunas, they don't like that. You got a malama. So to me, what they're talking about, please stop it. I don't support this at all. We should keep it the way it is. If there's boats that going out, take people diving, which I support, because the people come here to go look, they jump in the water and they go home. Leave our fish alone.
Okay.
That's how I say. So please, I don't like this allowed. Thank you. very much.
Mahalo. Thank you, Uncle. Appreciate you being here. Auntie Rocky?
This is another bona fide kupuna.
Mahalo. Age is just a number. Aloha mai chair,
Aloha.
members of the
Nice
board.
to
For
see
the
you.
record, Le Aloha Rocky Kaluhiva, State Ahamoku Chair. You have your testimony before you, but I'm just going to be reading inserts. Now, for decades, our Native Hawaiian fishermen from all the islands have reported critical declines of marine resources due to aggressive collecting of fish of marine species on the coastal and offshore areas. One of the hardest hit areas is West Hawaii, Mokuokeawe. In 2018, the West Hawaii aquarium collecting ban resulted in the largest yellow tang abundance ever documented on these reefs. However, that is only one example of the success of an aquarium collecting ban on one island. The fear now is, if the statewide ban is lifted, is that the traditional sustainable species, which our Native Hawaiians' traditional practices depend on all islands? It will be wiped out sooner than later. A particular island that is in danger and continuously every day is being raped is the island of Ni'ihau. There's no protection there whatsoever. Because commercial aquarium collecting is such a grave concern to Lavaia within the entire Pa'aina, the Ahamoku Advisory Committee, we did take a poll on every island with all the generation of Ohana that could not accept, and they could not accept the new rules of the island are proposing. The response were unified, every island in opposition. Currently, Lavaia continued to contend with climate change within the Ahapua'a. The unusual ocean heat waves are already impacting the normal life of our marine species. However, in anticipation of and preparation for the difference in ocean temperature, the Konohiki or the resource managers are taking steps in adjusting the kapu resting areas. While this works, every Ahapua'a is different. Our understanding is that the bulk of the aquarium collection is exported directly to the mainland or to foreign countries as pet or ornament purposes. I was raised, if you're not going to eat it, don't catch it. So the indigenous host culture asks why our traditional cultural practices is not protected in the way it's supposed to be protected. It is not only the Native Hawaiians who will suffer if the current ban is lifted, but all Hawaii stakeholders in the protection of our ecosystem. Further, in the DAR submittal and its request for approval to hold public hearings on new draft administrative rules, which they do in the air conditioned office, it does not take into consideration the Native Hawaiian traditional Lavaia practices would be adversely impacted.
Auntie Rocky,
And
can I ask
possibly-
you to summarize?
Okay, in summation, okay. The Department of Land and Natural Resources, your mission statement, enhance, protect, conserve, and manage Hawaii's unique limited natural, cultural, and historic resources held in public trust for current and future generations of the people of Hawaii and its visitors in partnership with the public and private sectors. We depend on the land and natural resources to continue to protect our marine resources from exploitation from those who would make money from Hawaii. Please remember that they take, but they don't put back. Mahalo nui. Ahamoku is advocating we're not advocating the position of opposition, but we represent the voices of the people of Hawaii. Mahalo.
Thank you very much.
Mahalo.
Is
Any
there
questions?
Nope, thank you. Is there any,
My guy, Kela.
do we have others? Come,
On a bark, cool.
Uncle, come. Yeah.
Get up.
Wow.
I'll pass it on. Thank you. Oh, thank you. Oh, that's good, that's good. Okay.
Don't start the clock yet, please. I can read these speakers, so make sure I get all my thoughts out. Hello, no kako. My name is Damien Kennedy. I'm here with my wife, Brandara, over there. We are from Okena, Kawako, the other last Hawaiian fishing village in South Kona on Hawaii Island.
Give me $1 million.
Our community has been involved with the aquarium collecting issue for over 30 years. We participated in the establishment of the fish replenishment areas along the coast of Hawaii. Since then, we have detected various collectors poaching in our FRA, coming at night to avoid detection, acting like they were kaili fishing during the day, while a diver was collecting below the boat, or parking the boat at the edge of the FRA at Alae and swimming into the no-take zone. These are only a few of the incidents where AQ collectors would not abide by the rules we all worked so hard for. At one time, DAR was considered to be our enemy, but over time that has changed. We began to realize that what they were doing was the same as what our ancestors did to ensure that each succeeding generation would be able to enjoy the ia that Kupuna had access to. The Department of Aquatic Resources is our partner in trying to protect our ia for everyone. We trust them to include us in any rulemaking that would impact our ability to fish for our families. 20 years ago, my son asked me if we could spear some fish for grandma. And we went on a canoe to keep away hoi. He told while I followed him with the canoe and filled a small cooler with pakakui Michael Manini Kole. We came home, cleaned the fish, and gave some to grandma and other ohana. Today it's very hard to spear enough fish to share with ohana. Pakakui is a favorite fish of the people of South Kona. But for the past 2 years, DAR has placed a ban on the taking of that fish because it has become scarce. We did not overfish and cause that depletion, but we are being punished anyway. We understand that DAR has the kuleana to be fair when making rules regulating the taking of iap, but they don't know what caused the depletion of pakukui. So how can they determine how much fish that AQ can take sustainably? Our community has been working on a fish management plan for several decades and have adjusted the boundaries to be fair with other fishers who feel they are being overregulated. We gave up an area of 6 miles between Hokkien and Minuli so our friends and neighbors will not feel overburdened by all the communities striving to protect their iap.
Uncle Damien, can you summarize?
We are asking the Board of Land and Natural Resources to please consider this testimony when making decisions regarding aquarium fish collecting.
I am grateful. I apologize when I have to ask you to summarize, but I appreciate your consideration.
Blame him.
I know, you take your time. I know. That's right.
I get more issues than you. I'm gonna explain everything.
I'm only 70, they're more older than me.
Thank you. You want us to add that to your record? Okay.
Thank you.
No, thank you. And I gave leeway to Kupuna. I gave them extra time, but I'm not gonna give everybody extra time. Okay, Charlie?
It was just my birthday, so I'm going to pretend I'm on Kupuna. Okay, first thing, 3 minutes for Kupuna. Aloha, my name is Charles Young. Aloha Chair
Aloha.
Chang and members of the Board of Natural Resources and our 2 new members since the last time I've been here. As I said, my name is Charles Young. In 1999, I submitted my first written testimony on behalf of my community and their concerns over aquarium fish collecting. In going back, I didn't know what to put on my paper because I've said it as many I've repeated. So I decided I'm going to read into the record other people's testimony. In 1842, the king said that the fishing grounds from the coral reefs to the sea beach are for the landlords and for the tenants of their several lands, but for no others. There's our connection. That's our community connection. In a publication, The Works of the Old People, People of Old, Kamakawa states that the Hawaiian people were a race of expert fishermen. The fishing profession was an important one. He goes on to explain how we caught certain fish. In there were koli, mai'i, kala, and hinalea, all of which are on the collection. Okay. In 1903, better yet, the U.S. government published a publication, and in it said, as strange as it may seem, the Honolulu Fish Market in the years 1901 and 02 provided the authors with the richest, most abundant study materials. Hawaiian fishermen whose ancestors had known the habitats and watched the habits of local fish for 1,000 years were of indispensable help. Abraham Kawila, more recently from Lanai, wrote into his mele, Naono o Ka'aina, Naono o Ka'aina, Halialila vale maino o Kama'i'i mekikole, in which he says, this is all delicious. Ma'i'i and kole, again named. In 1953, the Hawaii Territorial Legislature said, some of these ornamental fish have little or no value as food fish, but will sell for as much as $25 a specimen to a mainland market. That's how this started. In 1974, the Constitution wrote into it that the Hawaii must affirm our rights. And in 2000, a Kapa'akai decision decided that you need to reaffirm it. What I'm asking you today is, based on that lineage, to make a 2025 decision, not a 1993 decision or 1953 decision. Things are very different from when this mindset was set into place. And as we're saying now, we've created policy, we've created process, and we've created practice for the aquarium fish collecting. Thank you very much.
Thank you very much, Charlie. I appreciate that.
Thank you.
Do I have other kupuna before I start taking makua? Okay, I'm gonna now call from the list that I have of those of you who have signed it. Yeah, is there, that's right. Is there others from the neighbor island who would like to come up first? No, please come on up.
Feeling
Please
the
come on.
pressure from Uncle Willie.
Well, he puts on my place every day.
Is that
So he
right?
see. I
Okay.
hope he not take it.
Yeah.
He look, he cannot take.
Oh.
Solo. Kahuna got punch.
Uncle Willie, nobody gonna hassle with you.
That's why I leave it to the kahuna.
Aloha.
Aloha Chair Chang, aloha board members Young and Matsubara. My name's Mike Nakachi. I come to you humbly from Kekahavai Ole on Mokuokeawe. I stand on my written testimony that I submitted. But more importantly, I bring into this space and place many people, and I'm here with heroes. I've been on this issue with Uncle Damien and Uncle Willie for over 30 years. I bring into this space people like Uncle Junior Kanuha, Frank Ota, Auntie Josephine Kamoku, Auntie Lily Kong, who have all passed. All of us have become united through the aquarium trade, okay? And just so you folks know, as board members, I am a professional diver. I dive almost every day. And I got our humble start through OHA. And we dive and we have witnessed significant changes over the 80s. Tremendous amount of collectors coming into our AINA in the 90s and 2000s, unregulated, millions and millions of fish departing. So I'm strongly opposing these rules. And the reason is very simple. These rules are industry driven. These rules are, and I feel for DAR, but I think I have an answer for you. Act 306 formed in 1998, which was specifically a rule that then had a governing body called the West Hawaii Fisheries Council. I had a meeting on Tuesday with the West Hawaii Fisheries Council. All usually rules and anything like that associated with the aquarium trade were designated to be worked out at the West Hawaii Fisheries Council. That was not done. These rules are far too premature, were introduced way too early without dealing with all the different forms of community, okay? And what I'm getting at is I can put on many hats. I'm a member of Kia'i Kanaloa. I'm a member of West Hawaii Fisheries Council, but what's more important is that this opportunity for the trade and for people is to take this off because it is a tremendous amount of time. This needs to be fleshed out well before public rules come like this and enter Chapter 91. There's a thing called tri-weight. Took 17 years to do the ask, another 9 years going through the Chapter 91 process to develop rules to come before this body that engaged all civic members of our community. This was not done. These rules are not good. They're unenforceable. And more importantly, I have talked to DoCare agents in West Hawaii, Office of Law Enforcement from Fish and Wildlife. When they seen these rules, I beg to differ with my friend Chris T. They said these rules are unenforceable and they cannot do anything. And
Mike, I'm gonna ask you to summarize.
summarize, since 2017 and it's so greedy on this trade. There has been several poaching cases that this needs to be put back to the community, dealt with within the community, and come back with a comprehensive rule package that is then agreed upon as best as possible before this honorable board. Thank you.
Thank you very much. Do I have anybody else who's from off island that would like to provide a comment? Don't be shy. Oh, please come on forward.
I was on the plane, get a lot of us.
Yep. Okay.
Aloha, Chair, and board members. Hello, my name is Shane Nelson. I'm from Kealakekua Bay, and here to testify regarding the aquarium pet trade rulemaking process. But before I do that, my personal, not just personal, but just my community have grave concerns about how it'll impact not just the cultural values, but also economic as well as environmental concerns as well that the pet trade can have. We spoke about how yellow tang is predominantly the fish that's being collected, and also how the yellow tang is a huge part of our herbivore fish that maintains our reef system. And so it's contradictory to the tourism industry if we approve something that we don't understand well enough. And so with that said, we're hoping, or at least our community is hoping to see a little bit more about how the impacts the negative impacts or the cumulative negative impacts on the tourist industry will play out. If you remove the fish, you remove the very essence that tourists come to visit. And so it's kind of an oxymoron situation in our community's minds. The other thing too is that I wanted to mention, if I can paraphrase the Senator Favela here, that the priority is to the resource, yeah, and not the industry, and we should be looking at that. I want to summarize by making and closing up by saying that some of the fish that was listed in the presentation are food fish. And I think that's really important to consider about what kind of fish should be and not be collected. Based on the timeline provided as well for rulemaking, Dar mentioned that there was an appropriate time to apply the Kapa'akai analysis. I'm concerned that it's not fully understanding when that would happen, Chair. I think it's important to clearly state, and if it's during the public hearing, I think that's too late. That wasn't the intent of the ruling. I think it should be earlier. Anyways,
No, thank
mahalo
you.
for the time. Appreciate it.
Appreciate you traveling this far. Thank you. Okay, others from Hawaii Island who would like to provide comments, please come forward.
I know, get a lot of us.
Okay.
Aloha Chair
Aloha.
Chang, members of the board and new members. My name is Kaikea Nakachi from North Kona, Hawaii Island. I'm standing on my testimony from May and December 2023, April and August 2024, and from today as well. I believe the testimony in opposition for F2. I believe the board should stand with their previous decisions against commercial AQ exemptions for the Kole minimum size rule. I agree with all my fellow community members of food fish should not be on this proposal. Also endemic fish should not be on this proposal, and agree that those that can be farm raised should also be removed, and the emphasis should be put on farm raising those fish, not catching them in the wild. I believe the sheer number of fish being proposed to be removed in West Hawaii is ridiculous. It goes against Hawaiian values and practices in general, but specifically to West Hawaii. I also believe it's a violation of the hierarchy of use priorities, and I disagree that it doesn't apply to extractive. I think that's the sole reason it should be there. And also the precautionary principle and public trust doctrine, I think, are all violated by the sheer number of fish being proposed to be removed. But my biggest issue, similar to my dad, is the unfair standards in this process of rulemaking. We've provided an immense amount of testimony over the years, and aspects of this package has not changed. We didn't know the details of this proposal until a week ago when it was put on the agenda. And nothing has been engaged for communities that this would directly impact. I'm a part of community-based management in West Hawaii, and our communities uphold the actual mission of DAR and DLNR, and we're still instructed to spend years doing outreach before Chapter 91. There was no engagement, no outreach before Chapter 91. So I would ask the board to reject this, send it back, and hold DAR to the standard that they hold us as communities, and come back with a better plan that actually doesn't just take into account the aquarium fishers that would benefit from it, but all the community members, kupuna, to get their manawa on this plan. So thank you.
Thank you very much.
Aloha Chair, board members, welcome new board members. I'm U'ilani Naipo, a lineal descendant of South Kona as well as Kohala. I'm a marine advocate collaborating with many community organizations and partners in West Hawaii. And sometimes my work takes me across the Pai'aina. I am voicing my strong opposition to these rules package and urge you to deny public hearings. I've submitted my written testimony and stand on it. Most of you know my advocacy work in Kapalilua, primarily Miloli'i. But of late, I've been focusing in Kaikuliana. It's a network of 15 community organizations like Kalanihale does for Miloli'i. We individually work to serve our marine nearshore and ecosystems. It's our honorable kuleana and reciprocal relationship we have with our place. We are ho'aina, native tenants of our place. We're co-managers with the county, which are divisions DAR, DoCare, and state parks. We are facilitators to the visitors and the fishers of our shoreline, and hundreds of volunteers that join us to Malama Aina. We create management plans to promulgate rules. We conduct community educational outreach, remove invasives, outplant coral, create community action plan, and even act upon it, all to uphold your mission. It is our commitment to the resources, just like the hierarchy of use. It's so brilliant, and you use it as a tool for evaluating proposed activities like this. But what is even more brilliant is someone like me, a community member, a lineal descendant, and if I take on the kuleana to Malama Mai Aina, I can commit to it. Really easy. So thank you for that. As Hoa Aina, we are leaders and liaison into the community. So how do we explain this as West Hawaii is preparing to have Holomua arrive to our West Shores? This does not align. I want to take you back to August 23rd, 2024 in your unanimous vote to support our petition. Although there are 2 new members, I have all the confidence you would have voted the same. Unanimously, what you voted for was preserving and protecting our culture and natural resources. You voted to prohibit extraction and exploitation. You voted to cancel privatized commercial export. You voted to protect our reefs and marine ecosystems. The rules package is not what you voted for. In 1953, commercial aquarium collection began under legislation under false premise that our fish on our reefs had no function. You were willing to do the wrong then. And I'm asking you today to do it again. Mahalo.
Thank you very much, Ui. Do I have anyone else from Hawaii Island? Are you from Hawaii Island? Are you going to go back to Hawaii Island? Well, I'm going to try to take those from Hawaii Island. They're traveling, and then I'll take them. Thank you. No, please come on. No, please come on.
I submitted my testimony as well yesterday by email. Aloha mai kako to Madam Chair and the members of the Board of Land and Natural Resources. My name is Malia Kipapa, and I speak on behalf of my Kipapa Ohana of Pahoehoe Kona on the west side of Hawaii Island. We are a Lawai'a family, fishing people who have lived along the coastline for generations. The ocean has always fed us, taught us, and cared for us. From the reef to the deep sea, from the limu and the opai that cling to the rocks, to the fish that travel the currents. These are the foods that sustain our ohana. They are part of who we are. To us, the ocean is like a kupuna. An elder who holds knowledge, sustains life, and deserves care and respect. As a Kanaka Maoli, it is our responsibility to malama and steward our resources the way we would care for a kupuna or a keiki. If we all treated everything we hold with this same care, we would not be here today debating what is right or wrong, or who has the most money. Instead, it would be clear. We act for what is best for those who sustain us, in complete reciprocity with the life around us. We are in strong opposition to the proposed aquarium fishing rules and ask that you do not move these rules forward or approve public hearings at this time. When I look at our reef today, I see my kupuna who gathered there and our keiki who swim there now. We will be left if we take without care or reciprocity. Our reefs are our kupuna and lifeline, and caring for them is our kuleana as Kanaka Maoli and good humans. Please protect these waters for the future of Hawaii and our people, and may we continue to be steadfast and mindful of how our decisions today will impact those around us now and in the future. Mahalo nui for listening to the voices of our ohana.
Thank you very much, Malia. Anyone else from Hawaii Island that's going to travel? The last call. Okay. So now I'm gonna go through my list of those who've signed up. Lavinia, are you here? Senator DeCourt, and then I'm gonna take Senator Favilla. Would you like to say something? Yes. And thank you for your patience. I hope you didn't mind that I called those others up before you.
No, and I appreciate you making the arrangements to put this at the end so we could take our time. So
okay.
mahalo, Chair, board members. State Senator Samantha DeCourt, I represent the District of Waianae. However, I'm going to split up my testimony in two different ways. First, I'm going to come as a personal capacity. I am originally from Mokuokeawe. My family comes from Minoli'i, and I speak and represent my family, Kahumoku, Malama, and Medeiros family in this capacity for my first half of my testimony. I was taught by my grandfather and by my kupuna that we don't take more than we need. And right now we're facing a threat to our culture because we have people that are taking more than they need and they're leaving our culture not only naked, but they're leaving it threatened only for profit and only to exploit us as a Native people. And so we find this time and time again with our culture. We give a little and they take our lives. And so right now we're faced with a threat not only to our culture, but we're facing a threat to the only sacred place we have in the state of Hawaii, which is the last fishing village here. And what happens in Miloli'i will be a trickle effect to what happens to the district that I represent here today, which is Waianae. And so I am standing here in opposition of moving these rules forward now and at a personal capacity. Now in my legislative capacity, I'm very concerned that this will be a very heavy budget burden for the department. We're putting the cart before the horse, over-regulating and allowing rules to be amended with enforcement that we just don't have right now. We're short doe care officers, we're short in DOBAR, we're short in every area that we just cannot contain the capacity of what something like this looks like enforcement-wise. So again, what are we going to find out? We're going to find that there are going to be people that are going to just be illegally fishing. I mean, we see this time and time again, and we just don't have the enforcement for it. And I appreciate the presentation from DAR that are continuing to make tweaks. It sounds great, but the honor system for me is over. And I'm sorry, but we can't take an inch while these rules and these changes literally take our lives. So at this point, I stand in opposition, and I thank you all for your ability to allow us to share and to take our mana'o. So
Thank you very much, Senator DeCourt. Senator Favilla?
Thank you, Chair. I'm in opposition on the rulemaking, asking you guys not to make a decision on the rulemaking today and all the things that you have heard. You know, when I got the call last night, it was very emotional for me. She represents the area that we're depleting our fisheries, abuse on our dolphins and our everything and resources that we have that you guys are, don't care and we're supposed to be protecting. But we have short staff. We don't have the money, we don't have the resources. To have this sacred area to be pretty much, I don't want to use the word, raped, taken advantage of constantly on the burden of the people of Hawaii. We always take the burden, and we always got to compromise with the people that has the wallets. Yes, I listen to the other side of the fishery and I understand that. When I look at my resources and I find out how they take the fishes, so we won't count the fishes that come to shore. What about the ones that don't make it up? So you guys know that they purge the fish's lungs so that they can bring them up to the surface. If they live, they live. If they die, they die. 90% of the fish that make it to the continent is dead. Very small percent. So how are we going to protect our people? We're trying to protect the industry that is causing the issue. And we should not protect commercial over the people. And I always say this, industry never comes before the people. People before profit. If we do not save this fishing village that we are talking about, and everybody else is saying, everything that is there, they don't have one store that they can go Taniokas and buy fish. That's their Taniokas. That's their resources. I never got the privilege to go there, even though, Senator Kaikahele always invite me. Never got there yet, but I'm planning to go.
I'll take you.
I want to make sure. I don't swim and I don't dive. I don't swim and I don't dive. But I want to make sure that the fishes are there, that people that do fish and dive for the rest of our long lives here on this earth. But I humbly ask you guys to take in consideration, because we will at the legislation find out how we can do and work with you guys in making better protection and better rules or laws to protect our fishery that is protecting for our people to eat and have for their families. So again, thank you guys. So please, I humbly ask you guys not to make a decision on this rulemaking. No taking nothing away from your staff. Every one of you guys staff, every time I come here, I'm very impressed. They do a very, very good job. But at this time, this is not ready for prime time. So I'm asking you guys to please humbly not to say.
Thank you very
Thank you,
much.
guys.
Thank you, both of you. Okay. Go ahead.
Hello,
Hello.
Auntie. Jonathan Holman, I love you, board. I love all you people, my family over here. When I got the phone call last night from Auntie and the daughter, two things come to mind. Why the West Side and why Miloli? I come from the Koa family. They probably don't know, but they know my last name come from Big Island. And it's very important that people, for me, come first. I listen to the people. Who's the best stewards of the land? The guy who live over there, the girl who live over there. Common sense. I come today to talk about this because I feel that my words are important because I'm my Ohana. And I want all you guys to know this. Our people, you guys, our family, we all Ohana in Hawaii nowadays. Do not look at see, I'm a solution kind of guy. First, I want to see who's involved with the people. Miloli. That's the last village, fishing village. We're going to keep it original. We're going to take the city back to the city. We're going to keep the country country. We're going to keep the people happy. We're going to love the people. Until these people say yes, then we can make decision. But always the people first. My family and Miloli. I love all you guys. Aloha, Jonathan Omanau.
Thank you so much, Jonathan. Do I have anybody else from Hawaii Island who's traveling? Okay. All right, Leimana, you've been having your hand up.
Thank you, Chair. Aloha to all of you. My name is Leimana Damate. I'm from the Ahupua'a of Kahuku, Moku of Ka'u, Moku o Ke'awe, Island of Hawaii. I work and live here on Oahu because I'm also the Luna Alaka'i for the Hawaii State Ahamoku. What I'd like to bring forward, the testimony that our state chair gave, I stand on that. But what I would like to bring forward is that I've been receiving phone calls from every single po'o in the Pai'aina, from the 8 islands, in regards to this issue. They, in turn, checked with all of their moku. So now you're talking about 8 islands, 46 moku within the Pai'aina, 606 ahupua'a. And they're telling me, all 8 of them, is that they wanted to make sure that Ahamoku opposed this issue. It is not the right time. The scientific work that DAR has done is excellent, but it does not focus on the heartbeat of the Hawaiian people, which is their home, their ocean, their fish. That's what they live in, what they live for. What they asked me to bring forward, so that's why I have nothing to read from, is that they will continue to malama their fish in every single island and hope and believe that the land board will do the right thing in protecting their aina and their livelihoods and their culture. Thank you.
Thank you very much, Leimana. Do I have any, let's see. Do I have anybody else here who would like to provide a comment on K2? Yes, F2, I'm sorry, F2. Oh, so sorry.
Long day.
It has been indeed.
She never wake up at 4 o'clock.
Aloha Chair
Aloha.
Chang, members of the board. My name's Kavika Ruddle. I'm representing the Ruddle Ohana, direct descendants of the Pu'uko area of the island of Hawaii, not Miloli'i. I respectfully ask that you do not approve the public hearing at this time. This brings us to sort of institutional betrayal of public trust is what I feel. What began as a community-led petition to ban commercial aquarium collecting statewide, which this board unanimously approved, has been turned upside down. Instead of protecting reef life that, as intended, DAR's draft rules give the aquarium trade everything they want and would allow the capture of hundreds of thousands of reef fish every year. This is a profound betrayal of the communities who have worked for decades to protect Hawaii's reefs. The fiscal responsibility, which you sort of touched on, Chair, and this is just some numbers that we kind of came up with, but you know, the estimated revenue permit is about $700 per year, right? That the DAR would bring in for aquarium collectors. The estimated management cost, excluding enforcement, between $300,000 and $500,000 that we as tax people would pay, right? The state would lose hundreds of thousands of dollars annually to subsidize a handful of collectors who profit by removing our public trust resource. Meanwhile, Hawaii's tourism industry, which depends on vibrant fish-filled reefs, generates billions of dollars and supports thousands of families, including mine. So in closing, I just ask that you not approve the public hearings at this time and require them to redraft the rules. Thank you.
Thank you very much. Anyone else here who would like, yeah, please come on up.
Good afternoon, board.
Good afternoon.
Randy Gates. I'll be the lone voice of support. Before I start my 2 minutes, Mr. Ewan asked a really important question earlier about what can we give back to the resource? So Mr. Ewan, if you want the answer to that, after my testimony, you can ask that question. I'm in support of sustainable fisheries. I have been for over 40 years. And I'm here today, this fishery is clearly demonstrated that it is sustainable. The most endangered species that I see, and I'm on the water every day, is the fisherman and fisherwoman. It's not the resource. And believe me, my job is being in the water. I have two concerns about the rules, and I do support them going forward. The first one is, and the most important one is, there's a provision in there which basically requires that these divers dive by themselves. And I wholeheartedly object to that. I've expressed my concerns to Don and the DAR, not create a system that puts people's lives in danger. And I want to share with you one quick, just to exemplify that. I have a job for the past year removing invasive species at Pearl Harbor. I've been running a boat 6 days a week, 8 divers. And several months ago, I had one diver, 23 years old, had some discomfort, and on his first dive, within a minute's time, was unable to get to the surface. And we had to pull him out of the water, get him up, and it was a kidney stone. In 40 years of diving, I never had a young kid experience that. And that just showed me the importance of having the buddy system. So I really think the board needs to think about that provision. And we have a total allowable catch. That should allow that permit holder to have a safety diver at minimum in the water. With that, I'll take any questions.
Thank you very much, Randy. Anybody else in the boardroom, Mahesh?
You again, Chair and board members, Mahesh Cleveland, with the original rulemaking petitioner, Hui. I just want to, I was there in December of 2025, many, most of us were. This board made a decision. The board qualified its decision, but what the board said was, we're going to approve this petition for rulemaking to prohibit commercial aquarium collection, taking into consideration the rulemaking petition, the sentiments expressed, you've heard from the board. I mean, these are direct quotes. The sentiments of the board, which had just unanimously approved a rulemaking petition to prohibit aquarium collection, and applicable statutes. Okay, so we didn't necessarily agree that there was a conflict between a prohibitory rule and the statute, as you folks did, and as you probably know, we're going to be resolving that in court. But what this board never said was, Dar, go back and craft a rule based almost entirely on the collector's EIS. So the bottom line is that the rules that DAR has put before you today have no basis in any instruction that was given by this board. The board said to consider the rulemaking petition, to consider the sentiments of the board, to consider the public testimony, and to consider the applicable statutes. And what they've given you instead is a rule that gives the commercial collectors 99% of everything they wanted in their EIS, including the full complement of yellow tangs, all of these other, they reduced some of the quotas sort of nominally, but it's generally everything that the industry wanted in this rule. And so we reiterate our strong opposition to this version of the rules and ask that the board send the rules back for revisions to bring them in line with this board's prior decisions and instructions. Thank you.
Thank you very much. Do you have anybody else in the boardroom that wants to make a comment?
Chair, members of the board, Wayne Snako, Circle Bahoy. We strongly urge you to not move forward with this rulemaking proposal. We applaud you for your earlier decision, as Mr. Cleveland pointed out, that would, that directed our staff to come up with rules that would essentially prohibit aquarium collection. And just urge you to stick to your guns and not let DAR staff kind of run you around that in this process. I did want to add a couple of things to written testimony. You may have heard, we've hit a tipping point with our coral reefs, right? Our coral reefs are dying. The dominoes are falling, and this planet is going to drastically transform unless we do something about it, right? And so that raises two issues for me. Like, one is, how did we get here? And you look at the international community, what they've been saying, look at what people here have been saying. It's because we've abandoned indigenous ways of knowing and relating to the planet, to the land, and to each other. And we've adopted this extractive, exploitative Western economic approach that incentivizes the plundering of the earth, right? And so that's why, again, I really applaud you for your decision earlier to pivot us away from this idea of reef fish being something like swimming dollar bills that we can just take away and send to the continent to make a quick buck. The other thing that brings to mind is that we need to triple down on management, on actual protection of this resource that is ever more fragile, right? And we didn't do it 20 years ago, but essentially what we're looking at now is a proposal to move forward with a rulemaking process that's going to take multiple public hearings, likely thousands of testimonies, hours and hours and hours and hours of staff time, just to get through that process. And it's going to come back to the board here as part of this record review. And then to administer this, as the senator pointed out, is going to also cost tremendous amounts of resources, staff time, capacity that should be dedicated towards supporting the communities that are waiting in the wings to engage in poultry grounded indigenous resource stewardship management. And so I urge you to again, reject this rulemaking proposal and instead instruct DAR to put its resources where it's needed, which is in protection and management.
Thank you very much,
Chair,
Mr.
Sorry, Chair. Wayne, is that Wayne? Wayne?
Yeah.
Wayne,
Sorry.
and then Chair, I got a heli after this. I apologize, Chair, but I'm gonna be excusing myself after this kind of question. Wayne and Mahesh, am I hearing you guys correctly? Like, for lack of better words, you prefer it go back to DAR and DAR create a quote unquote more perfect template for the public to react to. Is that kind of what I'm hearing?
What we want, Member Yoon, is for DLNR to send this rule back to DAR to propose a rules package that matches with what the board told them to do in the end of 2023, which was to craft a rule based on the rulemaking petition, the sentiments of the board, and the applicable statutes.
Okay, so you guys don't think that this, so let's say let's walk this out. So we go out, let's say the board approves and we walk this out for public comment. You don't think your Manao and other Manao would help massage and lomi the rules so that we come and arrive to a place that's pono?
I'm not sure that public hearings on this rules package is an appropriate place for the community to have to negotiate for their constitutional rights. I think that the department needs to send out a rule that already addresses those concerns and then let the public comment, because how often does a rule go out for public hearing and then end up being substantially amended before it's finalized? It's pretty rare. Usually what happens is that the board will send the rule back for revisions and further drafting, like what happened with, I think it was the Pakuikui or herbivore rules, to revise the rules and get them ready for public hearing, rather than making the community again negotiate for their rights during a rulemaking hearing.
Okay, I suspected that's where you're coming from. Okay, all right, just for the record. Okay, mahalo, guys. Thank you, Chair.
Thank you. Do I have any additional comments before I take the?
How's it, everybody?
Was it?
My name is Kevin Chang. I'm gonna do two things. One is speak for my organization, Kuaina Ulu Awamo. We're very proud to be here with all the folks here that really played a role in the creation of our work. Most of the folks in this room flew here on their own dime and at expense more than the permit that you guys are proposing to have. And then just like, I guess speaking for myself, I'm from a place called Kahalu, near Heia as well. And I feel like the question today really is for your guys' consideration is, what does the prudent konohiki do? What does the prudent trustee do? As Kua was a part of that effort to create this green fee. And when they created that green fee, they did a study, found out that we fall about $560 million short of caring for our environment. And now we're telling somebody at the amount of $100, they have access to a $20 to $50 million market to send our stuff outside of Hawaii. We're already sending our community out of Hawaii. So I think as prudent trustees, I agree with Mr. Cates that if the state is encouraging unsafe activity, the state needs to relook at that. But we also need to look at the cost of the enforcement. If we're charging $100 a permit, but it costs us $500,000 a year to enforce and manage, I don't think the prudent trustee or the prudent konohiki would take that into consideration. And I think the prudent konohiki today really is the initiative of our communities, who many of you are here today, to become and share power with the state in managing and collaborating, a collaborative spirit of taking care of our resources instead of having to go around them. Like even though we call this a statewide permit thing, I really feel like we're targeting West Hawaii right now because of how hard this community has fought to hold this back. So,
Thank you very much, Kevin. Do I have anybody else in the boardroom that would like to make a comment? Oh, yes, please come on up.
Aloha,
Aloha.
Chair and members. I just wanted to say something like.
Could you introduce yourself first?
My name is Jody Kalana.
Okay.
I'm the daughter of Buffalo Kalana.
Okay.
I just wanted to just say something about growing up. So growing up, we was a poor family. Yeah, my dad made $80 a month working as a pot keeper. But we had 5 of us, but because of the fish in the ocean, yeah, we ate. And because my mom is an amazing cook, we never know that. Oh, we had a good life, but we ate lobster, fish, turtle. My mom made turtle so ono, like wow, you know, like no, for real, you know. But so what I'm trying to get at is we didn't survive all that. My mom and dad raised all of us on fish. We ate, you know. My dad never made money with the fish. That was our refrigerator, because that $80 went to the rent that we was, that's how much our rent was, right? So all I'm saying is the people, Uncle Willie them, they don't want jobs over there. You guys, the ocean is vast, man. Come on. Go someplace else. Leave us Kanakas alone, man. Come on. You know, if we don't, and if nobody gonna hear us out, yeah, our culture gonna be gone. And then what is Hawaii without Hawaiians? Nothing, right?
Amen.
Right?
Amen.
Nothing. So I just pray in my heart. that You guys do the right thing. You know, amen.
Pressure. Thank you for taking the time. Is there anybody else in the boardroom here? Yes, please come on up.
I usually pay $98 a month.
All right. Aloha, Chair Chang and members of the board. My name is Alohi Nakachi, and I was born and raised in Mokuokeawe. Today, I'm asking the board to send back the rule package set forth by DAR for redrafting and not go to public hearing. I've been attending meetings and hearings on the aquarium trade since I was 5. I'm here today, decades later, still fighting on this issue. I now hold a PhD in natural resources and environmental management from UH Manoa. And I continued in education and pursued this degree because I have long felt that Native Hawaiian values and knowledge have not been well included or acknowledged in management. And my dissertation focused just on that, on acknowledging Indigenous knowledge and values. I believe the aquarium issue continues to be pervasive and seen year after year because some of the deep roots of the aquarium issue are that Native Hawaiian knowledge and values are not recognized. The aquarium trade is not a pono practice. Being in Hawaii and in Aina, we need to recognize Heali'i ka Aina, He Kauwa ke Kanaka. Aina is the chief and man is its servants. Aina, while commonly understood as land, means that which feeds. Everything that composes Aina, from Vai, Kai, Pohaku, Ia, Kanaka, and all of us, and all others, we must live in reciprocity to feed and be fed. All of us that are in this Aina system are shaped and shapes our collective mo'okuauhau. To support Aina systems and build Aina Mamona, we need to keep Aina of place in place. The collection process of aquarium collection, it has high mortality at each stage of collection. And even if our Ia survive, they're still taken out of Aina. Their mana, their kino are removed and their mo'okuauhau is disrupted. Any practice that does not remain in Aina and support the reciprocal feeding will perpetuate cultural harms and not be okay by Kanaka Maoli. So we must build Aina resilience and keep Aina in Aina, especially as we face increasing and compounding stressors. I'd like to remind the board and DAR that contemporary ecological measures of so-called sustainability and impact only look at a modern baseline from degradation and not Aina Mamona. So let's send the rules back for redrafting and get better Native Hawaiian values and knowledge in this. Mahalo nui.
Thank you and congratulations. Is there anybody else in the room? Yes, please come on up, because I'm going to take a break pretty soon. I think we're ready for one restroom break. I am ready for a restroom break. Please go ahead.
Mahalo, Chair, mahalo, and new board members.
Go ahead, give them, we'll let them go. Oh, okay. Sorry, go ahead.
My name alone will signify that
Actually, this is my family members. My name is Blessing Punahale Kawaula de la Cruz Galinato. I'm also the diplomat of Ko Hawaii Pa'aina, the Kingdom of the Hawaiian Islands. I had a call yesterday from my cousins letting me know what's up with my uncle them. And I was like, oh, how are we gonna go do this? Then I had a call from my husband and saying, oh, you gotta say this, you gotta say that, you gotta say do this. But I came to listen and to hear. And just to remind the board to kindly look in the spiritual way and our cultural ways, not to deplete us as much as like our fishes. And I actually told my husband, no wonder I never have call off for my birthday. Yeah, I fit in the kapuna status. I didn't want to come sit here earlier. So looking at this, I have children that are raised here and they have the bloodline of this Aina. They're not gonna have fishes. They're not gonna have, and I already felt the effect because I didn't have it for my birthday, like I said, certain fish, right? But I do love the aquarium. And my boys, they used to go diving and whatnot. Majority of them is in North Korea, Alaska, Europe, looking at the fishes. There's no fishes around in the world other than here in Hawaii. I'm asking you guys to protect that, to protect the ancient cultural way. Go back. Don't move forward. Go back to the people. Listen to the people. That's all I got to imply.
Thank you so much. Thank you very much. Do I have anybody else in the boardroom that would like to make a comment? Okay, I'm gonna take a 10-minute break. We're gonna come back at 2:35, and then I'm gonna take people on Zoom. Okay?
Chair, before you
Yes.
break, I'm gonna try and call in. I'll be driving, but I'll do my best to try and call in, Chair. After break.
Okay, okay?
Yep.
Yeah. I think so long as we can see you two.
Okay.
Okay, thank you. Okay, we're gonna take a little 10-minute recess. We are back on the record from recess. I'm going to do one final call. Is there anybody else in the boardroom that wants to provide a comment before I go on to Zoom? Okay, I'm going to now open it up for those on Zoom. So we're going to let in 5 people at a time. And then we're going to call 5 names. They're going to be let into the meeting room, and then we're going to take another 5. We have probably got about 30 people in Zoom waiting. Okay, all right. So, Rihanna, do you want to call them, or do you let them in one at a time? Or let's see, I'll just, Maki Moranoi, are you here? Okay. If you can introduce yourself and yeah, go ahead.
Okay. Aloha. My name is Maki Morinoi. I'm a 4th generation from Holualoa on the west side of Hawaii Island, and I'm in strong opposition to agenda item F2. I ask that you do not approve public hearings at this time. These rules are unenforceable, premature, and extremely vague. As a testifier in December 2023, my own eyes on our West Hawaii reef from childhood to today can tell you that all 8 species are barely seen as a healthy level today as it was back in the 70s and 80s. I disagree on the thought that DAR is aligned with DLNR's hierarchy of use policy and Hawaii's public trust doctrine. This industry is commercial exploitation. This AQ fish is an ornamental purpose and not food sustenance. Also, a high percentage of the fish die in transportation. DAR ignored the 2023 petitioner's hui, who clearly requested the removal of kole and umaumale because it is a double take in the fish industry and for its cultural and sustenance value. The yellowtail and potter's angelfish is now being successfully cultivated by the Ocean Institute of HPU. Wild harvest is now unnecessary with these 2 fish when sustainable circular economic solutions already exist. The draft rules are dangerously vague, lack accountability, and contradict the conservation intent of the original petition and DAR's own mission and vision. The 7 permits aren't even defined in the rules. This proposal is fiscally irresponsible with a high annual cost just to manage this industry. Please make rules extremely clear, detailed, and far more stringent. Remove kole, umamaule, yellow tang, potter's angelfish, and endemic fish off the whitelist.
So Maki, I'm sorry, but I'm going to ask you to summarize.
Right, I'm almost done. If DoCare can't manage this, then this industry should not continue. People before profit. Thank you.
Thank you very much, Maki. After Maki, I have, is it Cornell? Cornell?
Oh, Ravenscraft. Yeah.
Is it? Is that right? Okay, go ahead. Introduce yourself.
Hey, hello everybody. Connell Ravenscraft. Good Hawaiian name. Good
Ravens,
Hawaiian
yeah.
name. Sorry, Kahaka'io. I'm from down in Kealakekua, South Kona, Hawaii. I work in community-based conservation management and speaking in unison with community advocates from West Hawaii and across Kapai'aina with deep concern and strong opposition to the dangerously vague and ecologically irresponsible rules that DAR is introducing. And this is not to bash DAR, this is a critique of this whole process to how these rules came forward. DAR, through these rules, so far indicated, disregards and discredits generations of traditional ecological knowledge, and also fails to provide substantial data in support of their position to open West Hawaii waters for aquatic collection. And I say this because I was in a recent conference call with community partners. Many of them are in this room with DAR leadership. And in that meeting, DAR leadership made it quite clear that their data was nothing short of arbitrary if not non-existent at all. They did not conduct their own studies. They were citing other studies. Some of these studies were decades old. And yeah, so not conducive, not substantial to be pushing forward these rules so prematurely. And it was also quite clear that DAR needed to be reminded of their commitment to the DLNR's own principles of hierarchy of use, as
Chanel,
well as
I'm
the
going to
state
ask
of
you to
Hawaii.
summarize. I'm going to ask you to summarize as your time is almost up.
Oh, yes, we're just asking DAR to remember the public trust doctrine and to put the ecological natural resources before commercial motives. Mahalo.
Thank you so much. I have. Is it Kahakulo? Kahakuhailoa? Kahakuhailoa Poi Poi? Kahaku. Okay.
Aloha mai kako, Chairperson, as well as fellow board members. My name is Kaku Hailoa Poi Poi. I come from the island of Molokai, and I stand in firm opposition to agenda item F2, DAR's aquarium fishery permitting rules. And I testify today, standing together with the West Hawaii Native Hawaiian practitioners who have testified before. These rules as proposed fail to reflect Hawaii's cultural, ecological, and legal responsibilities under the public trust doctrine. The aquarium fishery, particularly for ornamental trade, continue to take species that are both ecologically vital and culturally significant. So as an ally, I respectfully urge the BLNR to keep permitting authority with the BLNR to ensure transparency and accountability, send these rules back for redrafting, remove kole, umamale, ma'i'i from the list, as they are important food fish, as well as la'ipala and potter's angelfish, as they are now being successfully cultivated. Add clear and enforceable guidelines for permits, terms, and accountability to prevent abuse and ensure ecological balance. Uphold DLNR's hierarchy of use policy, giving priority to cultural subsistence and ecosystem needs before commercial exploitation. Honor Hawaii's public trust doctrine, which requires DLNR to protect public resources for the benefit of Hawaii's people, not for privatized commercial export, and also to conduct a kapa'akai analysis, the legal framework which ensures that Native Hawaiians have access to the resources. So mahalo nui for the opportunity to testify today. Mahalo.
Thank you very much, Kahaku. Is it Kehau Springer? Go ahead.
Aloha mai kako, chair and members of the board. Mahalo for the opportunity to speak. My name is Kehau Springer. I'm Kanaka Oiwi practitioner and researcher on Nohovao ma Kea'au Mokua Keawe. And I stand on my written testimony that was submitted yesterday and would like to highlight a few key concerns. I'm in strong opposition to the proposed draft rules authorizing commercial aquarium fish collection. These rules do not meet the constitutional, cultural, ecological, or public trust standards that BLNR is required to uphold. First, under the Kapa'akai o Ka'aina ruling, the state must identify and protect Native Hawaiian practices before advancing rules to public hearing. These rules do not address Lawai'a relationships, Konahiki and Ahupua'a systems, or cultural reliance on our reef species. Second, under BLNR's own hierarchy of uses, cultural, subsistence, and ecosystem-based uses take priority over commercial extraction. AQ collection is for-profit, export-based industry, and not a subsistence or cultural practice. And extraction in areas where declines are already documented, it conflicts with our public trust responsibilities. Third, DAR labels the fishery as low risk without an independent stock assessment. The annual catch limits were not derived from scientific sustainability models, but from AQ industry proposals supported by rough population assumptions. This is not true sustainability science, nor does it meet the standards typically used to justify opening a commercial fisheries. Fourth, the rules open the door to quota consolidation, which could privatize access to marine life and exclude our community, our Lavaita, as seen in Aotearoa, where individual transferable quota systems have marginalized indigenous fishers, a concern that was supported and testified by Dr. Fiona McCormack through her written testimony from the University of Waikato. And finally, reopening high-volume extraction contradicts the Holomua Marine Initiative, which commits to restoring abundance through community place-based stewardship. So for these reasons, I respectfully urge you, BLNR, to halt rulemaking in its current form, require a full Kapa'akaya compliance before going into Chapter 91, align with the hierarchy of use and public trust doctrine, and base any annual catch limits on independent stockus science, not industry proposals, and redraft the rules with the 2023 petitioner Hui, Docare, Native Hawaiian lineal descendants, and community members. Mahalo Dar and BLNR for all of your time and efforts. I stand here with aloha. Our reefs are not ornaments. They are our ancestors, our kupuna.
Okay,
our...
I'm sorry. Yeah.
Mahalo.
Your
Ua
time.
mau ke o kai nei kapono. Mahalo.
Thank you very much. So, can you bring in the next group? Who is that? Nick? Oh, Nick, sorry. Nick, go ahead. If you can unmute yourself, Nick?
Can you hear me?
Yes, we can hear you now.
Okay. Hi, landlord. This is Nick. I'm an aquarium fisherman on the Big Island. I'm in support of reopening the fishery with the new rules that have been proposed. I don't want to state all of the good information as to why the fishery has been sustainable, but this aquarium fishery has been open for decades and it's been proven to be sustainable. So I'm confident that the future of the fishery will be sustainable as well.
Thank you very much, Nick. Jeff Davis?
Thank you. I'm still hearing the last speaker.
Oh, sorry.
We don't hear the last speaker.
Yeah, he's on
You
YouTube.
need, you need to turn off your YouTube, Jeff. That's why you have an echo.
That's a good point. Thank you.
Thank you.
Thank
Go
you,
ahead.
Chair Chang and members of the board. I know a few of you are new, but the fishers have been effectively banned from aquarium collection for half a decade, and in West Hawaii for years longer. They have an approved EIS. It's been all the way, it's been through the board, it's been through the circuit court, it's been to the Supreme Court. The complaints that the EIS is insufficient, it's just, you know, that ship sailed a long time ago. The board has acknowledged that it does not have the power to ban the fishery and that it will be guided by science in making these management decisions. The Supreme Court's emphasized many times that the science has to guide these decisions. And the science here, the DRR representatives have discussed it with you. The science here is that fishing at these numbers is completely sustainable, that it's very low risk, and that it will be the most heavily managed fishery in the state. Nobody's talking about any of the other fisheries. This fishery would be the most heavily managed fishery in the state. Many of the people speaking in opposition are effectively saying ban the fishery or restrict it so far that it's an effective ban. The yellow tang, the reduction of the yellow tang, for instance, that's most of the fish. It's almost all of the economic prospects for the fishers. The fishers are being demonized for all kinds of problems people have. The reality is these fishers are Hawaii citizens. They want to make a living. Not being able to fish is taking food off their table and out of their kids' mouths. And I don't hear anybody talking about that. The petition is in fact in line with the board's decision a couple of years ago. We didn't like it. We had a F1 was about that, but the board and the chair specifically said at the time that petition the vote was taken, that the vote was not to adopt a ban on fishing. The vote was to go to rulemaking in line with the law, and that the law said the board can't ban aquarium fishing. That's all that this rule does. This is not an industry, and I know my time just hit 2 minutes, Chair Chang, but you let a few people go to 3 minutes arguing against, so I'd like a few more.
I'm going to give you 20 more seconds. I'll give you 20 more seconds.
This proposal is not an industry proposal. The EIS voluntarily restricted the number of species dramatically, largely because of cultural views. The Achilles tang was removed. It was an important economic fish, and it was removed for cultural reasons. The board is being asked to further reduce the species and further restrict this. These rules need to move forward, and this process has to get completed. It's been far too long already.
All right, thank you, Mr. Davis.
Thank you.
Kaimi Kalpiko?
Aloha. I hope you can hear me.
We can.
Oh, mahalo. I just wanted to come on and speak in opposition of the proposal. I'm happy the Ohana is there. I'm from Iloli'i. I'm happy my dad's there. One of the most important things that we have achieved in the last 5 years is becoming the third community to co-manage our Miloli'i community-based subsistence fishing area. And with all of that kuleana, we have seen a lot of the responsibilities continue to be on the backs of our work that we have done and we continue to do. Just the other night, we have again, people coming and taking our resources. This is happening as we speak, and we are adamantly trying to enforce our Makai Watch to take active roles as we see them taking. It might not be collectors, but we just wanted to, share with you, board chair, about the current state as we tackle on this kuleana and probably try to co-manage. But I wanted to add, with everything else everybody said in opposition, that we have fought for many, many years in the courtrooms, in our own waters, to see and protect what little we have left. And we have stood beside many of our West Hawaii communities, filing petitions, testifying, and working to ensure that our reefs and fisheries are managed for the public good and not for private profit. So if you continue to allow them to public hearing, we're going to go down the same route, and we will undo the years of work and that we have done to protect and continue our work towards fighting for our community and our West Hawaii coast and other communities that are following in behind us. So I just respectfully ask that you continue to keep permitting authority with the board, send the rules back to be redraft and to listen to our petitioners hui, remove the kole and omaumale, and of course, ensure that the rules are truly aligned with the DLNR's hierarchy of use public policy and Hawaii public trust doctrine. So I just wanted to share that with you guys. The mahalo again for all the outpouring of support today from our Ohana here. Mahalo.
Thank you very much. Kalani?
Hey, aloha kako, Chair Chang and board
Aloha.
members. Mahalo for the opportunity to testify today on behalf of the Nature Conservancy Hawaii and Palmyra chapter. My name is Kalani Kiocha. I was born and raised on Mokua Keawe, and I serve as the director for TNC's Hawaii Island Marine Program. TNC works closely with dozens of communities and individuals leading community-based makai management efforts across West Hawaii and Hawaiʻi. We carry kuleana for the places where we work and to the people and communities we work alongside, including those directly impacted by and continuing to raise concerns about the effects of the aquarium trade on their livelihoods, culture, and ways of life. While DAR's proposed rules and the request to advance them to public hearing represent a step in the process toward resolving these long-standing issues, we strongly believe this step comes prematurely. To create rules that truly balance science, cultural values, and community needs, we respectfully recommend that the board consider the following process improvements. 1, conduct community scoping meetings prior to advancing for public hearing through multiple meetings in West Hawaii and statewide. 2, complete the Kapa'akai analysis prior to public hearing approval so the state can evaluate whether it has fulfilled its constitutional obligation to preserve and protect traditional and customary practices. 3, proposed rules should better align with Hawaii's public trust doctrine and previous board directives, including the 1998 hierarchy of use prioritizing first, natural resources and cultural resource protection, second, general public use, and third, commercial activities only if it does not conflict with either resource protection or public use. These process improvements will help to address concerns and ensure that the final rules better reflect the values of Hawaii, the integrity of Hawaii's ecosystems, and the intent of the DLNR's public trust mission. Mahalo for the opportunity to testify and for your continued commitment to meaningful community-based resource management. Ua mau ke au ka aina I ka pono. Aloha.
Aloha. Thank you very much, Alana. Jim Lovell.
Yeah, aloha, board chair. Board members, thanks for letting us testify today. My name is Jim Lovell. I'm a fisherman here in Kona. I'm in full support of F2. I know that everyone is very emotional about this and everyone has a right to their feelings and it supports everyone's right to that. But with all due respect, there's a lot of testimony here that, I just really want to point some things out. It's just so frustrating that we can never move forward on anything on this. People have talked about there's been no opportunity to give input. We've been holding these meetings now for over 8 years since the closure. Testimony is still the same. There's been years to have input. So there's been plenty of chance for people to come and speak in their mind. We heard a lot about Milili'i today. I was always in full support of everyone, what they said in Milili'i. As a matter of fact, we had a holding station there that actually employed people in Milili'i, to give them jobs. That station obviously is not there. But we agreed to close that area 25 years ago now. And with the addition of the recent additions, it's over 20 miles around the Milili'i are closed in order to, support, that. Hokena is another one. We closed that in 2000. That was 25 years ago. We closed Puako in 1985. That was 45 years ago. I was here when we did that. I know a lot of people aren't even alive at this point still. We weren't alive then. Anyway, respectfully, we've addressed these concerns and we've come up with solutions. Remember, the females, they lay 1 million eggs a year. There's over 1 million of them. And it's tens of thousands of fry that hit the reef. 83% die in the first year, 99% never reach adult life. So, this is the reason why we don't have an impact on the resource. We're taking a resource that's not even going to be around next year. I heard another comment, 90% of the fish die. None of them die. We had someone that actually went out to prove this a few years ago and I'll summarize, did a 2-year study and not a single fish died in the 2 years from the time it was collected till the time 2 years later in the fish. So we're talking 1 fisherman per day and 150 miles of coastline. This is not huge. If you want me to go out and catch hundreds of pounds of koli, as opposed to.
So Mr. Lovell, could you please summarize? Your time is up.
If that's what is better for the resource, and that's what we'll do. Thank you for your time.
Thank you very much. Billy Kenny?
Chair, what was his position?
He supports the rule. He's an AQ fisherman.
Thank you.
Billy Kenny?
Aloha, Chair.
Aloha.
Board members. For the record, Billy Kini, come from Hanalei, Kauai. I'm the Assistant Director of the Hui Maka'ainana o Makana in Ha'ena. As some of you know, Hui Maka'ainana is a lineal descendant group, a nonprofit. We steward Ha'ena State Park as well as our fisheries. We were the first CBSFA with a rules package management plan in 2015, working with the state and various agencies since the late 90s. We strongly oppose the rules as proposed, and we also strongly urge the board to not allow DAR to proceed to public hearing, as public hearing is not a place to gain clarity, as Ha'ena knows that very well. It's not a place to also build integrity of a rules package. You should go into a public hearing process with integrity and with clarity. we stand on a written testimony that I've submitted with specific concerns and comments on species. So I won't iterate, but I'll highlight co-management real quickly. I would like to encourage this board to have DART initiate an analysis process probably immediately through community co-management, be it collaborating through Kapakai or a public trust analysis, and to assess the enforceability with DoCare, with DOBOR, and with the community Makai watches prior to public hearing, of course. The Mauka to Makai model, the Mauka Makai model that Chair Chang mentioned earlier today, that this board is guided by is really a model that is based on balance, bringing balance to the land, to the sea, and to governance, right? I've heard conflicting risk assessments here today. Low risk, low impact, no risk, no impact. I'm not sure which it is. But I will say that I know that those assessments are not based on sustainability science. So to repeat what Kaiwi said is, what is the industry going to do for us? And are we going to depend on community-based management areas like Miloli'i and Kaupulehu to mitigate those impacts and put those industries on their backs again, right? And so when we approach this topic, I want DAR to and other government agencies to take Mauka to Makai seriously and lean into this model of balance, because Mauka to Makai is not a
So
metaphor.
Billy, I'm sorry, your time is up.
I'm Paul. Mahalo,
Okay,
Chair Chang.
thank you so much, Billy.
Aloha no.
Aloha. I have Robert Winter. Oh, sorry, you're on mute. If you can unmute yourself. You're still on mute. There you go.
There you go.
Go ahead. You're on unmute.
Aloha, I'm Robert Wintner for Snorkel Bob's Hawaii. What do we perpetuate in righteousness is trafficking in reef wildlife pono, chains and anchors on coral. 90% mortality within a year is what the aquarium trade calls sustainable for business. The aquarium trade is not pono. Who owns Hawaii reefs? Who does DAR work for? DAR never defines sustainable. Hawaii people cringe on the aquarium trade. DLNR scoffed Supreme Court injunctive relief, saying no aquarium permits required. Pono? Hawaii is cultural. DAR is not in the heart of Hawaii. We had public hearings. Should you go see aquarium hunters in action? I've been. DAR has a history of warning collectors when enforcement is on the way. Can DAR go to the ramp to enforce reporting and high-value species poaching? What's the budget on this? Does cost exceed revenue? Does this betray the public reef trust? Here's a news item from the Associated Press in 2010. State lawmaker opposes aquarium collecting. Democratic Rep. Josh Green from the Big Island will introduce a bill to ban aquarium collecting in Hawaii. Green says the law is needed because reef wildlife in Big Island and Maui waters has decreased. He says it's time to restore the Gold Coast, as West Hawaii was known for yellow tangs. Aquarium collectors call the move politically motivated and uneducated, extreme and not warranted. Rep. Green changed his bill to describe buoy markers and night lights in gibberish. Kona DAR got to him on the money side. Follow the money. Good luck. Robert Wintner, Snorkel Bob's Hawaii.
I'm going to now take, I see the first Rob. I don't know if you're there twice. Rob, you can unmute yourself and introduce yourself.
Okay, can you hear me now, Chair?
Yes, we can.
Okay, my name is Rob Culbertson from the Big Island also.
Go ahead. Oh, you just muted yourself. Can you unmute yourself?
Okay, trying again. Can you hear me now?
Yes. Yes, we can hear you.
Okay. Like many gathered here, I am profoundly dismayed by the perverse turn of events in the DAR proposal. Good faith in working for the public interest has clearly been broken by DAR. Members should ask themselves why. We are realizing is that DAR intends a reboot of the prior AQ industry-driven program, despite the most recent community-based petitioners initiative. But it goes even further this time in its affront to the public trust responsibility they and you all hold. Now they want to usurp the board's authority and make rules internally. So first and foremost, they must not be allowed to rewrite the administrative rules and duck out of public accountability before and with this board. I will leave others to cite the compound cultural, ecological, and ethical problems we all clearly see, but I ask your attention on just one aspect of the entire enterprise that looms so large it may be taken for granted. I'm speaking of the inherent financial inequity and burden imposed on us, the tax-paying public. DAR's devotion to the industry's solvency has for decades committed the public to a worst-in-kind accounting scam, albeit theft of public resources, both natural and financial. For the mere price of $100, a single collector could receive a license and right to operate as a commercial collector of aquarium fish, a substantially unsupervised business with virtually unlimited take potential. Meanwhile, the financial burden for administration, monitoring, and enforcement amounted to millions of dollars in public expense to both our state and federal agencies. What a boondoggle.
So Rob, your time is up. I just want to clarify for the record, you are opposed to the rules?
Yes, and I stand on my written testimony in which
Very good.
I cite the cost benefit analysis that
Thank you
makes
so
very,
much.
very clear.
Okay, thank you so much. So are you the same, is that the same Rob? I got two Robs.
I don't know which, I started early this morning and then I chimed in after various breaks to see, so I'm the only
So
one.
I'm assuming,
From the
well,
Big
I'm
Island. Mahalo.
assuming you're the same one. Okay. Kim Cock?
Thanks, Chair. You guys have stated many times the board reads testimony. All of these issues have been addressed, listened to, mitigation has been offered. No aquarium fishing has happened in all of these cultural villages up and down the West Hawaii coast in over 25 years. They have exclusive areas. So at some point, you've got to wonder, is there a reasonable solution? And I think based on the last board meeting, we realized that's not true. They will stop until there's zero fishing. And we need to look at the science. The science, in the past, this board approved 30,000 pounds of commercial uhu and 15,000 pounds of kala. For perspective, this entire proposal is less than 350 pounds per fisherman per year. That's less than a pound a day, assuming the entire quota is fulfilled. Can these Hawaiian citizens not have a right to a pound a day? A yellow tang within the current rules in West Hawaii's size limit is 5 grams or less. When you view fisheries, you need to analyze biomass. This is the amount of biomass. This amount of biomass is as minimal as a fishery could possibly be. If you imagine snowfall, not all of it sticks and can be measured. This fishery is catching the snow, and it does not affect the amount of fish on the reefs because they are at a transitional phase of settlement. DAR's proposal is 2,500 pounds compared to other commercial fisheries this board has approved with minimal impact, minimal data, no scientific understanding, no EIS, and it's all measured in tons. I think if we want to analyze fisheries like a lot of the testimony has said today, I think you need to apply it to all. They don't seem to like commercial fisheries, so maybe implement no commercial fishing. I mean, where does it stop and where does it start? We're all citizens of Hawaii. We all have rights, and you cannot continue to discriminate and prejudiciously apply standards to certain groups of people. And I ask you to pass this today, realize the process, realize that we can't fly over because we're out of work, yet they can continue to laugh and enjoy the testimony and continue to fly over
So,
people
Kim,
and do
your time
lunch.
is up. Your time
Thank
is
you.
up.
Sorry, it's frustrating.
Thank you very much. Do I have anyone else on Zoom that I have not called? Okay, seeing none.
And Renee Umberger and Elena Bryant should be
Oh,
on Zoom.
oh, Gail. Okay, Gail. Gail Grabowski, go ahead.
That was the C2C.
Oh, that was a C2. Oh, okay.
Oh, Gail, right there.
Chair Chang, can I speak? I'm C2C.
Yeah, go ahead. If you can introduce yourself.
Oh, okay. Good afternoon, Chair Chang and the board. My name's Todd Shiraki. Can you guys see me?
Yes,
No.
also me. Thank you.
Okay, I'm just gonna keep going.
Yep.
Okay, sorry I couldn't be there in person today, but I would just like to give recognition where it's due. I think DAR did a fantastic job. So much so, I think board member Kaivi almost saw the light there for a second. I respect my kupuna, Uncle Willie, Uncle Damien's there, Uncle Mike, but the areas they're saying that no more fish, this is their ahupua. This is right in front of their homes. These areas, if you look at Dar's slide from earlier, these are FRAs. They haven't been touched by the AQ fishery in decades. So if no more fish, something must be wrong, and they shouldn't be blaming the AQ because they haven't been in there for decades. As for Uncle Mike, he said, hey, we go try wait. Hey, whatever happened to the Kapulehu? We try wait. Where's the information on that? We wait 10 years already, and we still don't have any good information. So with that, I'm in support of pushing through F2. I'm in support of it. Thank you.
Okay. Thank you. Gail Grabowski.
Yes. Hi. Aloha. Chair Chang and Land Board. It's my pleasure to speak with you today. I speak in opposition. For two reasons. The first one is a moral argument, which is it's always fascinated me that the food fishers and the aquarium fishers seem to support each other because the first is a need. We need food fish. This is a want. Years ago, someone argued that it was a vanity, and that's always stuck in my mind. Oh, by the way, I should say I'm at Chaminade. I'm the dean of the School of Natural Sciences and Math, and I run a United Nations Center, and I've been following this issue for many, many years. At the moral level, in this time of climate change with these herbivorous fish, if the science is done right, it could be sustainable. So I would like this to go back because the numbers that have been proposed are over the top. They're a limit that isn't a limit. And so last meeting years ago, I had said that I had been on the advisory council for Papahanaumokuakea, and one of our mottos was everything is prohibited unless permitted. I would be for permitting the extraction of introduced and alien fish species, but for leaving the rest on the reef or doing some real rules through very vigorous scientific study. And last thing I'd like to say is that Chaminade has a United Nations Center, and you guys may be familiar with the Sustainable Development Goals and the Aloha Plus Challenge. And Goal 14 is life below water, and all the UN goals have a target. And one of the targets in that goal is that we need to sustainably manage and protect marine coastal ecosystems to avoid adverse impacts, including strengthening their resilience and taking action for restoration. I'd like to thank the board for doing just that by taking this issue so seriously. Do we really need these fish to be removed in numbers that could do harm? And I'd say the answer is no. Thank you so much for your consideration.
Thank you very much, Gail. Keikoa, go ahead. Unmute yourself.
Okay, call on my house train. Not too familiar with this kind of electronics. So, aloha mai kako. My name is Keikoa ulit. Kanaka Maoli here from Kona, Hawaii. I'm here to testify in strong opposition for the marine aquarium fisheries. I'd like you to know I'm not a hupua coordinator here for Hui Aloha Kiholo on the west side of the Big Island. I was also an aquarium fisher myself. I would help my cousin from the mid to late 80s, all the way up into the 90s. We were realizing with the pakukui, the kole, the umamale depleting. As I got older, as we got more in tune with what was going on ecologically, it's unsustainable. Also looking at the impacts of, maybe we don't eat some of these fish that are out there, but they are predatory. There are predators that eat those fish, and it's going to impact those fish. I would love to see the Pa'akai analysis on this agenda item. Again, I am in opposition of agenda item F2. I would love to see a lot more studies around what that would do for the impacts of our environment, our fishes. I appreciate your time. Mahalo nui loa. I would also like to note that, the money was really good. It was. My cousin was buying new trucks all the time. And like what the impacts were, it's we cannot continue that way. So the money may be good and all, but it's not worth it. Definitely not worth it. We gotta take care and be great stewards. So again, mahalo for your time. Aloha.
Thank you very much, Kekoa. I'm going to take Ron Tubbs. No, he just F1.
Aloha, board and chair. Thank you so much for your time on this. I'd like to start with, I'm hearing a lot of testimony that's anecdotal, and I realize the aquarium fishery desperately needs to educate a lot of Hawaiians. 10% of the fishery is statistically Hawaiian. A lot of my friends Hawaiian that worked with me packing the fish too, so that's even greater number. They've lost their jobs. They can't afford to pay into the $600,000 that's taken to get us to this point. As far as money is concerned, I think Earth Justice and its overreach on a sustainable fishery has cost the state hundreds of, well, I know several millions of dollars in paying their legal fees. Also, I'd like to point out that we've spent since 2017, 2 EISs, 2 cultural assessments. That's a lot of input. Hawaiian cultural importance has been greatly studied and has been incorporated already in the EIS. We do not take larger fish. We don't touch the fish that are used for eating purposes. In a study, the 2025 and 2020 West Hawaii fishery report by DAR for the legislature stated there was no difference in the fishing areas for aquarium purposes versus the open areas in eating fish. So science is not being quoted here. It is actually being perverted. So why are they perverting science? Because all they have is the cultural. The science is very strong. The gold standard for fishery management is fish counts.
So Mr. Tubbs, I'm sorry, your time is up.
Okay, so please pass this, follow the science, read the science. And yeah, I know that some of the testimony wasn't read because board members are not quoting or understanding what's in that testimony regarding the science. Thank you so much for your time. And I know it's complicated. God bless.
Okay, I'm going to now take Elena Bryant.
Velina Maike Aloha, Chair Chang and members of the board, Ea au Elena Bryant, He Kupa au no Ka'aina Aloha o Ko'olau Poko, and I'm testifying today on behalf of rulemaking petitioner Ko'olau Poko Hawaiian Civic Club. Like other club members, I come from generations of Lawai'a, both subsistence-based and commercial food fishers, and we strongly oppose the proposed rules. In addition to a variety of concerns regarding the rules for permit issuance, terms and conditions, whitelist species, and catch limits, and the lack of a Kapa'akai analysis, we also share the concerns made early on on by Chair Chang and board members Yoon and Smith regarding enforcement, administrative costs to regulate this fishery, and lack of any mechanism for this trade to give back to the public trust resources it's attempting to monetize. Chair Chang, you noted that these rules should take into consideration all perspectives, and it's extremely clear that these rules are completely tailored to the asks of the collectors and do not take into consideration our rulemaking petition or our community and cultural values. The rulemaking petitioners were guaranteed by DAR staff that we'd have the opportunity to review and give feedback on the rules before it was presented to the board to go to public hearing. DAR reached out and met with us a little over 2 weeks ago, and it quickly became apparent to us that it was simply a box-checking exercise. While the petitioners maintain our position that the rules can and should ban commercial AQ, we also made many make-sense proposals to strengthen the rules, such as removing from the whitelist those fish species that are actively being farmed, removing food fish, and to allow the collection of invasives. The response we got from DAR staff was, and I quote, "The collectors don't want to collect that." And with all due respect, I think that speaks volumes to how DAR proceeded in drafting these proposed rules. DAR staff also shared that they had worked closely with the collectors to come up with this rules package because they're the fishery being regulated, and the same courtesy should have been extended to the community because it's our public trust resources that the collectors seek to extract for personal profit. Instead, DAR staff informed us that it wasn't willing to negotiate or change the draft rules to take into consideration any community feedback before coming to the board. For these reasons, the Ko'olaupoko Hawaiian Civic Club urges this board to send these rules back to the drawing board. It's not this board's kuleana to cater to the desires of the commercial AQ trade and rubber stamp their asks. It is this board's kuleana to protect and manage our public trust resources for present and future generations, and these rules should reflect that heavy kuleana. We strongly urge this board to reject DAR's request for approval to hold public hearings on these rules and require DAR staff to work with community stakeholders in an
Elena?
actual and meaningful iterative process. Thank you.
Thank you. So I am now going to take Kai Kok.
Hello, can you hear me?
Yes.
My name is Kai Koch. I'm 21 years old. I live on Kau on the Big Island of Hawaii. I come up from a family of fishermen and aquarium collecting as part of that. This is the most managed fishery in the state, and the science has been proven that it is sustainable. You know, my life's been very difficult, and many other families' lives have also been affected since you guys have shut down the fishery. I've had to make some very tough life choices and sacrifices to help support my family since then. And being in Kau especially, it's difficult. Being so far away from everything, I hope you would make the right choice today and reopen the fishery. This would help not only my family, but many other families too. I am in complete support of reopening the fishery and the staff recommendations. Thank you, Chair and Board.
Thank you very much. Renee Umberger.
Yes. Aloha Chair and Board members. I'm Renee Umberger, Executive Director of For the Fishes and a 2023 Hui petitioner. With all due respect, our statement that the ACLs will cause no measurable impact reverses 20+ years of its own research. A new analysis of DAR data by an independent scientist shows that yellow tangs have failed to recover on West Hawaii reefs, where the aquarium trade operated until 2017. This is a big deal. They were biologically and historically expected to double in 4 years, just as they did in 2023 after the new FRAs were established and collecting was banned. The trade itself has frequently cited this idea of the doubling. Doubling has not happened in the open areas. It's not even close. Something is wrong on the reefs. Next, DAR's proposal also runs directly counter to overwhelming public sentiment. A recent scientific poll conducted by Anthology Research on Oahu found that 84% of Oahu and Hawaii Islands residents favor a permanent ban on commercial aquarium collection. Importantly, only 10% support the large-scale capture now proposed by DAR. The poll also found, in lieu of a ban, 2/3 favor either prohibiting capture of species available through captive breeding or allowing only the take of non-native introduced species.
So Renee, I'm sorry, your time is up?
I don't see that it's up. I'm sorry.
I know, I'm sorry. We have the clock in front of us, that's why.
I
So
have the clock in Zoom and it says I have 20 seconds left, of which 5 I just used
it's
talking to
25.
you.
You've exceeded the 25.
Oh, jeez.
That's okay. I'm going to give you 10 seconds to wrap it up.
Maui Ocean Center, with decades of experience, reported that 65% of its reef fish died within a year, most within 1 month of captivity. This is a disposable ornamental fish trade that benefits off-island sellers. Thank you. Please send this back.
Thank you very much. Okay. I have Randy Clark. You've been waiting patiently.
Unmute yourself.
Oh, you have to unmute yourself? Go ahead. Yep, unmute. Nope, you have to unmute. Sorry, we still can't hear you.
Okay.
Yep, go ahead.
Okay. So yeah, I'm not Randy Clark. We testified on the last hearing, so his name's on my phone, but my name is Simi McMichael, and I was born in the territory of Hawaii. I'm the president of West Hawaii Surfing Association since 1986, and that is to protect our surf for the keikis of Hawaii and also the natural and cultural resources. I also own the first surf shop since 1978. So now I'm the oldest. I'd like to get firsthand on what our fishing and our fishes are on our waters of West Hawaii, since this is targeted here. I'm seeing less and less fish, and it's not only the fishery, it's also our land and our special management area, the allowing the development. And so our waters are also off Ali'i Drive are still a cesspool, and there are tons of nutrients going into our ocean. Our sewage in Kealakehi are massive. I mean, it needs to be corrected. So our industry here is mainly tourists. The tourists love West Hawaii. They love to snorkel. We're seeing less and less fish here. We need to protect our fishes. And even if you say they don't die while you're capturing them, they will die faster in captivity. I say, stop it. We need to keep our resources. This is not traditional Hawaiian. Hawaiian fishery at one point in time, they were managed. You could only fish so much. This is a small group of people that are going to take millions of fishes from our resource, that they should be left for our tourist industry and for the keiki, the next generation. You leave
Simi,
Hawaii.
Can
Yes.
you? Yes,
Yeah.
your time is up.
Okay, so yeah, leave Hawaii a better place than you found it. We
Okay.
aren't going to live here forever. Leave it alone and malama.
Thank you very much, Simi. I have Ohana Unity Party.
Aloha, Auntie Don Chang, speaking to Shelby Billionaire. How are you? God sent me today. Everyone's there the whole time. I've been waiting this whole time to jump on Zoom. Welcome to New Boards. Luckily, I'm well prepared.
Pikachu.
Yes, I got 5 main points and 6 recommendations. Well, reverse. So I'm opposing this rule F2 because number one, the statewide permit ignores regional diversity. From West Hawaii, you got all the octopus and the special stuff. Number two, you're gonna have an erosion of the West Hawaii protections that everyone fought for decades to do. Number three, the economic hardships are going to be massive for the small scale fisheries and the dealers and the people who are just fishing at home because they're gonna have to compete against commercial people and greed comes in, which is no good. Number four, you're going to neglect the native Hawaiian culture and the values, which is very important, like other people said. Without the Hawaiian people, then you ain't got nothing. I must go to Montana, take all their cattle, and sell it for a gyudon or something. It doesn't make sense because you're going to take away your resources. Number five, you're lacking the robust scientific data, like the other testifier said. It's like hypothesis statement. The fish are disappearing because there's not good enough algae. And if the algae is not there, the fish are going to disappear. If the people are going to capture the fish, they're going to make babies, but you're not like raising the fish in aquaponics. We do it in Waianae High School out of salt water. You can also do it freshwater with kampachi. Number six, this is too premature to push for a public hearing and put all the pressure. I agree with everyone said, and just going to my 5 recommendations. Number one, automatically cancel this proposed rulemaking so you put the pressure off of you guys off the board. You can handle it on the side. Number two, conduct your independent scientific research and charge DAR to do it because it sounds like Darth Vader. Dun, 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 dun. Number three, you got to engage the stakeholders comprehensively like we're doing now. Otherwise, Big Island is rough, just like Molokai. I just can't go grab a boat and fish in Molokai. They're going to shoot me. They're going to sink my boat. And Big Island, everyone got guns. So you got to know what you're doing when you guys go out there because how you going to enforce and management. Number four, you have to incorporate the traditional ecological knowledge and the traditional stuff because we combine aquaponics with the fishery, but who's going to manage it all to make sure it's Pono? And number five, I want you to explore alternative solutions that you can use working with the community and everyone together. Boom, that's my time. Love you all. Yeah, you.
That was speed. That's Pikachu. If I knew that was you, I would have saved you to the last one. Okay, Kimberly Clark. Kimberly Clark? Crawford, I'm sorry. Kimberly Crawford. And then I'm going to take a break pretty soon because I do need to use the restroom. Okay. Kimberly Crawford.
Aloha Chair and
Aloha.
board members. I am testifying today as a Kia'i local and a mother. I am adamantly opposed to the taking of any and all reef fish for aquarium purposes. One thing DAR missed that the community mentioned was stewardship. We need to get back to giving back more than we're taking and to restore the resources, restore the vai, restore the dry land forest, restore the Kona field system. Those are the things that are valuable to the Hawaiian people. Our ocean and our i'a are facing a great number of stressors: groundwater depletion, overfishing, habitat loss, climate change, including warming and acidification, lack of food sources, especially during these times when food is going to be unaccounted for. Wastewater and other pollution is going to cause nutrient blooms. And at this time, we need all of the fish that we can get in the ocean. We need them as a food source. We need them as herbivores to clean the reef. We need them to balance we need the balance of predators to help keep our stocks healthy. And the benefit of more fish gives us a better chance at the most optimal ocean conditions we can get. So I'm asking you today to deny this to deny F2 and to consider not opening up aquarium fishing at all in Hawaiʻi. Mahalo to you folks for the long day today, and I hope you have a great afternoon.
Thank you very much. I apologize to those of you who have been on Zoom that I'm not taking on the order that you're coming on. So I have a list. I'm going to take Kapiolani Spencer, then I will take Kauiki Lin, and then Godfrey Akaka, and then Daryl S. So Kapiolani, why don't you go ahead?
Aloha mai kako. It was a long day for all of us, so I'm not going to repeat a lot of that was already said in a lot of the testimonies today. Everyone had strong testimonies in opposition to the F2 extraction of reef fish for profit versus protection. So aloha mai kako. Let me start off with introducing myself. Ovao o Kapiolani Spencer. I am from Moku'o Keawe. I live in Kailua Kona. This is my moku aina from my mother's side, from Honoka'au all the way to Ka'u. So we have a lineal and cultural descendancy to the land here as well. I just want to bring up a couple of things right now. The state of Hawaii and the Board of Land and Natural Resources, I understand we're short-staffed, and yes, everybody here is doing an excellent job. What I wanted to bring up, and the reason for me bringing this up, it shows the decline in our ecosystem and our reef systems. So as trustees of the Public Trust Resources and have long been aware of the severe contamination now impacting West Hawaii's nearshore ecosystem. The reason for my mentioning that is because it shows that this is a declining ecosystem and it's already being stressed, not only by what everybody else is saying, but to just continue to take from our reef system. And I was taught the same way. We fish for what we need. We take what we need to sustain ourselves. And if we continue to rape our ocean, and yes, I'm going to use that term, just blatantly, because that's what it is, to protect our cultural resources for our future generation. I submitted my written testimony. I don't need to rehash everything everybody else just said, but I am in strong opposition of F2, extraction of reef and fish.
Thank
For
you very
profit.
much, Kapiolani.
Thank you for having.
And thank you for your patience. Koiki Lin.
Koiki.
Hi, aloha,
Aloha.
aloha, board chair and board members.
Board members.
Board members. I'm sorry.
It's a long day. It's a long day. I know.
Aloha. My name is Ka'uiki Lin. I was born in Ka'ululu'a, Kauaipapa, Hanamoku, here in Maui Hikina. I'm in opposition against the AQ industry, especially for the folks who suffer under science that's still elementary. As we move to the future, trying to understand all this this knowledge branches, and how it's epistemologies. I think like the yellow tang and the Potter's angelfish from whitelist be removed because they're successfully cultivated by the Oceanic Institute of Hawaii Pacific University in Oahu, and wild harvest is unnecessary. Remove the akole and the mamole. We eat the akole and we eat the innards, so that's a double take of the fish species. The na'au from the akole is also eaten. Remove the sand and stuff like that. They're also culturally respected food for sustenance. What else? The whole the battle between the trust doctrine and all of that stuff that was reported earlier. Please, just, aole. That's all. Thank you.
Mahalo, Koiki. Godfrey?
Aloha, you guys can hear me?
Yes, we can hear you.
Aloha, Godfrey Akaka Jr., representing the Native Hawaiian Gathering Rights Association, Molokai, Kanaka Ma'ole. I mahalo everybody's testimony. We're in support of the aquarium fishing, giving them their permits. They did their EIS. They did everything that you guys requested of them to do. The right thing to do is to give them their permits. We do verify that fishing is part of our culture. The fisherman is the one that strike the balance in the ocean. Yeah. I don't know why the continuous anti-fishing rhetoric, that is what is wiping out our culture. That needs to be really taken into consideration. And then our earlier testimony, I heard the lady talking about you gotta leave the fish so the tourists can come see the fish. Yeah, that's the kind of action that I've been witnessing. Yeah. So the next question I get when you guys talking about money, all of the NGOs that are opposing these aquarium fishers are the same NGOs that have been trying to put down heavy restrictions on our native gathering subsistence fishings. We are not. Majority of the families that I represent are subsistence fishers, but some of them are commercial, and we support commercial because, again, fishing strikes the balance. The fisherman is the one strike the balance in the ocean. Where are the NGOs getting your money from? That is my question. And, what is the reason for the anti-fishing rhetoric and reefs getting wiped out? Those are all lies, and I'm expressing this from my heart. This is not just for Molokai. This is statewide. We need to really look at all of the facts of these things. Mahalo.
Thank you very much, Godfrey. Daryl?
Aloha, Board and Chair Chang. I appreciate you allowing me to testify in support of F2. I've been giving public testimony since 2008 at the Editam Center when Laura Thielen was the head of the DLNR. I'm in support of the fishermen who have endured slings and arrows of outrageous fortune since the entire time I've been interested in this little project. I just want to remind people that as soon as a shoreline fisherman catches a fish and sells it by the side of the road, then he has basically made that fish a commodity. So I don't really understand the distinction between the aquarium fisherman and the recreational shore fisherman who is also making a little bit of money on the side. In the end, the money is going to feed your family, regardless of whether you sell it as an aquarium fish or whether you collect it to eat or then collect it to sell on the side of the road. I just also want to comment on sort of the negative characteristics of aquarium fishermen. Since the beginning, when I attended the Eddie Tam Center meeting, there was an ad put out in the Maui News that said, "Come to Eddie Tam Center and meet the reef rapers, no fights." So that was the type of incitement that, I think is just completely inappropriate here. I've been here for 21 years. I've been in a few halaus. My Hawaiian name was given to me as Iolani, and I like to think of myself as somebody who can be the hawk. So I just wanted to also say that I support the process to reopen the sustainable aquarium fishery and allow vetted commercial permits to be issued alongside the 100,000 recreational shore fishermen that already exist in the state and all the commercial boats that also exist. I do have an aquarium business, but I could get fish from anywhere. I had a great relationship with a few guys on the island, and they were forced to leave. So I would just really like to see F2 passed and move forward. Thank you very much for your time. I appreciate your consideration.
Thank you. I have got the next, but I am going to take I need to take a 5-minute break. The next commenters are going to be Rufus, and then Kanani Enos, and then Kai Nishiki, then Eric, then Jai Cox, and then Riley. But we are going to take a 5-minute break. Thank you. I'm going to tell you how we're going to handle the rest of the afternoon. First of all, those of you in the breezeway, we're going to close the TV so they can bring it inside. So those of you that are outside, please come inside and join us in here because we're going to remove the TV from outside.
I'll tell people.
Thank you so much. I appreciate that.
Because I feel they may not hear.
Okay, so these are those that I'm going to take that are on Zoom. Rufus, Kanani, Kai, Eric, Jai, and Righty. Do I have anybody in this room that hasn't provided comments that wants to provide a comment? Okay, because I'm gonna lose some board members pretty soon. So these are the last that I'm going to take of public comments so that I can provide the board time for deliberation. So with that being said, we're going to start off with Rufus. And Rufus, we just received your, no, this isn't you. Oh, no, this is Ron Tubbs. Okay, so go ahead, Rufus. Please go ahead and start. You have 2 minutes. Go ahead.
Yes. Can you hear me?
Yes, we can.
Okay, thanks. Yeah, I'm just testifying in support of F2. I'd like to commend you guys on doing the job of finally getting this rules package here. It's been a long and arduous journey, I feel, for everybody. I appreciate you guys using the EIS and the science that's been presented before you. I just wanted to provide a little frame of reference or maybe a different perspective on this whole ordeal. In 2020, the U.S. Department of Housing and Urban Development said that 90,000 was low income for an earner in Hawaii. I used to be a rescue fireman over here on the west side of Oahu for 14 years, and they paid far less than 90,000. So for me to support myself and my family, I had to, supplement my income with commercial fishing, mainly aquarium fishing. I think there's a common misconception outside in the public's mind that divers are making tons of money. In reality, if the Oahu fishermen are allowed to sell their entire quota, each individual quota, if they were to catch all the fish allotted to them every year, they would probably be making less than 70 grand at 2020 prices. So that's something to keep in mind. None of the local guys are becoming a millionaire off this. The other thing that I wanted to address was to Miss Samantha DeCortea. I appreciate your support of the Mililiki group, but for me, this just shows how out of touch you are with your own constituents. If you paid attention to this issue, you'd see that almost half of the applicants on the Oahu EIS trying to get their permits back are from the west side. We grew up here. We went to Waina High School. And for me personally, I had to leave because I didn't have a job anymore. So it's just something to keep on mind. These are the kind of people you're pushing out of the state, the people that were born. I was born in Molokai, grew up in Waianae, now I'm gone.
Okay, so
Thank you
Rufus,
for your
I'm
time.
sorry,
Yes.
your time is up.
That's fine. Thank you.
Okay, thank you so much. After Rufus, I have Kanani Enos. Kanani?
Aloha mai kako.
Aloha.
Before I start, I have my 9-year-old son that wanted to submit testimony. Does he get his own time or should I share it with him?
He gets his own time. If you want him to speak first, he may.
Okay. I think I will go first.
Okay.
Yeah. Okay, mahalo. Aloha mai, my name is Kanani Enos. I submitted my written testimony and I continue to stand by it. Hanau ka ma'i'i'i, hanau ka alaihi ke kaila holo. Hanau ka umaumale, noho I kai. Kia ia e ka ule, noho yuka. I just wanted to bring into the room, as we talk about our kai, our ocean, and the life forms within it, as dollar signs, swimming around, to collect and to sell, and sometimes to waste. I just wanted to bring the mention of them in our Kumulipo, our Hawaiian creation chant, and our Hawaiian cosmological chant into this space as we talk about them as commodities in this process of lawmaking. I just wanted to honor our Kanaloa and our ocean kupuna in that way. Mahalo nui.
Thank you very much, Kanani. You want to have your son introduce himself?
Mahalo.
Hi, my name.
There you go. Hold the phone.
Aloha. My name is Koiwai Enos Cruz. I'm 9 years old from Kona, South Kona. And today I want to say stop letting them b- capture our fish and putting it to the aquarium, to the aquarium. So please stop. And if there's no more fish, there's gonna be no more people. And if there's no more fish, the coral can die because all of the algae will grow all over it, and then it'll cause death for the coral. So I'm asking you, please send back the rules. Thank you. Mahalo.
Thank you very much, brother. You did a great job. Thank you for participating. Mahalo. So Kai Nishiki?
Oh, wow. Hard to follow up the keiki. Kai Nishiki, I am calling in from Maui, and back in 2010, Maui County was the first county to protect aquarium fish. My dad, Wayne Nishiki, was on the Maui County Council at that time and worked with ocean resource protectors to put that legislation in place. And then, the aquarium collectors, Palamai, they all said, "Oh, we're gonna go move to Hawaii Island." Sorry, we sent more of those collectors over to you guys. But this is a luxury extraction and completely unnecessary for if you're gonna catch fish, then you should use them for sustenance, not as a luxury extraction. And we are concerned that these proposed rules and permitting will then embolden aquarium collectors to want to expand outside of West Hawaii. And so we would be strongly opposed to this moving forward. And I just want to bring enforcement up because I testify before this board a lot about commercial permittees. And, if the DLNR is already struggling for enforcement on their current issues that they need to deal with, like adding is not going to help with that. And Maui, we have so much problems with enforcement on just the commercial permittees. I can't even imagine adding, a complex enforcement that would be needed for this effort. So strongly opposed. Mahalo
Thank
nui.
you very much, Kai. Jai Cox? Jai, if you can unmute yourself. Oh, I missed Eric. Eric, whoever unmutes themselves first, whether Eric or Jai, you may go first. Oh, you did it, Eric. Go ahead. You may go
I got it.
first.
Thank you. Aloha, Chair and Board. My name's Eric Koch. I am a commercial fisherman and an aquarium fisherman on the Big Island of Hawaii. I'd like to discuss the science and the cultural perspective and how aquarium fishing impacts these two things. I hear some of my fellow community members are concerned that me earning a living at sea is impacting their life.
We may have lost you.
Same thing. Just give it there.
That being, I'm sorry, I got just something happened with the mute. That being said, I have some questions for the board. I hear all the opposition saying this rules making is premature, not enough discussion. Interestingly enough, you know what I don't hear them speaking about? The entire 343 HEPA process that most all took part in. This seems to be a forgotten element. They asked for us to do HEPA. I'm sorry.
Go
Is someone
ahead.
speaking? Jeez. They asked for us to do HEPA and we did it twice. Now it's overlooked and some act like this is day one. Aquariums are a tool and a source of knowledge, and this creates understanding. I encourage all the opposition to get an aquarium for this very reason. The Waikiki Aquarium is the second oldest aquarium in North America. It was established in 1904. Who do you suppose were catching the aquarium fish back then? Hawaii has a long history of aquarium and aquarium keeping. I heard you, Chair, when you asked us aquarium guys to think about some fees. I support this fully with one condition, that it applies to everyone, every commercial fisherman, not just us. I don't support prejudice, and surely you don't as well. So if you agree to apply such a concept equally, me and you are in full agreement. Our intent as fishers isn't to be a burden, and we do care deeply about oversight and management of said resources. I hear people claiming the fishery costs $500,000 to the taxpayer. I've looked into this and this isn't accurate. I would like the board to verify the breakdown of this. Where's the proof in that? I hear Member Smith presume that there might be mortality, and this means more than what we're allotted will be taken. With all due respect, this is incorrect, Mr. Smith. I would encourage you to read Emily Monday's study in Kona, tracking mortality from capture out on the reefs to dealers and beyond. The mortality is virtually zero. This is in line with my professional experience, and I would welcome you on my boat anytime to see for yourself, so you don't need to speculate. You'll know firsthand. We do not fear investigation. The assumption that we fishers are some sort of flagrant rule breakers and we can't be managed. We do not break the law. DoCare will see over and over that we follow the rules as we always have. All 7 fishers have never committed any source of resource violations.
Eric, I'm sorry. Eric, your time is up.
Thank you.
Thank you very much, Eric. Jai, are you able to unmute yourself?
Hey, can you guys hear me?
Yes, we can.
Right on. Aloha, everyone. I hope you guys are having a great day. My name is Jai Cox. I'm from Big Island, Hawaii. Live down South Point area, and I'm in full support of F2 and this fishery because of the sound science and the amount of management that is going into it. I'd like to keep it short. I'll just add really quick. I'm a diver. I'm a spear fisherman, and I don't exactly see what the other side is talking about. On my dives, I'll see hundreds of yellow tang, if not thousands, just in small areas of reef. And that's all I got for you guys today. Thank you for your time.
Thank you very much. Riley? And this is our last public commenter. Riley? Unmute yourself. Riley? Can you unmute yourself? Okay, Riley, I would give you more time, but you are the last person that we're going to take comment from. So I'm going to give you 10 seconds more, and then I'm going to close public comments. Somebody was keeping. Okay, I'm sorry. So Riley, for whatever technical reasons, we were unable to hear you. So with that being said, I am going to close public comments. It is now 4:10. I think we have heard, we took 58 public comments.
Hi, can you hear me?
You were saved by the bell, literally.
Yeah, sorry, it kicked me out. I don't know what happened.
Okay, go ahead. You got 2 minutes.
Aloha board members. My name is Riley and I'm born and raised on the Big Island, where I spent most of my life fishing, swimming, diving on the coast of the West Hawaii. I wanted to grow up to be a marine biologist like a lot of my friends do because I just love the ocean. And you guys banning this aquarium fishery has led me to believe that you guys don't believe in the science. My school hasn't been able to start up more projects with aquariums due to us unable
to collect aquarium fish. None of this makes sense to me. I hear all these people talking about how there's no more fish, but I question how often they go in the water. There are plenty of fish, and what I see based off of my diving is what I hear or I see from the DAR guys. You can see all these fish if you just go look in the water. Even out of the water on the land, you can see all the yellow tangs in the waves. Supporting this plan solves the aquaculture permit issues with my school, which would allow for more science, more learning, and will provide jobs for kids like me locally. I also heard earlier that we need to preserve the fish for the tourism industry. I fully disagree with this, and I believe it is common knowledge that tourists show the least respect for the reef. Thank you for your time. Listen to the science.
Okay, thank you very much, Riley. I appreciate you keeping under the time. Again, I'm closing public comment. I'd like to, so we're going to close public comment. I'd like to bring up Dar, Brian and David. So I want to be very clear. We're not going to take public comments. This is an opportunity for the board to ask Dar, now that we've heard all of the public comments, if there are final questions that you have for Dar before we go into making a motion and deliberation. I just want to be really clear for the record. There's testimony about, there's concerns about Miloli'i. Could you please confirm that there is no fishing in Miloli'i?
Yeah, so Miloli'i is designated as a community-based subsistence fishing area and co-managed by members of the Miloli'i community. And no aquarium collection is allowed in Miloli'i as part of that marine managed area. And what we're proposing today, those aquarium bans would continue.
Okay. Okay, board members, do you have any other questions? Denise?
Chair, one more question. There were other areas mentioned that were closed to fishing. Is it Ho'okena? Are there other areas that are closed?
Yeah, so 47% of the coastline is closed to aquarium fishing, and it's a network of no-take areas, fishery replenishment areas. There's marine life conservation districts. There's multiple areas along the coastline. We could probably pull up a map.
Yeah, I was going to ask the slide because I think you clarified that there's 46% of the areas closed.
I think so, with Miloli'i coming on board and expanding the no-take area, yeah.
And these rules do not, okay, Chris, did you want to clarify that?
Sure, I was going to say I'm happy to share my screen and bring up a map.
Okay. I want to make sure that we're very clear on what the facts are.
Oh, it looks like I need permission to share.
Oh, Rihanna?
I wonder what percentage of that estimate of yellow tang are in the 54% of open area. 7.6%.
I know, I appreciate the comment, but I'm not going to take public comments, okay?
Just a question.
Yep, no, and if a board member wants to ask it, they can, okay. There we go.
So Chris, do you want to point out Miloli'i? I think Ho'okena came up as well.
You're on mute, Chris.
Thanks. I'll start in the south. So this yellow area down here, this covers the Miloli'i community-based subsistence fishing area. This is the Ho'okena fish replenishment area that was set in place in 1999. There's a few different zones in here, two of which are fish replenishment areas, and one is the Kealakekua Bay MLCD. The Ko'opalehu Marine Reserve. Oh, sorry, skipped the town ones. So Keaho to Kailua is an FRA, as well as another NLCD and FMA. And then Ko'opalehu has the fish reserve or marine reserve, which used to be the Ko'opalehu fish replenishment area. There's two additional FRAs, fish replenishment areas in Kohala, as well as the Pu'oko FMA and Wailea Bay MLCD. and then Lapakahi MLCD up to the north.
But the Miloli'i, when it doesn't go out to the 3 miles, the boundary is a little further inland, right?
That's correct. So most of them
Yeah, so the
do not
blue is
go.
open.
Yep.
Most of, okay, okay. The blue.
Got realized it drops off so deep, it goes to 600.
Okay. Any other question, board members? Denise?
I have some clarifying.
Yes.
As a new board member, I just want to affirm the facts that there are. As the board, our limits of authority are that such that there is a law that already permits this type of fishing. And our limit, as much as I feel and I hear and I feel for them and want to do something, we are limited by not being able to ban this type of fishing because there's a law that permits it. Is that correct?
So there's a statute that authorizes the use of fine mesh nets for aquarium collection through permit. And based on that law, which authorizes or permits aquarium fishing, our AGs have told us the department is not allowed to completely ban aquarium collection by rule. Whether the board decides to issue permits or not, that's a different story, but rulemaking, we've been advised the board cannot completely ban.
Thank you.
And if I could just add, what shut down the fishery was that court ruling back in 2017. So there hasn't been a law or rule that shut down the fishery. It's that court ruling that the fishery needs to be compliant with HEPA or Chapter 343.
Okay, so now that you mentioned that, the 7 permittees that did the EIS and did the HEPA, are they allowed to continue on with their AQ permits, or they don't have a permit right now?
They don't have a permit right now, so.
Can they come in and apply for a permit? I
They-
mean, they
they
did
could.
all the requirements that it was mandated of them.
So they could apply for permits. They would be regulated under the old rules, which have like a 40 white list and no ACLs. And so what we're proposing would limit what they could take to ensure that it's sustainable.
So, and a clarification, the 7, we did not have individuals that submitted a HEPA. It was PJAC.
Yes, PJAX submitted or completed the environmental impact statement on analyzing in their preferred alternative the impact of take by 7 collected.
And so the way, as I understood your presentation, it would be up to PJAC to decide what 7 get that initial, may be eligible to qualify for the 7 permits.
They can designate
They can-
to 7, right?
And then after, because these are going to be annual permits, after the permit, assuming that it goes through the, after year 1, they'll be able to renew their permits and they will individually then hold those permits.
Correct.
Yeah. If they are found in violation, if any one of those 7 permittees are found in violation by DoCare, that could be the basis to ban them from any permit for 5 years. Is that correct?
Well, under these rules, yeah, they would not be able to, they're not eligible for an aquarium permit for 5 years.
So they're not eligible for AQ permit. They could get another permit?
The law, I think for commercial marine licenses, the board can revoke a permit for up to a year.
Okay, but what you are proposing under these rules is any violation, and I'm assuming it's not just was a citation a violation?
It's a criminal violation.
Okay.
Yeah.
Then that could be the basis that would prohibit them from applying for a permit for 5 years.
Correct.
Or prohibiting the department from issuing them a permit. Okay. Questions? Go ahead, Riley.
Yeah, so Randy Cates had asked a question about safety. So there isn't a limit on how many divers per permit, right? So you could have 2 divers in the water. No.
So each permit,
Address the safety issue.
so each, you need a permit to engage in aquarium collection. If you don't have a permit, you're not supposed to collect aquarium fish. The challenge we have is, if there's a permitted diver and an unpermitted diver, it's really difficult to enforce that the unpermitted diver is not somehow assisting in the collection. With the ACLs, it's not really a resource take issue because they can ultimately land as a fishery up to the ACL. It's more of a fairness issue. If, certain collectors might have assistance, they can have their higher individual catch towards that ACL. And when we talked with the West Hawaii group, at least, I guess they're close enough that they feel they don't need individual catch quotas.
I'm just asking, how do you get someone not diving by themselves?
Yeah, and if I could just add, we totally support dive safety, our own protocols support dive buddies, and we don't prohibit the permittees from diving together either.
Oh.
That's allowed.
Oh, so it'd have to be 2 different permits.
It would have to
2
be,
guys in the water.
2 of the 7 permittees would have to dive together. So that's allowed. We just don't allow a non-permitted diver to be in the water because of the reasons that David described.
But they can be on the boat.
They can be on the boat,
vessel.
yes.
Yeah.
So
But
if
you
someone's.
can't see the diver underwater.
Yeah, so.
And they're in scuba, right?
Yeah, so that's it's a legitimate safety concern, but you could have 2 of the permittees diving together and have a dive buddy that way.
Oh, that's.
But it could come up as a discussion later, right?
Yeah.
During the
rulemaking
process.
Yeah, if it goes that route.
To amend the rules before going to public hearing, we could remove that part that says, that prohibits a non-permitted diver from being in the water with a permitted diver.
So.
I mean, even a spotter on the surface or something. In the water.
Oh, like a
Looking.
snorkeler or something.
Not somebody standing on a boat trying to see through the water if the guy's in trouble.
So
Right?
so if they reach their, let's say within a month, they reach the quota, then it is closed.
Yeah, whatever species the ACL is reached for will shut down for the rest of the season.
Okay, so the ACL, that is the primary driver. If when they reach that and you have a notice date, you're gonna notify them 3 days in advance or some period of time.
When it hits 95% of the ACL, we'll send a notice.
Okay. Yeah, when they hit that, whether it's 30 days or 11 months, that resource will be closed for any continued gap.
Chair, I have a
Yes,
follow-up
please,
after
go
you.
ahead. Okay, no.
So I wanted to
yeah.
circle back on something you mentioned about a fee structure.
Yeah.
And before you go out, would it be possible to insert a fee structure in the rules?
I guess there's just that question about whether we have the authority to tax, and I don't know, what are your thoughts on that?
So if we did implement a fee for the aquarium permit, we would recommend it being consistent with all of our other license and permit fees, which is $100 per year. Just in
Which maybe
fairness.
we need to revisit everybody's commercial license permit. I mean, that's when they're all making a commercial, an extractive activity, rendering a benefit. Yeah, I mean, because I also recognize the Division of Aquatic Resources, like our Division of Forestry and Wildlife, you generate no money other than we now have the ocean stewardship. But besides that, you don't generate your own revenue. So we have got to think about a creative way to make and whether it's an annual, a registration fee commensurate with DOBAR has, and I recognize that's by statute, that's why. They can charge 3% of the commercial, of their gross revenue.
Yeah.
So perhaps that's something we need to look at, Senator, to institute, so that is nothing. $1,000, I mean, for all of ours, but I mean, and I appreciate that Senator Favela and Senator DeCourt is here. Because we also do say, I mean, this is a legislative matter as well. So thank you for being here the whole time. Denise, did you want to add anything more?
Yeah, no, I just realized it is work. I did come from working within the state and having to face those same issues and making those changes. It was not easy. But once we did it, things became more remunerative. And the population understood, especially if it was going to be a revenue-making activity. So I know it's tough. We got to start somewhere.
Karen, did you want to ask? Did you have a question? No. You're okay. So I
don't have any right now.
Where his hand is up. We heard a lot of testimony today, in particular about Hole and then Umamale. And those you have Hole, 12,775, and then Umamale, 5,827. And I'm gonna share with you, I mean, Kole is for our family, that is when you only have them at special occasions, I mean, we were raised, only royalty could eat Kole. But nowadays, when you have a party, that's one of the main things, if you can get Kole, but nobody's selling it, they're just catching enough for the party. I mean, I will share that is a concern, only because on the herbivore rules, we are prohibiting a certain take on a certain size. And here we are permitting. I know that you guys have shared that what is it, the fatality rate, or
Mortality.
when they're too small like that. But there is a, like I said, I guess a cultural issue for me, both on the Kole and the Umamale.
Can I make a motion to go into executive session?
Okay.
Board, I request that we go into executive session pursuant to section 92-5A, subsection 4 HRS, in order to consult with our attorney on questions and issues pertaining to the board's powers, duties, privileges, immunities, and liabilities.
I have a motion. To have a second?
Second.
Motion's been moved and seconded to go into executive session. All in favor, say aye.
Aye.
Aye. Okay, and so we will step out. You may all stay here. So we're going to be in executive session. session. We were in executive session to confer with our Deputy Attorney General on our duties, privileges, and liabilities specifically related to item F2 on the agenda. With that being said, board members, we were asking the department any final questions. Do you have any final questions? Okay, all right. Thank you very much, Brian and David and Chris and Kelly, those of you on Zoom, thank you for being available. All right, board members, we have heard lengthy testimony all day. We appreciated everybody's patience and waiting and being here with us. We also appreciate everybody's civility. This is not easy. I recognize this is a very hard decision. So with that being said, do I have a motion, board?
As a Hawaii Island representative, I make the following motion. First of all, this is all prefaced based on, we are legislatively required to allow aquarium fishing. Okay, so we cannot ban it, we cannot prohibit it. Based on that understanding, and based on the policy setting nature of BLNR, that we can consider social and cultural norms that we feel are appropriate, I propose the following approval of item F2 with the following amendments. First of all, I'd like to exclude from the ACL all the fish that are typically considered to be native Hawaiian food sources. Okay, so that would include the kole, umaumale, and chevron tang. Okay, so those ACLs are 0. Okay, as far as the laipala, the yellow tang, from a ACL of 200,000, I propose a reduction to 100,000. Part of the reason for that is because there are numerous propagators of farm-raised yellow tang, including Oceanic Institute, Biota, and other organizations that have perfected or at least improved the ability to farm raise the yellow tang fish. Okay. I've been out to the Oceanic Institute location out by Mackay Pier, and they've explained what they've done as far as the food sources to enable the fish to survive between the 3-day age and 30 days when the food sac that they're born with is depleted and before they can eat other types of food. So the plankton sources that they can develop enable that species of fish to be farm raised. Farm raised has a higher likelihood of survivorship. Similar to freshwater fish, they are raised in cages, fed commercial feed, and so their likelihood of survivorship is much, much higher. Okay. On the other species of fish that are proposed, the Potter's Angel fish, the Mai-Ii, Hinalea Iivi, and the Thompson Surgeon fish, I propose that those quantities remain the same. So Potter's Angel fish at 1,086, Mai-Ii at 800 fish per year, Hinalea Iivi at 344 fish per year, Thompson Surgeon fish at 182 fish per year. Okay. We are asking the department to find a solution on the safety issue raised about allowing an additional diver to be in the water with appropriate diving gear. That would be scuba tanks. So if that someone on the bottom collecting fish got in trouble, that person could respond immediately. Okay. And we need to find a way to have prudent dive safety measures implemented so we're not risking people. And I think it's unlikely that 2 permittees would collaborate together to dive in the same place on the same time and the same day. So I think we need to find a solution to allow that safety diver. Okay. We're also not clear, but we would like DAR to propose some kind of fee structure that the Attorney General's office will allow, or possibly the Senate would permit to be proportional to revenue or quantity of fish or something like that. I mean, a flat fee to me seems inappropriate because you might hit the limit after a month And I don't think it's appropriate to charge everybody the same fee if they don't harvest the similar amount of fish, okay? Anyway, that's my motion.
Chair, I will second that.
All right,
And I'd like
we
to
are in
comment-
discussion. We're in
Yep.
discussion.
I'd
Go
like to
ahead.
comment quickly. Before I comment on the Nohona Hawaii part of it, the cultural side of it, I just wanted to mahalo Riley for that. And I hope that the people that heard that his amendment demonstrates that this board is very capable. Riley not only knows the science, but he knows the operations behind the issues. And so I quickly wanted to second and bolster his mana'o with the same fact about our ability as a board to answer on the Nohona Hawaii side. So thank you for your indulgence, Chair. So
Thank you very much.
I heard in the testimonies a constant theme of trusting the science, and that is Dars Kuleana, and they're very good at it. In fact, all our divisions have science, and they're very good scientists. But the science has inherent limitations. It is absent of morality, values, cultural values, if you will, and experiences. You know, science is confined to what can be observed, what can be measured, what can be tested. You know, they can report on the phenomena of things, but it cannot provide definite proof or final answers, absolute answers. And so these puka, these holes, if you will, is where our community, our Kanaka Maoli community comes in and fills these gaps. And I didn't hear that our community or Lahui requesting finality. What they're begging for and asking for is continued consultation and consideration for these phenomena that the science is absent and quiet to. You know, we all, no matter what culture you are, we're human beings and we experience these phenomenal things in life. And that's why I was a little disappointed when I hear comments of, you know, undercutting one another, communities saying you're incapable of understanding the science. You're incapable of comprehending. I don't agree with that. Now, as far as, I'll say one more Hawaiian thing. My definition of pono, or a definition of pono, is doing the right thing at the right time for the right reason. And as far as timing, my mind, the science, if you will, I understand it. So contrary to popular belief, us board members read everything and we understand it to varying degrees, but we understand it. But also my na'au, which makes me Hawaiian, which answers to the morality and the culture of things, the point I was trying to make. Both these things, in my mind and in my na'au, aule makaukau, we are not ready yet, but that's okay. I think the things that Riley has recommended to be a problem solver is maikai. So that's why I seconded and will support, and I hope that our community, our legislators will help join in this kako, because it's very difficult. And I think our chair eloquently said it again, that our kuleana on this board is very, very fragile and very difficult, but we must do it. We must. So in closing, Chair, thank you for your indulgence again. I think we can be better, and I hope that the science and those that believe in the science understand its limitations and actually reach out across the aisle to us Hawaiians, because we know the science as well. You know, once upon a time, they told us that the earth was flat. That was the science. So here we are today, and I think there is so much value and money in our lahui. And I please, let's be better and not discredit the Hawaiian community. Mahalo, Chair, for your indulgence.
Can I have
Thank
a
you very
comment?
much. Yes, go ahead. Do you want to say something?
Thank you, Katie, that was very well said, thank you. So this morning, most of you were, if not all of you were here, the way that this agendized item started was a little heartbreaking for me because it challenged two of our members. Here we are at the end of the day, and you done good, Riley, you know. So I just wanted to share that with you because it's not easy sometimes up here to take the abuse, but we do it, we don't get paid, and we love what we do, and we just want you to know that what we do is for all of you and what you stand for. But thank you, Chair.
Thank
Chair.
you very much, Board.
Can I thank Brian and David for the work that they did and laying out everything so that it was easy for us to understand the process from years ago to today, to where we are right now. Thank you.
And that's Chris and
Yes.
Kaylee on there too.
Yes.
Thank you, guys.
It was a team effort. I wish share.
Okay,
with
now
you.
we all leaving in tears.
Denise, do you want to say anything before we take a vote?
Yes, Chair, thanks again to the staff. Thank you for those words, Kaili. You carried a heavy burden of being the cultural and traditional practice rep on the board. So very well said, very timely. I really appreciate that. And thank you, Riley, for coming up with a solution. Thank you, Chair.
Thank you. Thank you.
Point of order, Chair.
Yes.
Just to clarify, because what I thought I heard was that you made a motion to send these rules out for hearing.
Subject to these
Subject to the
amendments.
amendments.
So maybe the first half of those amendments were really specific, so I can
Yes.
see how you did like an amendment on the fly. Solution for diver safety and new fee structure are like things that DAR is gonna have to write from whole cloth. And so are you am I understanding correctly that they will amend that
Yes, before,
without approval from the board before, and then just automatically go to
well,
hearing?
they're gonna have to implement the board's guidance, which is to come up with a safety solution for the dive. The second one is to come up with a fee. We may not be able to do that. It may be a legislative matter. So I think that what the board is asking them to do is confer with the Attorney General's office on what we can do. Because I also recognize, I mean, the fishers are right. We need to treat everybody fairly. If we're gonna start charging commercial fishermen, we're gonna start charging them equitably. So, but if we cannot make that change in this set of rules, I think the guidance of the board is we would like to go out to public hearing on these rules in a timely fashion. And then let the process vote out, because as you mentioned too, there may be substantive changes that require it to come back to the board.
The board won't get a chance to review these amendments before it goes out to public hearing, just making sure I understand that.
You're correct, other than the chairperson, because I think the other is to delegate authority to the chair to sign the rules as approved by the board, and we appoint a public hearing officer.
Thank you, Chair.
No,
That'll
no,
all be in the
no.
record.
Okay, yes, that will be in the. Okay. Yeah.
I had a question as well, in terms of trying to find a safety solution for the diver safety issue, which I agree, Member Smith, that's a really important consideration. One of our concerns with having just a dive buddy and the challenges of enforcing that they're not helping the collector collect fish is fairness, that, you know, you could have people collecting more in one place than another permitted team. Would you consider adding the ability for us to scope individual catch quotas associated with each permit to kind of address that fairness issue for the dive safety?
Riley, I don't think we went that far. We were just looking at the cumulative catch quota, but not at individuals. And maybe there isn't a solution, but I mean, I think what the board is asking for you to come up with some potential recommendation and let it go out to public hearing, and then let's see what comes back. The public may have a better solution than what we come up with. But I think it is sort of a compromise. How do we move forward? But yet taking into consideration all of the comments that were said.
7 o'clock.
I hope that makes sense. So there may some things you may be able to do and some you may not be able to. Sorry. Calvin, did you want to say anything?
No, I don't want to prolong the meeting anymore.
Because he wants to go to a game.
Okay. But I will tell you, Calvin Young is a new board member. He went back and watched the December 2023, the 3 days of public comments, 2 of them, which were probably all related to AQ. So my only comment is, you know, I think you've heard from all the board, this is not an easy role that we play, the Kuleana that we've all assumed sitting here. But we do take it very seriously. And I'm hoping the board's actions convey to you a message that we listen to what you guys have to say. Our kuleana is that social and cultural considerations. The department looks at science, but we're looking at what we hear socially and culturally. What are those considerations that must be considered as we're looking at our different actions? We're not going to please everybody. I know that there are some who would like to see total ban. There would be others who'd like to see, no, let us do whatever we want. So we're trying to walk this very fine line. So with that being said, I am going to call for the vote. And Rihanna, why don't you do a roll call vote on this one?
Member Ono?
Aye.
Member Isari Masaguara?
Aye.
Member Young?
Aye.
Chair Chang?
Aye.
Member Smith?
Aye.
Member Consul?
Aye.
Member Yulin?
Aye.
Okay, the motion passes unanimously with 7 votes. So again, thank you, everybody, for spending your day here with us and providing us the comments. I would urge you to talk story to the legislators for a different fix, but we are going to try, you saw what the staff's schedule is like, so we're going to try to see if they can make the amendments consistent with the board action and try to move forward. Okay? So again, thank you, everybody. Greatly appreciate it. Thank you, Kaivi, for being with us this whole day. So
Aye.
we're good?
We're good.
We're good?
Yeah.
Okay, okay. So with that being said, having no other business before the board, we're adjourned.
Hello.
All chair, mahalo board.
Everyone, thank you, thank you, thank you.